I seek,
Yes.
I seek my lord's kind leave to mention a matter for release of the matter, my lord. A similar, connected read
Why didn't you
application.
mention yesterday?
My lord, I am.
Mention next Monday, please. Yes.
My lord, it's being taken up by the coordinate bench. My lord, I just got
It is in the list of the coordinate bench.
My lord, it's in the
Hand over this. Yes.
item number 707 of monthly list.
We mentioned it. Yes.
Do we mention item number 1 for
Lord,
correction?
There's a correction with regard to the present. The name of the present DM will have to be my lord Shumit Gupta. I have handed over a copy of the affidavit filed by the present DM. It was Dr. Ulganathan, so he is no more my lord the DM. And my learned friend Mr. Pankaj Halder said, yes, I had.
No, contempt has been disposed of. In the order, his name is not there.
No, this cost settlement has to be changed, Lordship. Because Shumit Gupta has filed a affidavit, and pursuant to your Lordship's order, advocate for the petitioner, Mr. Halder, also amended the cost title, he told me.
The
Inserting
order
the
has been passed. It has been decided. Where is the scope of?
no, only the cost title will be instead of
Oh, acha, that.
Dr. Ulganathan,
Acha, very.
it has to be Shumit Gupta. Kindly see the
Cost
affidavit.
title, in the cost title of the order dated August 18, 2023, comma, Dr. P. Ulaganathan shall be replaced by, within double inverted, Shumit Gupta.
Lordship.
Double inverted close. Let this order be deemed to be a part of the order dated August 18, 2023.
Grateful to Lordship.
Item 2 for non-prosecution.
My lord, praying for withdraw and kindly leave liberty for test filing, my lord.
Why? Why are you withdrawing then?
My lord, some points and some documents has been changed, my lord.
Lord counsel for the petitioner submits that certain averments and documents have been left out, and as such, the petitioner seeks to withdraw the writ petition with liberty to file afresh. Full stop. Accordingly, WPA 1643 of 2022 is dismissed as withdrawn with liberty to the petitioner to file a fresh writ petition on the self-same cause of action.
My lord, thank you.
Item 3 for correction.
On my instance, my lord, matter came up, my lord. Upon
Yes,
notice,
no,
my lord, I have mentioned, my lord, kindly see, my lord, page number 2 of my lord's order.
Yes.
The first line, my lord, instead of husband, it ought to have been brother. My lord, it's my mistake.
No, no, it's anywhere else.
No, only
Thank
this.
In the first line of the second page of the order dated July 20, 2023, comma, the expression within double inverted husband, double inverted close, shall be scored through and be replaced by double inverted brother, double inverted close, full stop. This order be deemed to be a part of the order dated July 20, 2023. Grateful. Thank you. Yes.
Extension of interim order. Item 4.
You are for the petition, Mr.
Interim order is still valid August 31, 2023.
On the prayer of learned counsel for the petitioner, comma, the interim order granted earlier is extended till October 19, 2023 or until further order, whichever is earlier. The writ petition be listed in the monthly list of September 2023.
No. October after vacation. Yes, sir,
Extension of interim order. Item 5.
May it please your lordship, my lord. On 6th July, my lord passed an interim order. You are appearing for sale. My lord, my learned friend is appearing. Lord, we served them. Lord, they did not appear on the first day. That is why I was looking
Oh,
for it. Then
The interim order is
then-
still
Lord,
31st.
till 31st August. But we have
Still what?
served them the order that was refused. I am carrying the envelope since he is appearing now.
Yes, yes.
I have small objection. Territorial jurisdiction, my lord.
Jurisdiction, yes. What
That
is-
your lordships have considered and kept it open in the order.
Yes.
Kindly have a look at it.
Certainly, that is
Page
kept
3.
open.
Page 4, first paragraph.
The objection is kept open for being.
And page 4, third paragraph, hence the objection of territorial jurisdiction arguable and kept it open for be decided at the time of final hearing of the writ petition.
Learned counsel for the petitioner seeks an extension of the interim order granted earlier, full stop. Learned counsel appearing for the respondent authorities reiterates the objection of the respondents regarding the territorial jurisdiction of this court. Whose it is pointed out by learned counsel for the petitioner that in the order dated July 6, 2023, the objection of territorial jurisdiction was observed to be arguable and kept open for being decided at the final hearing of the writ petition. Full stop. Next para. Keeping the said observation alive, the interim order granted earlier is extended till October 19, 2023 or until further order, whichever is earlier. The writ petition shall be listed in the monthly list of September 2023.
My lord, one indulgence, my lord.
Yes.
My lord had been pleased to grant me a time to file my affidavit of opposition.
Not yet filed.
I have, my lord, filed. My lord,
How much time?
fortnight, my lord, so please. Yes.
I have to extend করে দিই।
Fortnight, then no, cannot be a fortnight. আচ্ছা তাহলে মান্থলি লিস্টে যেটা বললাম না আগেরটা appear in the monthly list of September না করে appear in the monthly list of October 2023 full stop on the pair of the state respondents the time for filing opposition is extended till September 5, 2023 full stop reply if any shall be filed by September 19, 2023.
Interim order extended.
Fortnight, interim order till 19th October before the puja, the court closes for puja vacation. It will appear in monthly list of October. Yes. Great. Thanks.
Top item, item 6.
Yes, Mr. Arifin, what is the matter?
My lord,
You implemented whoever.
yes,
My lord, in this matter, Mr. Amitesh Banerjee, senior standing counsel, is appearing. My lord, he is sick. My lord,
This
he
is the
in
item number, which is the
My lord,
first top item. No adjournment. You are there, I'll take up the matter. Yes, what is
no,
the
no,
matter?
I am not in the matter, my lord. I
Then
have
I'll take
been
up
asked to,
expert.
my lord,
In the
take
first
time,
top
my lord.
matter, no time, sorry. Yes,
1 week adjournment, my lord.
yes, page
Page 40,
40. Yes.
1/4. E3. This is for the boundary wall and renovate of a graveyard. Money have been allotted, some money has not been released by the district magistrate. You ask for to release the money. This is the page 14. From 2019 to 2023. no
Page
This is the
14 is
19
something else. Please
29
don't disturb
matter,
it.
my lord.
Please. Yes.
Huh.
Page 14 is something else. This is the ordering portion of Justice Banerjee.
Yes, that is page 14.
Page 14 says urgent certified copies. Only this.
Last full line,
Page 14 must be some other page.
last full line.
Page 13 in my copy. District magistrate should also release the requisite funds in accordance with law.
BDO asked for that money. From 2019 till date, no money have been given, but the work is half done.
Why didn't you file a contempt application? You have an order of court. So where is the necessity of a further writ petition?
As they ask for further money, that for.
They asked
have
for?
Allotted 19 lakhs. That was expended. They have asked for further money,
You have asked for further money.
BDO, for completion the work.
Who are
That Money
you?
has not been given.
You are the
BDO could not.
You are the secretary of the Gorosthan Porichalan Committee. You are in charge of upkeep of that graveyard.
Yes. In the last of-
No, some money was disbursed to you.
Yes, some money has given. That has already been,
So you have to apply again for further money.
yes, well, that was applied for that reason.
Page 15.
Page 14, 15, this is the BDO has given the notice to the DM. The further money is required for completion the work.
So I'll direct the DM to scrutinize this request for further money and disburse the necessary money.
My lord,
And-
instead of passing order, my lord, kindly
No.
adjourn for a week, my lord.
No.
He is sick, my lord, on his part.
একটা order record করুন। An adjournment order is prayed for on behalf of the state. Full stop. Next para. However, this is the first item appearing in the list today under the heading within double inverted top,
As
double
because
inverted
he is
close.
sick, my lord, that's why I am praying adjournment, my lord. He is in hospital.
I've heard you, at least you have said 5 times. I think 5 times is enough. I've told you no. full stop. As such, comma, the prayer for adjournment made by the state is refused. Full stop, next para. The order prayed for by the petitioner in the present writ petition is innocuous, full stop, by placing reliance on a previous order. Mr. Arifin should have pointed out. Aisa kete din. Since I appeared for the petitioner in a previous matter, comma, which should have been pointed out by learned counsel for the petitioner, but unfortunately was not, comma, I release the matter on personal ground with liberty to the parties to seek for assignment before a different
Not I
bench.
am very
Next.
grateful.
Yes.
Item 7.
Yes.
Lordship, I appear for the petitioner.
I appear for the National Medical Commission.
Yes.
The affidavit of service,
7, right.
the affidavit of service is ready.
Yes.
The state has been served according to your lordship's order.
How are you, Mr. Chakravarti? Long time no see.
Uh,
In the rest of them, yes.
So in 21, 22, after Corona, I was a little away for some time. I was suffering.
What is the matter?
Yes, Lordship, may I take you?
Sir Roy and Mr. Haq, please take your seats. Yes.
May I take your Lordship briefly through the facts of the case first? Lordship, the National Medical Council had devised a system whereby private medical colleges were to come up in different parts of India.
Inside or outside, Mr. Vasu? Outside. Yes.
Keeping the door open.
So after that, yes. Mr. Chakravarti.
So this National Medical Council of India had framed a policy whereby private medical colleges were given permission to appear in different parts of India. Now, subsequently, around 2020, the state government decided that it will start a public-private partnership, the system being that district government hospitals would be leased out to private parties on the basis of rent. Now, this was because these hospitals had to have medical colleges come teaching hospitals. Now, when private entrepreneurs came in the picture, they could provide land and they could provide buildings. But what about the hospitals? So the system was that the government will provide the hospitals in lieu of rent and sometimes lease stretching up to 33 years and so on. Now, this system was formalized around 2020. In the meantime, the Medical Council of India was rechristened as National Medical Commission. Now, the system was this, that there would be this invitation for opening of private colleges. Then this is known as expression of interest. Now, after this expression of interest was scrutinized, it would go through various channels, and ultimately the arbiter will be the National Medical Commission. It will be sent to Delhi and National Medical Commission will be the arbiter. Now, under this system, the petitioner, who is a trust registered under the Indian Trust Act of 1910, Mollobhum Human Resource Development Trust. Now we applied under this system. After we applied, we were asked to submit the requisite documents in order to obtain the essentiality certificate and the affiliation. So these are given by the Ministry of Health and Family Welfare along with this
University.
along with the health university. So they provide these certificates. Now, subsequently, the matter goes up to the National Medical Commission and the National Medical Commission approves. So this is how it works. Now, accordingly, we submitted all our documents. That is all here, Lordship, in the public domain. However, there was a rival party, which is the respondent number 7. The respondent number 7 also came up with its plan. Now here, after the 2020 regulations were revised, there were 2-3 vital points. The first point was that there has to be a separate piece of land for this infrastructure. It cannot be combined with any technical college, engineering college, nursing, dental. it is specifically stated that that cannot be done. It has to be on a separate piece of land.
Which you have
Second-
to provide.
Which, yes, the private entrepreneur can provide it,
Yes.
but the government will come forward with district hospital. Now, this district hospital and this building, they say that there has to be a distance, it should not be more than 10 kilometers, and or alternately, it should not take more than half an hour to travel. If it is not too close, at least it should be 10 kilometers, not more than that. These were the various provisions.
Between
Now-
the college and the hospital.
That's right.
Yes.
Because both are part of an
Has to
integral
be,
system.
yes,
Yes. Now, subsequently, we applied. And after we applied online, this is online systems, everything is in the public domain. Now, the rival institute also applied. Now, there's a specific provision that if there are 2 or more contenders, there has to be a bidding. Now, what happened? After this, we were waiting for the results. Suddenly, we were told that you have been disqualified and the rival has been given the opportunity. Now, while this was said, they came up with their affidavit in opposition. Now, in their affidavit in opposition, which is here in the public domain, and it was all from the website. Now, they have given the picture of the institute, which clearly says that it is Institute of Technology, Institute of Polytechnic, I'm sorry, Polytechnic. And additional floors, it was quite clear, additional floors have been constructed thereon to provide for this medical benefit, which is against the provision which is there. Point 1. Point 2, we know that it has to be on a separate piece of land. And it has to be, even the nursing, dental, medical should be separate. Now, what happened here was that they admitted that, no, we have had a fencing done. On a piece of land, there's a fence. And so there's a fence, it is separate. Now, after this, when these documents, they didn't show any pictures, but we came up with these pictures because it was in the public domain. It is there in our reply. Now, since our case was rejected, we had come up with this writ petition. In the meantime, what happened was that our rival, the respondent number 7, had gone up to the National Medical Commission, as was expected. At that stage, the National Medical Commission rejected. And they rejected on the grounds that your essentiality certificate, certificate of affiliation, and certain documents which you have said were there are simply not there. And yet, in the affidavit in opposition before your lordship, they say we have submitted everything. That is why we have got the permission. That is as far as the state is concerned. At the center, it was rejected. Now, what happened was that the state conceded to. The state took. Now, this was before another litigation held before Justice Amrita Sinha on a different cause of action for which we were not parties there. But since it is in the public domain, we know about it. Now, subsequently, they said that we are taking this case to the appellate forum of the National Medical Commission. Here, the state intervened to say that the National Medical Commission appellate forum has also rejected their case. So this is where they stand. Now, after this, what happened was when they went before Justice Sinha, their prayer was that subsequently, again, a new notification has been issued for the year 22-23. This was the previous one where I was rejected and they were accepted. That was 21-22, which ultimately faced rejection before the National Medical Commission. Now they say 22-23 is out. So we want to contest for 2022-23. So that was the reason, which does not concern us because it was a separate cause of action. We were not there, but we could glean the facts from this case. Now, what happened was, in the meantime, it was detected that the 21-22 original circular has not been repealed. This 22-23 circular has come about without repealing the original circular, and both were there side by side. So here, Lordship, at this stage, we, after knowing all these facts, first, we had filed our affidavit in reply. Subsequently, more of these facts came out when the canvas filed. Now,
You had challenged their selection in 21-22.
no, only the first one. In the petition, That was in 21-22, but not 22-20.
So that has not yet come.
Right. Only, yes, we are child.
So both of you may participate now in 22-23. That would suffice. I mean,
Qualification
Yes,
the
but
best
then the
solution.
point is that if now, since they were not qualified, they were rejected in 21-22. Now, our stand at that point of time was that since 21-22 circular was not repealed, our application is already there and our rival has been rejected and it is sub judice. The matter is before your lordship. So why should we not get a chance to process our papers and seek final approval for 21-22? Now, at this juncture, lordship, we had to come up with the scan because these factors came to our notice later. Now, as it stands today, I think last time your lordship was pleased to observe that this gives rise to a separate cause of action. Now, what we are saying is that if now we had filed a representation before the concerned authorities that why are you not considering our prayer as far as 21-22 is concerned, and our rival has been rejected, although he has misrepresented his case before the honorable court. He says that I have every right and so on, but the National Medical Commission has rejected it and the state has conceded that it has been rejected.
In the
So-
application, you have challenged the 22-23 floating.
In the original writ petition,
In the application,
no, in the application, I had only brought out these facts with the prayer that since I have filed a fresh representation before the authorities to consider my case, they are keeping mum. So they should consider, which really will give rise to a fresh cause of action. So they should consider our representation and the
representation is for what? Considering you.
kindly, lordship kindly comes to the press on this scan application.
Basically, what is it, Mr. Chakraborty? So that 21-22 is sustained because they were rejected. So you should be put in as in their place
Absolutely.
automatically.
Absolutely. And kindly, lordship kindly sees prayer D on page 14 of the can. That is the sum and substance, the crux of the matter.
So there are two limbs. The primary limb now is that you have to satisfy me that they could not have floated this 22-23 despite you being the clear winner after their refusal.
In the earlier year.
In the earlier, yes. So that is the first limb. If you succeed there, then the second limb comes in. That probably, I mean, automatically it comes in because they have been rejected.
And lordship, basically, since we are not applied in the second case, since our application was still pending and the matter was sub judice, so therefore it
What
was
is the stage of the second one, the current one?
the current one,
Has it
lordship.
been closed?
Perhaps the respondent
will be
number
able to
7 will be able to throw light on it because we are not parties.
So, Mr.
But-
Chakraborty, my first question to you on this is, why under law, why can't they float a new notification?
No, I'm not on that, but they have not repealed the earlier one. So why
What's
should I
that?
not be considered in the earlier case? There's no supersession of the earlier.
Can you please
provision.
show me the last one?
Yes, lordship. Last order.
The last circular. I mean.
Last circular, yes. Lordship, yes, lordship will kindly come to the can.
Can page 49?
Yes,
is it that?
yes, page 49.
Can 1, page 49.
Can 1, page 49. কোথায় page 14?
এই তো, এইটাই হচ্ছে
হ্যাঁ, হ্যাঁ।
22-23
This new invitation, Government of West Bengal Health and Family Department, dated 14 September 2021. This is, I think your lordship is wanting to see this.
Yes, yes, absolutely.
মানে ডিটেইলে করা আছে
This appeared in 2021.
Was it exactly similar to the previous one?
Yes. Yes,
বাট নট ইন সুপারসেশন
but there was no supersession. It was not repeated.
কোয়ালিফাইং ক্রাইটেরিয়াটাকে হাইড করা হয়েছে
কি বলেছে?
600 কোটি টাকার নেট অ্যাসেট থাকতে হবে।
Oh, lordship, I'm instructed to say that only the amount has been hyped, that the net assets have to be 600 crores.
Acha.
That is the only difference.
But the tenor was the same. So let me hear them now, Mr. Chakraborty. Yes, whom should I hear? The state or you?
My lord, I have a very short submission, Lordship will hear me.
Yes.
My lord, possibly Mr. Chakraborty's grievance is not against me.
No.
Because my lord, my
Not
stage of
exactly.
my intervention has not
Not
come.
yet come.
But my lord, your lordship will consider, my lord, whether at all the writ petition is maintainable at the instance of the petitioner. Why I tell your lordship, my lord, and subject to correction by my learned senior friend, my lord, an impression has been given that it's sort of a tender where, my lord, various parties are applying and it is being, and the government considers as to who should be given. But in my respectful submission, if your lordship sees the regulations of the National Medical Commission, which was originally issued by the Medical Council of India, but there is no bar on the number of applications which can be made. And it is open to everybody. Anybody and everybody can open a private medical college subject to fulfillment of the conditions of the regulations. So therefore, my lord, my submission to this extent, your lordship kindly considers that he does not have any right to challenge the appointment or the permission given to another medical college or an institution to set up a medical college. Now, this is not in the nature of a public interest litigation. Therefore, this particular trust, but in my respectful submission, cannot be a person aggrieved. The question is whether this trust fulfills the conditions and gets permission to set up a medical college. This is not, my lord, your lordship knows this is not a commercial venture. So therefore, my lord, he
There's
cannot
not a
have any
single, sir.
he cannot have any objection to other medical colleges being
So it's not a single
established.
slot type of thing. So
Yes.
there may be many hospitals.
Yes, yes, because that is not barred under the regulations.
Very good.
So therefore, he cannot have any legal right if somebody else has been given permission to establish a medical college in a particular district, but no other person, in my respectful submission, can have any legal right to challenge that. And if it is to be done, well, possibly it is to be done by a public interest litigation if there is something wrong with it.
Very well.
If
Then
there are any
why should
allegations.
they be incorporated automatically by virtue of their rejection?
No, Malad, that is because
That's a different question, but why not?
yes, because Malad, kindly consider their rejection is not material for their inclusion. As I said, Malad,
They were also not qualified.
if
They
they
were
are,
also,
yes, if your lordship, Malad, kindly see, if your lordship kindly takes the writ petition once, I just want to place one part of the regulation. The first very opening part of the regulation. Kindly take Malad page 113. Kindly skip over to the English part at page 115.
after Justice Datta's judgment, you should place page 113.
But I am handicapped, but I will not be able to place it before your lordship.
Yes.
But kindly see 115.
Right.
These regulations may be called the Establishment of Medical College Regulations Amendment 2020. They shall come into force on such and such. In clause 2.2, the qualifying criteria, actually, Malad, I should place the original.
Yes, I think so.
Yes,
This is the
Malad, kindly take not the amendment. Kindly, Malad, take page.
18.
Yes, Malad, kindly give me a moment's time. Yes, 18. Malad, kindly take 3.
Yes.
The last paragraph. The establishment of a medical college. No person shall establish a medical college except after obtaining prior permission from the central government by submitting a scheme annexed with these regulations. Now, Malad, kindly turn over to the next. The eligibility criteria. The following organizations shall be eligible to apply in Form 1. And that is the state, a university, an autonomous body promoted by the central government, a society registered under the Registration Act, a public religious charitable trust. Then, Malad, kindly see the qualifying criteria. 2. Eligible persons shall qualify to apply for permission to establish a medical college if the following conditions are fulfilled. Then, Malad, these conditions are given. But what I am trying to impress upon your lordship is that anybody, wherever in India, if fulfills the criteria under these regulations, are entitled to establish a medical college. Now, therefore, somebody else establishing or being rejected it doesn't matter because there is no bar
So
that
that part I've understood.
that part is-
because it's I mean, they don't operate in the same, for the same land or something like that.
absolutely.
So they can, two of them can also.
They can apply.
Several people.
They can apply.
Yes.
Therefore, Malad, his establishment,
No,
in
no.
my respectful submission, cannot be challenged
That is
by
the
the
subsequent cause of action that I've understood you.
My lord.
But about the first cause of action, probably you are not the answering. party.
No, that would be the state because application has been made before the state. So, Malad, state has to explain why, despite if my learned senior friend is correct
Yes.
and all conditions have been fulfilled, Malad, then why state is not issuing the or not giving the permissions, Malad, that has to be.
Mr. Chakravarti, you want to say something?
May I just clarify one or 2 points from
No, I'll come to you. Yes.
Lordship? First point is, I'm in no way challenging what somebody else
no,
has got or not got.
We are speaking probably at cross purposes. I
Yes.
mean, all of us understand that.
So,
that
Malad,
part.
subject to correction, that is the specific prayer in the written.
No. That is what I have said is that if he has been disqualified, and in these cases, there's a question of tender. That is, bidding. There's a question of bidding. That is their rule. So no bidding took place, number one. Number two, if they have been rejected, it
You have
is.
served on the state also, Mr. Chakravarti.
I've served.
Mr. Chakravarti, please show me the relevant regulation. now.
Yes.
Because
just a minute.
probably
Page 18
we need not.
Page 18 onwards of the writ petition.
Page 18 onwards. No, which is a relevant regulation.
Yes.
Which says that a bid has to be held.
Yes, that is.
And was there any
2A.
specific rejection of your application?
Yes, there was specific
Please
reason.
show me that
Yes,
first, then we'll
yes,
go on to that, the
yes.
other one.
No.
Yes, you were apparently never successful, even amongst the two of you. You were never successful, even among the two of you.
No,
Respondents say-
it was only one chance because the next
Obviously.
time I didn't apply.
So in the first place, why should you be reconsidered after they were rejected also?
No, I'm not talking of reconsideration. Since my application was there and it was rejected, despite the fact that I have given
Why
all.
were you rejected?
Yes, I will come to. I will come to the annexure, Lordship. This annexure which the state has given, that is enclosure E. Enclosure E, it starts from page 30, page 38. Enclosure E. That is of the writ petition.
No, it application.
Application, I'm sorry, application. Page 38, annexure E. There, it is the state which has said that we are rejecting. Now,
Where is the rejection order? Is there any communication to you?
no communication, but it is on the website. Though. It is on the website because this is all online. So, this is page 38, enclosure E.
Affidavits were directed in this.
Affidavits are directed.
State, what is the stand of the state in their affidavit?
Yes, the state had on they originally in their affidavit when we had stated that you have not followed the regulations and they are saying that I've been rejected. So the compilation has been given, compilation has been prepared.
Composition status.
Evaluation reported at a compilation.
They have given a evaluation report in the form of a compilation. That is what the state has done. Now, this evaluation report in the form of a compilation.
So what is the
this
reason given by them for rejecting it?
Lordship, they say, now this is page 38 of the application. And it is so interesting that the Lordship will see that this is the copy that they have given. We can hardly read it, but they've said it is rejected. Now, there they have made.
In their affidavit, have they said anything?
No, the state has not given any affidavit.
Only a compilation has
Only a compilation. The affidavit has been given by respondent number 7 only. That is the rival party. They have not given any affidavit till date.
কেউ কোনো opposition file করে?
একটা part relevant.
আর একটা
part
compilation
that
উনি
is
বলছেন না?
This is enclosure E, Lordship.
Page 38
Page 38.
of the application.
Page 38 of the latest
কোনো
application.
তো compilation দেখছি না।
And today also state is not appearing.
And today also, despite notice that the state is not appearing.
38 of what?
Evaluation
The writ
report.
petition.
No, application. The last application,
Oh.
can.
I have annexed the
Oh,
relevant
this.
part.
Acha.
The relevant part has been annexed. And, this is what they have said. Now, number two,
Number one is private respondent.
the number one is the private respondent whom they had cleared. And
Everything is Y. Yes means yes. Everything is Y.
in their case, everything is Y. Y means yes. That is how they have done it.
And
Lordship sees.
next page.
And in the next page, at the bottom of next page,
Hmm.
comes my
Mollabun.
trust, Mollabun Human Resource. But that is absolutely illegible, and this is all that they have provided.
Only the ends are legible.
Yes.
N.
N means no.
Yes, those are
Everything-
legible only.
Everything is N. No affidavit, nothing.
Now kindly come to read petition.
Now, Lordship kindly sees the writ petition,
Page 125.
page 125.
Why is the state remaining absent in so
I
many
don't know.
matters like this?
And if they have been rejected at the ultimate level, that is my learned friends level, they have
You
been
don't
rejected.
automatically come in. If you are also not qualified, eligible,
No, but there is every chance of my case being reconsidered because now there's
not
nobody
even
else.
that, Mr. Chakraborty. If you are not eligible otherwise, suppose you are also providing a land which is not qualified,
Lordship,
why
see-
should you be reconsidered?
No, I understand.
Suppose I
but
get zero in an examination.
I understand. But
Another person gets zero. So
yes, but everything is there in the public domain. So we have forwarded our documents. Everything
you
is
need
here.
not be reconsidered. You need not be reconsidered. If you are not eligible, you go.
No, but
Even if they go, you also go.
but if whether I am eligible or not, the ultimate
That has to be disclosed.
arbiter here, in their case also, it was the National Medical Commission. In
Probably
my
it's a
case
part of
also,
the state secret.
Lordship, the state is not appearing.
It's a
And
part
they-
of the state secret.
And they are not providing any affidavit.
125 page ta
And page 125,
The
Lordship,
difficulty, Mr. Chakraborty, is if the state does not take a stand, this is not one of the matters we can automatically direct you to be given allotted
no,
this
I'm not
project.
saying that.
Because that cannot be.
I'm not
Because we are
saying
not
that.
technically qualified to know whether you are technically qualified.
Absolutely. But since we have given all our documents, it has been uploaded on the website. If they say no, it has to be a reasoned order. Why no? There's no order. There's no affidavit, nothing. So this is the problem, Lordship. We have given all the documents. So if we have been rejected, there has to be a case why we have been rejected. So without any reasoned order, without any case, can they reject us
So
arbitrarily?
subject to hearing the respondent number 7 now, Mr. Haq, one solution can be you will be given another hearing and your case will be reconsidered. by
Yes,
issuer.
that is what we have
That
also
can be one
prayed
of the
for.
options in
That
the
is
absence of the state.
what we have prayed for. It is not our case that we are challenging anybody or we are not allowing anybody else to contest. That is not the case. The case is when you have given all our documents, when those documents are, according to us, all in order.
Achha, regarding their rejection, you have annexed everything.
Justice Amrita Sinha's order is also there, where they have conceded that we have not been able to provide the papers and it has been.
Just show me that order of
Yes,
justice.
yes. That order is
application.
in the application, Lordship. The application which I have provided,
আপনার application টা আপনি দেখুন sir.
it is there. Just a minute.
Page 61 onwards.
Page 61 onwards. Page 61 onwards of the application.
আপনার application টা দেখুন।
Enclosure H, enclosure H. This was the representation I had sent subsequently. So here my case was that since I've sent a
Page 60.
representation for reconsideration, at least they can give a reasoned order that we are rejecting or we are approving. Even that has
Your
not been done.
representation is page.
That is Lordship. Yeah.
এটা প্রথমে দেখিয়ে নিন স্যার।
হ্যাঁ।
এটা প্রথমে দেখিয়ে নিন।
Okay, first let me show this order of Justice Sinha.
Very.
So here, the second para, Lordship,
Yes.
page
61.
61, enclosure H. By an order dated 27/28 July 2021, the petitioners were intimated by the National Medical Commission that the deficiency in the application was found incomplete to initiate the process of application for starting the medical college. The essentiality certificate, consent of affiliation, and the memorandum of understanding from the government on availing the district hospital for a period of 30 years was not available. Challenging the order passed by the president member, the petitioners preferred an appeal before the National Medical Commission. And according to the petitioners, the said appeal is pending. Now, Lordship turns the page. Lordship comes to page 63. There, it is said, the petitioners, last but one para, the petitioners submit that though when the earlier application was made, all the documents were not readily available with the petitioners, but presently the petitioners are in possession of all the necessary documents that are required for the purpose of filing the application in terms of the present advertisement dated such and such. But just the para prior to that, 2 paras ahead, the learned counsel representing the state respondent submits upon instructions that the appeal preferred by the petitioners has been disapproved by an order dated such and such passed by the president member, Medical Assessment and Rating Board, National Medical Commission. So the National Medical Commission, they've been thoroughly rejected. Even the appellate board has rejected their contention.
So they have been given a new lease of life. If they now can produce those documents and something, they can participate in the new one.
Yes, but
It is legitimate.
But the appeal went, their appeal had also went. So I am not on whether they should get it or they should
Is
not
that
get it.
exercise over pursuant to the new advertisement? That is my question.
That lordship.
Let me ask
yeah.
this respond on 7 now. So this is all, Mr. Chakravarti. Basically, this is all. Yes. Yes, Mr. Haq.
The inconsistency is apparent.
Yes.
Evaluation reporting.
What is the stage of that new advertisement? Tell me that first.
My lord, no eligible person was there. So the entire thing was dropped.
The new one also dropped.
New one was dropped. And the earlier one, your lordship, wherein we participated, my learned friend's client participated, Lord, at the initial stage, their application was rejected.
On what
the-
ground that is not disclosed by the state?
That is not up to me.
Obviously, if you knew that it would be collusive.
Definitely. It's not that, your lordship, because they didn't challenge that. That order they didn't challenge.
No, it is.
They should have.
No order has been issued.
Whatever it is, their application was rejected. They didn't challenge that. They should have. If they would have been aggrieved, means without taking into consideration of any of their documents, the state has rejected their prayer, then they should have challenged it.
There was no specific rejection. They say there was no rejection. That was only disclosed in the
My lord, the entire thing proceeded. After, my lord, this is not a one step thing. After this, your lordship, what happens, your lordship, this with regard to this availability of hospital, it happens that when a new medical college is being established, a medical college should have a fully running hospital or a nursing home, which is running for 4 or 5 years, 3 or 4 years. Now, with all the facilities. Now, these institutions, my client, they are newly established, new concern. They didn't have any experience of all these things. So they only have the lands and the structures. So they had to, for the establishment of a private medical college, one want to have the assistance of a medical college. So the state came forward. They said, we will be assisting you with, we'll be providing with the facilities of our existing hospital. So they advertised. All the eligible persons, all the eligible candidate or the interested candidate, they participated in the bidding. It is by way of a bidding.
Participated, their bid was rejected. Their application was rejected.
Yes, Lord.
They did not challenge, but after that,
Subsequently, yes, sir.
they have challenged this in the petition. They have challenged the essentiality clause.
Yes,
Subsequent also for that.
Need not go into. I mean, I don't want to hear the entire history. Please don't waste time. To come to your point.
Yes, Lord. My lord, I will place before lordship the order. Means the
Need not place anything. What is your point? You are rejected up to the end.
Yes.
So what
My
is your locus
application-
standi to oppose them?
Their application, I will tell you, lordship. I will take 2 minutes before lordship. My lord, their prayer in the application that has become infructuous. Can you look into the prayer?
What is your locus standi, sir? I am asking you. You have been rejected to the hilt.
Yes, my application was rejected.
So you
They
have
may
no
have-
business to resist them. In fact, you have been given leave to approach the.
This subsequent application, wherein they had stated,
Hmm.
they had prayed, my lord, that I should be blacklisted.
No,
But
definitely I'll not grant that.
That is it. Otherwise, I don't
Yes,
mind
I'll not
anything.
grant you blacklisting from here. How can I?
That is the prayer. I don't object, my lord, whether they pray before the concerned state respondents for seeking any.
So,
direction
Chakravarti,
for
one
their
question to
consideration.
you before deciding
Don't
the
mind.
matter. Finally, one question to you. Why haven't you challenged your rejection at all? You have challenged after participation, after rejection. You have challenged the essentiality certificate clause. That is the only challenge in the writ petition.
Because Lordship, this scan that had been filed with all the papers that they have been
In the main writ petition.
yes, because at that point of time nothing was known for certain.
না, না,
Because
দুটো part আছে, দুটো
there are
part
two
আছে।
parts.
প্রথমে
আচ্ছা,
essentiality
very
certificate,
And the essentiality certificate comes
তারপরে চলে
first.
যাবে
The essentiality certificate comes first, then it goes to the National Medical Commission. Now, in our case, Lordship, what happened was later on, when all the facts came to light, we had filed the scan. Now, in this scan, we had prayed for reconsideration, and there is no reply to it. So, as your Lordship said, on,
By the can you cannot improve
No,
what
no.
is not there.
no, I'm not saying so.
So let us see the cause of action of your writ petition
Yes.
first.
My lord, another thing I'll submit for lordship on the two things. My lord,
Need
what-
not need not. Yes.
দুটো টায়ার আছে, একটা স্টেটের লেভেলে essentiality certificate and certificate of affiliation, এইগুলো যদি থ্রু করে দিই
তবেই আমি ওখানে পড়ছি।
স্ক্রুটিনাইজ হবে এনএনসি দিয়ে। ফার্স্ট জায়গাটাতেই আমাকে আটকে দেওয়া হচ্ছে, তাই আমি চ্যালেঞ্জ করেছি, আর কোনো রিজন অর্ডার পাস না করবো।
What is the cause of action?
May I submit?
Yes.
The essentiality certificate and certificate of affiliation, these are the first stages. Now,
Yes.
at this stage, despite uploading all the documents, I've been rejected. So naturally, I have not reached the National Medical Commission level. So, but there is no order, nothing, only they have said no. They have given a document where they said no, no, no.
But Mr.
So-
Chakraborty, that process has become infructuous now because they were selected good, bad, indifferent. They were selected. The process took place up to the National Commission where they were also rejected. So now they are also not there. The entire process is over.
My
That has spent its force.
Lordship, my instructions are till date, nobody has been selected.
So you cannot reopen that, I mean, the entire thing.
No, but since my they let them give a reasoned order why they reject.
Now what will be the effect of that reason order, Mr. Chakraborty?
But then they have to reopen the
They'll have to
bidding in
reopen the
that.
entire thing, which is not there anymore. That is the difficulty.
Yes, because at that moment of time, we are not aware of all this.
Yes, but subsequently also when you came to know of the rejection,
রিজেকশন অর্ডার পাস করেন,
But there was no order, Lordship, so I cannot.
there need
really
not
say-
be any order as such.
No,
No
but-
communication also, you say.
Neither any communication, nor any order, nor any affidavit, nothing is there. Only that's that essentiality certificate,
কনসেন্ট অফ অ্যাফিলিয়েশন,
consent of affiliation, these have been withheld. So it is a peculiar.
Suppose your reply is given to you. You are considered now to be a fit candidate for that. According to you, what should be the next step?
Lordship, if they
Because
give-
they were chosen and they went up to the National Commission
Yes,
and
but
they
I was rejected
I
at
will
the
be sent to the
at
national
the
council.
first stage. I was rejected at the first stage. Now I was rejected despite, according to me, all the documents being there and being uploaded. I have been rejected. They have not given any order why they are rejecting me. They have not given any affidavit why they are rejecting me. So in that event, the next stage is they must hear my representation. I have said so in my can that since you have rejected me, the reasons and so on, if you give a reasoned order why I've been rejected or why I cannot be considered, perhaps that can solve the issue.
এখান থেকে আমাকে থ্রু করে দেওয়া হোক।
And
Yeah.
otherwise, Lordship, the alternate remedy is that since the National Medical Commission is the ultimate arbiter, if as I claim my documents are all there and they have rejected without any reason,
they cannot be the first authority.
yes. So it is the National Medical Commission, which is the ultimate arbiter. So let them reject me. Let me at least make my way to the National Medical
Unless it
Commission.
is, it goes through the state, it cannot reach them even.
No, the state has rejected without any reason, without
After
any
the
order.
state's rejection, if the state does not reopen that issue, they cannot look into it even. As per their
That is why I have called for this representation, that a hearing be given to me, and then the reasons can be made known as to why I've been rejected. There's nobody else there now. Because, and Lordship, why have they not repealed that circular? That was also my
Need not.
contribution.
Need not. These are not mutually exclusive.
No.
As Mr. Roy pointed out, rightly pointed out. There may be umpteen circulars.
Yes.
Since I have submitted all
আমি বলেছি
No,
তো
but
ওটা।
then Mr. Chakraborty, you will be, I'll just give you leave similar to them. Whenever a new notice is floated, you can, I mean, I cannot do
I think
anything.
that will suffice at the time.
That would be the only thing we can. আচ্ছা একটা order record করে নিন।
next year এ
The predicament of
তাই।
the petitioner is rather peculiar.
ক্রাইটেরিয়াটা
Yes,
ওটা আমি পারবো না, আমি কোয়ালিফাই করছি না।
It's not required, but whenever there
No,
is
no,
an
no.
advertisement, anybody can apply.
No, the point is that every year the net asset is going up.
No,
So-
after once being rejected, I mean, we don't know whether if you put in a
Yes.
clause, if the state, no, Mr. Roy, the state may put in a clause that once rejected, you cannot participate.
And
We don't know that.
and lordship, every year,
May happen in future, but on that basis, well,
No, similar leave was given to their competitor
yes, it is
by
there.
Justice Sinha.
Justice Sinners,
Directed after that, well, even after the National Medical Commission, a second appeal is preferable to the central government.
Maybe.
They went up, that was also rejected.
Maybe.
But all I'm saying is this, that today, Malad, if your lordship passes an order, then they will be considered for the next. They may not be eligible.
I have
Subject to
that required
eligibility of
document.
lordship.
Obviously subject to
Yes,
eligibility.
why I tell your lordship, today your lordship is considering whether some other clause is.
No, if they're eligible only, then they'll be selected. Definitely they can participate. I'll keep that
No,
open.
they can always participate, but for that.
Anyway, so why waste so much time?
and just one point, Rashid,
No,
last
no,
one.
nothing is. The predicament of the petitioner is peculiar. Full next para. Most of the arguments advanced by learned counsel are at cross purposes. Full next para. At the outset, the writ petition had challenged the introduction of certain stipulations in a notice inviting expression of interest, for setting up a public-private partnership arrangement of hospitals and medical colleges with the state of West Bengal. Learned counsel for the petitioner contends that the petitioner participated by submitting expression of interest in connection with such a notice, without specifically rejecting which, subsequently the petitioner came to know that the respondent number 7 within bracket competitor of the petitioner bracket closed had been selected. However, ultimately the said selection went up to the National
Medical
Thank you. National Medical Commission and was ultimately rejected. The matter culminated in a writ petition before a coordinate bench of this court, where the respondent number 7 had challenged the issuance of a subsequent notice inviting expression of interest dated September 14, 2021. The coordinate bench, however, granted the respondent number 7 the liberty to participate in the said notice. Next para. It is contended that by default, upon the rejection of the respondent number 7 in the previous exercise, the writ petitioner ought to have been selected as the successful candidate for entering into a public-private partnership with the state. Next para, it is contended that at the outset, while filing the writ petition, there was no specific communication of rejection regarding the petitioner's expression of interest by the state, for which no such rejection of the petitioner could be challenged in the writ petition. Next para, it is contended that, in fact, the state has not expressly rejected the petitioner's application by furnishing any reason at any point of time. The cryptic documents disclosed by the state subsequently, as found from the relevant website, merely indicate that the petitioner's application was rejected. Next para, during pendency of the writ petition, it is submitted that the petitioner learnt of a subsequent notice inviting expression of interest dated September 14, 2021, comma, which had been challenged by the respondent number 7 before the coordinate bench as well, without impeding the petitioner, comma, which apparently could not have been issued, comma, since there was no supersession of the previous notice, comma, in which the petitioner had participated. Full stop, next para. Thus, comma, challenging the subsequent issuance of notice on September 14, 2021, as well as the apparent rejection of the petitioner in the previous exercise, comma, the present writ petition and the application are submitted to be allowed. Full stop, next para. Learned counsel appearing for the National Medical Commission contends that the respondent number 7 was 7 apostrophe S application was rejected up to the topmost forum. Full stop. However, comma, it is further pointed out by learned counsel for the National Medical Commission that the notices in question are not mutually exclusive. It is submitted that, comma, at the same point of time, comma, there may be different notices inviting expression of interest for setting up such hospitals in the state, comma, as per the extant guidelines. Full stop. Next para. Learned counsel appearing for the respondent number 7 submits on query of court that the respondent number 7 participated in the subsequent expression of interest invited by the state on September 14, 2021, but ultimately due to no eligible candidate being found, comma, apparently the said exercise was also closed. Full stop, next para. In the circumstances of the present case, comma, the submission of the National Medical Commission appears to be justified insofar as the separate and different notices inviting expression of interest are not mutually exclusive to each other. Full stop, next para. Under the scheme framed under the scheme in question, comma, at any point of time expression of interest can be invited by the state for use of government hospitals for facilitating establishment of private medical college in West Bengal based on National Medical Commission guidelines by allowing use of government hospitals of 300 beds or more in lieu of user charges on temporary basis. Full stop, next para. In the at the present juncture, comma, as it stands, comma, the respondent number 7 apostrophe S application stands rejected insofar as the previous notice inviting EOI, expression of interest bracket EOI, is concerned. Full stop. However, comma, since the petitioner's application was never rejected by any reasoned order, comma, the petitioner is still aggrieved by such rejection. Full stop, next para. However, comma, there is nothing in the guidelines or the notice in question to indicate that any reasoned order of rejection is to be communicated to the candidates. Full stop. Although the state, comma, in the present case, comma, ought to have appeared and used an affidavit in opposition, comma, the state, comma, for some unknown reason, comma, chose not to use any affidavit or appear at the final hearing of the matter. Full stop. Be that as it may, comma, for whatever reason, comma, the petitioner had been rejected on the previous occasion and the exercise had reached culmination upon the respondent number 7 having initially succeeded but having been turned down till the last forum. Full stop. The said previous notice inviting EOI cannot, thus, be reopened at this subsequent juncture. Full stop. Such an exercise would be futile. Full stop. Next para. Insofar as the subsequent notice inviting EOI dated September 14, 2021 is concerned, the petitioner has not participated in the same, due to pendency of the present litigation. Full stop. Next para. However, that does not preclude the petitioner from participating in any future notice inviting EOI, including the notice dated September 14, 2021, if the same is still subsisting. Full stop. In such case, upon participation, in the event the petitioner is found to be eligible and qualified as per the relevant guidelines, the petitioner shall be given an opportunity to participate such process without being prejudiced in any manner by any of the observations made herein and or its previous rejection in the notice inviting tender, which is the notice inviting EOI, which is the subject matter of challenge in the present writ petition. Full stop. Next para. In such view of the matter, WPA 11405 of 2020 along with Can 1 of 2023 are disposed of by granting liberty to the petitioner to participate in any future future notice inviting expression of interest to open a public-private partnership with regard to the scheme floated by the central government, by the national medical
State government.
scheme is floated by
No, that's national medical, but this private-public partnership is state.
under the scheme floated by the government of India.
State health department.
No. The original scheme is by the government of India or the National Medical
No,
Council?
National Medical Council is government of India, but here the state is
By the
doing this.
government of India. কি বললাম না সেন্টেন্স না সেন্টেন্সটা বলুন dispose of by granting না future notice inviting EOI if floated by the state within the contemplation of the scheme of the government of India in that regard. Full stop. Next para. Nothing in such case, nothing in the previous rejection of the petitioner and or the observations made herein shall preclude the petitioner from so participating, if the petitioner is otherwise eligible and qualified to do so. No address to cause such a set.
Deeply obliged, Lordship.
Sir, Chakraborty, the notice has to be given by the state, but the scheme is of the central government.
Yes.
But, may I just indicate one thing?
Yes,
But
Mr.
kindly
Rai.
do not take me amiss. Your lordship has held at the beginning and end of your lordship's judgment that
Yes.
the subject matter of challenge is the expression of interest. But subject to correction, that is not the case. The challenge is to the certificates issued in favor of the respondent number 7. The scheme has not been touched in any way.
No,
They have
B,
not-
the relief B of that writ
Yes,
petition
kindly,
is
have a
relating to eligibility
Mm,
criteria.
Yes,
No,
because it
kindly
is not
see-
in terms
kindly
of the
see.
scheme.
I read it, Malad.
B is
Subject to your
eligibility
lordship.
criteria.
Yes.
Criteria.
No, Malad, B says, for-
C is challenge against them, Mr. Rai.
Malad, kindly give me a moment's time.
Check
Malad.
up later. Call on the next one. Yes.
Item 8,
Malad, in favor of
So,
Vishnu.
Basu, please show him B and C. Yes. Next matter, yes, who is appearing for the petition? Yes, what is the matter?
But I
and for the petition.
have the basic issue.
Yes.
This matter, my lord, in short, is this for shifting. The issue was, my lord, high tension supply is to be shifted. Technically, it was not feasible.
Right.
They referred the matter to RGRO. RGRO said, you are the best person, you decide it. We said very well, we take protective measure. We raise the quotation. 1,47,000. They were aggrieved. They were, my lord, again asked for reconsideration. We reconsidered, we gave particulars and quotation was again sent. Then, well, they were not happy. They went up to, my lord, Ombudsman. Ombudsman dismissed the matter. Then, my lord, they came up before lordship. Lordship in number of orders was pleased to observe. They, you will have to do.
Yes,
it.
what is your challenge?
My lord,
And one more thing, lordship.
it is a
The move is writ petition.
my lord, it is a transfer bid to me. Previously, I was not there.
Apart from that, any other point?
My main point is, my lord, as per Article 300A, I have been deprived for enjoying from the property.
I've forgotten what is in 300A. Please tell me what in your writ petition, what is the practical
My lord, my submission is they have to withdraw the.
What is your grievance?
My
What has
grievance
happened against you?
My grievance is, my lord, the high tension lines of 33 kV have been passed over my line. I am residing there in a
That
tin
has
set.
been taken care of. They have given an estimate.
My
You
lord.
have challenged that once. Once that exercise is complete, the second time the exercise is complete. Now what do you want?
My lord, my submission is it is my constitutional right to live in peace without any obstruction.
It is also my constitutional right.
My lord, my lord, what my submission is they have to take off the electric wire.
Yes.
And they have another submitted another estimate of 7,44,000. When we proposed to take the line underground. That is my point. My humble submission is they have to take off the electric high tension line from over my cottage, my lord. It is my humble submission. I could not live there.
When the line was being installed, did you protest at that point of time?
Yes, my lord. My lord, I have acquired the property in 1984, my lord. 1984, it was there. I have protested time and again, but it was not.
When did you come in?
84, my lord. I have purchased the land. It is a VT land, my lord.
It was not there at that point of time.
It was there. It was there. It is a.
Then how could you protest when it was taken?
My lord, it is my right.
If you are not there when it was installed, you came in later. How could you protest when it was installed?
My lord, I have to purchase the property, my land, and I live there.
Pay the money, they'll shift.
My lord, I have no money to pay.
Then you cannot
It is a lady. It is a he is an unemployed lady, my lord. Let them take off from the electricity.
I cannot do it because you have to pay them. That is the law.
My lord, another point, my lord.
Why did you purchase the property in the first place with seeing that there is a high tension line? Why did you purchase it? Who told you to purchase? You were a lady at that point of time also.
My lord, they have installed the electric line without any permission from the government. 68 violating electricity section 264, my lord. That is evidence. That has been point taken by
the 64th stage is over now. Now you have agreed because you have submitted to the jurisdiction of the GRO, and you have challenged the quantum which is to be paid. That challenge you have failed up to the uppermost forum.
Lordship.
Now they have reassessed now. So what remains?
But I have taken some points, my lord, in my CAN application.
Tell me the points.
My lord, you lordship.
300A, 64, and what else?
164, my lord, 164.
Section 164 of the Electricity Act?
68, 164. And Telegraphic Act, my lord.
Naturally, if you take 164 Telegraphic Act.
That's my point. And my submission is before your lordship under 226 that they have to take off the electric line from my land. That is depriving my right to property under 300A. That is my main point submission before your read court, my lord. And that's submission I made in your lordship already allowed the CAN application. This incorporated and in the read petition, my lord. You have allowed the my CAN application, my lord.
Achha, where are those orders of the RGRO and all which Mr. Naik submitted? You have annexed those?
Lordship.
Where is that?
It was previously there.
In read petition, my lord?
Yes.
They have not given me the final order, but draft settlement order is at page, my lord, 52. In our affidavit, we have said, my lord, it was dismissed.
Yes, what else?
Lordship,
Section 164 Telegraph Act and
should I read two paragraphs of my CAN application, my lord?
yes, yes.
I'm reading CAN application from paragraph 2, my lord.
Can 2 or can 1?
CAN 1. CAN 2 is dismissed only. CAN 1, my lord.
Acha, yes. Can 1, yes. Which
Uh,
paragraph?
Paragraph 2 at page 4, my lord.
Read it, please.
That the writ petitioner is the owner and occupier of VT line stated in the writ petition as the said high voltage line as per section 235 of Electricity Act, that the respondent number 1 carry the said high voltage line as prescribed in section 68(1) of the Electricity Act, that the respondent number 1 carry the line illegally without taking sanction of or permission of the owner and occupier of the writ petitioner, and also no sanction obtained from the competent authority prescribed by law. Though the petitioner repeatedly prayed for withdrawal of the said H2H, H2H is the high tension line, but nothing done forcing the petitioner to live with her family members in endangering environment and risks their life. That at the time of the storm, it is hardly possible to live beneath the H2H as the sound pollution causing, but also made all the members of the family residing under confinement of fear. Next, paragraph 3, my lord. That petitioner's constitutional right secured under Article 300A has been inferred with unauthorized encroaching the overhead skyline over my said, not only deprivation of enjoyment at sweet well of the petitioner, but also the petitioner cannot construct his dwelling house as per the building plan sanctioned by the competent authority. That the action of the respondent number 1 not only violation of constitutional right guaranteed under 300A, but also violation of 68(1) read with 164 of the Electricity Act 2003, read with section 10(16)(1) of Indian Telegraphic Act. Next, that respondent number 1 is liable to pay compensation for
Telegraph Act at 164 is not applicable to
Lordship,
you.
Lordship.
Not applicable to you. Not applicable because they are not a transmission company. If it is a transmission company, section 164 read with Telegraph Act would be applicable. In your case, Works of Licensing Rules 2006 is applicable. Works of Licensing Rules 2006, that also provides for similar provisions in section 3. In section 3, but the difficulty is that if you are shifting, wanting a shifting regarding on your own plot of land, yes, then they have to pay. But if you say that it has to be shifted to some other plot of land, then you have to pay. That is the difficulty because you have purchased later and come in later. It was there already. That is the difficulty. So now it's settled that you have to pay. The quantum, I can very well appreciate this. The petitioner, she is not in a financial condition to pay that. But then you cannot apply for this transfer, shifting of the high tension lines. Because high tension line caters to several people. Several people, not in your locality, but in several other localities also. So at the drop of a hat, then the difficulty is the scheme of the act is that anybody and everybody over whose land it goes, anybody will purchase tomorrow and then they say, please shift it. It is not possible. Then the entire electrification of that area will suffer. That cannot be the law. That is why individual has to give way to the public interest. That is the reason I have to reject your application. I mean, you don't have a case.
Will you lordship kindly consider the cost they incurred?
I cannot. Can I? You tell me whether I can.
No,
Under which provision can I? You tell me, give me the provision.
No, there is no provision like that. It is up to
them. Yes, Mr. Naik, anything what to add to worsen your case?
No, nothing, Lordship. Only thing is this, it was existing and Lord, it was
obviously
it is not possible. And technically it also.
Yes, Mr. Niyogi also knows it, but you are Mr. Niyogi.
Yes.
Mr. Niyogi also knows it.
Lordship.
The petitioner claims to be a lady of meager financial condition and is not in a position to pay for shifting of high tension line above her property. Full stop. However, it is submitted that the WBACDCL has estimated huge amount as shifting charges. Full stop. It is argued that the petitioner is suffering immensely due to the hazard of a high tension line running over her property. Full stop. Next para. Accordingly, it is prayed that the said high tension line be shifted at reasonable charges or at the costs of the WBSEDCL. First up, learned counsel for the petitioner seeks to rely on section 164 of the Electricity Act 2003 as well as the relevant provisions of the Telegraph Act. First up, next para, learned counsel appearing for the WBSEDCL submits that there have been previous rounds of litigation. First up, ultimately, the WBSEDCL was willing to shift the high tension line and estimated the costs therefore. First up, the petitioner challenged such estimate before the concerned grievance redressal officer. First up, being dissatisfied with the said order, comma, a challenge was also preferred before the ombudsman. First up, next para, as such, comma, the question of the charges for shifting cannot be reopened. First up, next para, upon considering the submission of parties, comma, it is clear that the petitioner had came into the land by purchase after the high tension line was installed. Full stop, hence, comma, there could not have been any question of the petitioner objecting when the high tension line was taken initially over the land. Full stop. Although the petitioner is not justified in submitting that section 164 of the Electricity Act is applicable, comma, for the simple reason that the WBSEDCL is not a transmission, not operating as a transmission company, but as a distribution licensee, and the works of licensees rules, comma, 2006 is the relevant provision, comma, even the provisions of the relevant section, that is section 3 of the 2006 section rule 3 of the 2006 rules does not help the petitioner much in the present case. Full stop. Next para, the chapter of the petitioner seeking a shifting of the high tension line is over, comma, since the WBSEDCL is agreeable on principle to so shift. Full stop. The dispute now is relating to the costs of such shifting, which as per the provisions of rule 3 of the 2006 rules, comma, has to be borne by the petitioner, comma, since the petitioner has sought such shifting much subsequent to the installation of the line. First of that apart, comma, the high tension line caters to public utility in the area as a whole, and the interest of an individual has to give way to public interest. Full stop, next para, be that as it may, comma, although the WBSEDCL is agreeable to shift the line at the cost of the petitioner, comma, the petitioner is not in a position to bear the costs. Full stop, next para, although expressing its full sympathy to the petitioner due to her financial condition, comma, the court does not have the jurisdiction vested in it to arbitrarily alter the estimate which has already been arrived at by the distribution licensee and affirmed up to the ombudsman, comma, which is the relevant authority in law to do so. Full stop, next para, in any event, comma, the WBSEDCL, comma, as the distributing company, comma, is duty bound in law to ensure that the high tension line is always kept at a sufficient height as sanctioned by law, comma, from the property of the petitioner and all other properties over which it is running. Full stop, next para. Accordingly, WPA 18423 of 2022 and can such and such, can listening, can two
disposed of.
Can one তাহলে শুধু ওটা WPA 18423 of 2022 is disposed of by granting liberty to the petitioner, comma, if possible for the petitioner, comma, to bear the expenses for shifting the high tension line. Full stop, if such charges are paid, comma, as assessed, comma, the WBSEDCL shall shift the high tension line from over the property of the petitioner. Full stop, in any event, comma, the WBSEDCL shall ensure that due safety measures are taken at all times to ensure that there is no no electrical or fire hazards from the high tension line running over the petitioner's property, comma, in due deference to legal provisions in that regard. No rest to cause.
Only one
Get-
indulgence, Lordship. Estimate was made 3 years back. Now, my lord, upon my lord raising fresh
She
quotation.
cannot pay.
Grateful.
Grateful, Lordship. That was applicable at that time. Now, my lord,
If she could pay, Mr. Naik, she wouldn't be before the court.
grateful,
Yes.
Lordship.
Item 9.
You can pay. Whatever is the sum. Yes, Mr. Bhattacharya, what is the matter?
I have a very small request. The request is, your lordship is likely to rise for 10 minutes. I'll do the matter after that. A matter, a very poor lady's matter is going on in court room number 13. I have to attend. I want to come, just come back, a few minutes down.
I'll take it after 12.
12.
I'll take up the next matter.
Great.
Yes. Pass over.
দুটো 12টার পরে উপরে করে আসছি
We'll wait for after 12, Mr. I'm waiting.
Item 10.
Yes, Mr.
Well, this is my application.
Yes.
Oh, Victor.
My lord, in this matter, I am appearing for state, my lord. My lord, a can application.
Why is the state avoiding appearance in so many matters?
No, my lord. My lord,
Any idea the panel difficulty is now over?
now it's
So
sort of.
why are you not you? I mean, the state is not attending in so many important matters for the state. Much revenue is being lost by the state. I mean,
My lord,
in many matters.
I will intimate that.
No difficulty, but it's ultimately taxpayers' money.
I will.
That is my problem. Not about the state as an entity, but it's taxpayers' money.
I
You're
will.
losing revenue.
I
Please
will.
ensure, please convey it to the appropriate
I will
authorities.
intimate that. I will intimate.
Yes, Mr. Chatterjee, I'm sorry.
Now, my lord,
Yes.
in this matter, on 11th August, your lordship was pleased to pass an order. Now, my lord, there is a can application filed by the erstwhile owner
Right.
or the present owner.
My lord, in this matter, my lord, can application is mine, my. I am not facing, my lord, the talk of settlement is going on. I am not facing, my.
Yes, last occasion, it was informed to me and your lordship was kind enough to indicate that if it is then, it should be placed by the learned counsel appearing for the
Right.
owner.
So if there's a
Now, my lord, the main matter. The
Yes.
main matter, my lord, Justice Bhattacharya, Moushami Bhattacharya was pleased to pass an order in March 13, 2023,
Yes.
where the honorable judge was pleased to direct my client to deposit the amount assessed by the Registrar General, assessed by the collector, not 24 Parganas, before the Registrar General High Court, and to intimate the same for impounding the document. My client has done the same. And the amount has been directed to be invested in a short-term fixed deposit till the disposal of this application. This was the order and the direction for affidavit has been given. Now, my lord, no affidavit has been filed by the state. In the meantime, the panel has been changed. My learned friend has come because earlier Mr. Devashish Ghosh and Dev. Oh, he was
I
there.
was
They were
there.
present.
I was there.
He
but
should have filed the affidavit by this
but
time.
at that
But
point
he
of
did not. Very well. A junior member of the bar did not file it. I don't mind. Let him file the affidavit. Your lordship can grant me time till Monday. Your lordship can take this matter next Tuesday. Today is Tuesday. Next Tuesday, I shall do the matter. I want to do the matter. He has no problem to that extent.
my lord, at least 2 weeks.
So why 2 weeks?
Because my lord, practically, my lord, I need to communicate with the concerned department and get the report and
You are
everything.
there on the
The
last
affidavit
occasion.
is there. No further report is required.
You are there on the last occasion.
My lord, I was there on the last
That was 5 months
11th
back.
March.
Now, if the affidavit is not there, then
Is
the
the matter relating to
matter is relating to that a development agreement has been executed between the
FSC.
landowner and the promoter on 100 rupees
You are the
stamp.
promoter.
I am the promoter.
Yes.
On 100 rupees stamp.
Oh,
Then there is a dispute between the landowner and the promoter. Landowner cancelled the power of attorney and also directed that the land to be transferred. Now, my lord, then the matter went up to the arbitration because there is a clause for arbitration. Matter went before the learned arbitrator. Point was raised that this document of the development agreement or the agreement for sale, whatever it may be, cannot be taken as evidence because it is unstamped. Accordingly, we have prayed before the learned arbitrator so that it can be impounded. Learned arbitrator passed the order upon the collector for impounding of the document upon payment of proper stamp. Initially, the collector did not assess
Then we sent a notice for filing writ petition. On the basis of our notice, he has assessed, and the assessment was 19 lakh something. We have made a representation. We say that this is not correct assessment. Please correct it within 7 days. Otherwise, we have to prefer the writ petition before the Honorable Court. He said, yes, it's wrong. We are doing. Now he has come to 6,72,000. That is also, according to us, is wrong. The section which he has given, that in that section, the calculation is much less. The amount is much less.
So that is a challenge in the
That is a challenge in the present writ petition.
So it is a question of an affidavit.
There is no question of affidavit. There is a question of pure question of law. What is to be assessed?
On that section, you will have to argue. They will have to answer.
Yes. Now, if my learned friend is not prepared, let him make the preparation within a week. I don't mind for that.
If the affidavit is, I'll waive the affidavits and then you come prepared.
My lord.
I'll record something on that so that the affidavits are waived and all these things. I'll just put in. I'll first record that you are not pressing that application in view of out of court settlement. This is can 1.
Can 1.
Very good.
They are not affidavit application.
I'm sorry. Yes. Can 1 of 2023 is an application for addition of party. Full stop. Learned counsel appearing for the applicant submits that the said applicants do not want to proceed any further with the same in view of a settlement having arrived at. Full stop. Next para. Accordingly, can 1 of 2023 is dismissed dismissed as not pressed. Full stop. Next para. The writ petition itself is taken up for hearing. Full stop. It transpires that there was a previous direction for filing of affidavits. Full stop. Learned counsel for the state seeks some extension of time to file affidavit in opposition. Full stop. Next para. Upon hearing learned senior counsel for the petitioners and learned counsel for the state, it transpires that the primary dispute in the writ petition pertains to the principles of assessment of stamp duty with regard to a particular document by the collector. Full stop. Next para. Since the outcome of the writ petition entirely depends on legal questions, no further affidavit in opposition is required, particularly keeping in view that the matter is pending for some time. Full stop. Next para. Hence, the direction, the requirement of filing affidavits in opposition is waived. Full stop. The matter shall next be taken up on, today we are on 22nd, should I repeat on 29th?
29th?
The matter shall be listed fairly at the top of the list on August 29, 2023 for final hearing.
My lord, deeply obliged.
With your friend.
Item 11.
Item 11, I represent the state, my lord.
Right. I am for the district. Yes, you are for the WBC.
But I appear for the petitioner. My lord, on the last occasion, your lordship was pleased to pass an order. Kindly takes up your lordship's order.
Mr. Chaudhary, I'll come back after 10 minutes. I'll take that break and start the break.
Before your lordship rise, my lord, may I just only for 2 minutes. What happened, my lord? Your lordship was kind enough to, considering the, my lord, conduct of the WBCDCL, was pleased to impose 50,000 cost, my lord. On the next day, on the very day, my lord, when my officer went to give connection, found the meter was not there. They called me. I said, you install a new meter. New meter has been installed. Now, my lord, yesterday when my officer is going to his house, found the entire building somebody has been demolished.
Sure. What can I do? I don't recollect
personally. The problem
file an application then.
We have nothing to do because we are distribution company. Your lordship.
What can I do?
No, your lordship said that the 50,000 cost has to be, my lord. They will consume the electricity and that shall be adjusted.
So you're not finding the person to give that 50,000?
No, there is no house, my lord. Now, my lord, the developer, what they have done, they have
don't pay the 50,000 then, Mr. Mukherjee. Then I'll decide in the contempt whether you are justified in saying. But this is not an order of court. There is a direction. That direction stands for payment of.
Should be stopped. After your lordship's order, my lord, the entire building, the shop room has been demolished.
Who demolished? How can I know? I don't have any personal knowledge that I can assure you.
Only that thing.
I don't even remember the order. 50,000. Honestly, I don't remember.
What happened, my lord?
Must have been just before the recess or before rising something.
No, there is some conduct, my lord.
Like now.
Yes, only one.
So that's a cue for you.
No, 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 not that.
A similar situation must have happened that I was going to rise and you
No, no, you
disturbed me.
had
So
the matter for
that's why probably 50,000.
more than 45 minutes. You already had the matter. Because there is a direction, consideration of the disconnection. On the next day, my client.
Mr. Mukherjee, if you face any difficulty, if there is some proceeding, then you can, or you can take out an application also, I can modify my order. And whichever way you advise your client.
on the last occasion, your lordship was pleased enough to grant my lord, the direction on the deputy inspector of electrical inspector to my lord, rehear the entire issue. This issue pertains to grant of compensation pursuant to an alleged electrocution. My lord, this alleged part is my lord, been waived, my lord. Now it has been found that there was an electrocution. My lord, we have reheard everybody, all the stakeholders, and here is a comprehensive report as I have been received from the authorities, my
Have
lord.
you given copies to
My
them?
lord, no, my lord.
Then circulate copies, you come back on.
My lord, on the WBC as well as the
Both of them.
yes, yes,
That will be because both are
yes,
stakeholders.
definitely, definitely. My
So
lord,
when do, yes. Anything
just to my lord,
Yes,
my
yes,
lord,
yes,
submit, my lord, the part of electrocution has been found out pursuant to the report filed by the police authorities. Save and except this incident happens 5 years back, that is not 5 years, in the year 2016. Now, my lord, save and except that, my lord, nothing has been found out whether the method of electrocution, the cause of electrocution, and hence, my lord, the assessment of, my lord, compensation could not have been made by the electrical inspector. That this is the sum and substance of the report.
But you could have taken evidence from the WBSCDCL as
Well,
well.
we have taken on record, we have taken all the call records, call docs, and the police evidence of the police authorities. They have submitted their final report that they have made over to the learned court below. They have initiated and that apart, my lord, we have also made a request to the police authorities, that is at page 31 of the report, the last but one page, requesting the police authorities to provide us any further report which is there with them. It was dated on 7th of August, my lord. Till date, we are yet to receive any kind of.
But Mr. Chaudhary, because the WBSCDCL is the distributed, it's their property. Now, why shouldn't liability be fixed on the WBSCDCL if it is not proved that it was due to some other reason?
My lord,
shouldn't the presumption be on them?
My lord,
against them rather.
My lord, the question is whether the allegation raised in the writ petition is there was a live wire and it got, my lord, electrocuted. My lord, such evidence of the allegation of the petitioner could not have been substantiated by any means whatsoever from even the point of view of the petitioners. Hence, my lord, the question of, my lord, assessing the compensation and putting the compensation on the WBCADCL, Lord, could not have been made, my lord. If it could have been the situation that we could have assessed that at least.
It was electrocution. I mean,
electrocution may happen in the domestic area also.
Achha.
That is the method of electrocution. The cause of electrocution.
This person was a resident of that area.
This person is a resident of that area.
Achha.
But the police was informed after the dead body was received by the the hospital.
Then you have to. I'll give you liberty to use an exception if you want.
Well,
otherwise, it's because if the electrical inspector says we cannot do anything on that.
Well, let me go through the report first because.
So I'll hear your response on the next date. When should I keep it? Tell me.
Kindly fix it next week. The petitioner is present in court, so kindly, he has lost his only son, only child.
Yes, I appreciate, but if it's only on compensation now,
absolutely, we
cannot. I mean, she cannot get back her son, unfortunately.
No, absolutely.
So we only decide on the compensation part, the money which you will receive. So if it cannot be ascertained, then how far the court can interfere with that? I have my doubts. No, I have my doubts. You can clarify those also. A report is filed on behalf of the electrical inspector, a deputy chief electrical inspector, as per previous direction, which is kept on record, full stop. Copies thereof are circulated to learned counsel for the WBSCDCL as well as the petitioner. Full stop, in order for the learned advocates for the petitioner and other parties to give their response thereto, comma, the matter is adjourned till August 29, 2023, when it will be listed under the same.
Grateful, my lord. Grateful.
Mr. Rai, you also go through the report, although it's in a sense in your favor. I mean, you check up whether anything is there.
No, in the event, my lord, I receive any further communication from the police authorities, I shall make my lord, further.
What is the scope of that after assessing?
My lord, I have written to the police authorities if they have any other documents to suggest about the place and
When did you write that?
my lord, on the 7th of this month, my lord. My lord, I have appended that letter also in the
When was the order passed?
my lord, on the third, my lord, the police authorities has
When was my order passed?
my lord, your lordship was kind enough to pass this order on my lord, on the 18th of July. Thereafter, we have heard the police authorities visited. They have deposited all documents.
Very well, if something
that
else
apart-
comes up, yes, something else comes up, you just send.
Grateful, my lord.
Item 12.
Yes.
Item 9 passed over matter. I appear for the petitioner 12.
9 is not passed over. 9. Oh, Mr. Mukherjee is matter. Vishwarup.
Yes. My lord said it would be taken up.
Whenever he comes back, I don't know. Yes, Mr. Bhattacharya, 12.
Here is the affidavit of service. Pursuant to your lordship's direction.
After this, I'll take up 9, Mr. Chaudhary. After this, I'll take up 9 ta call kore pore. Yes. Yes, sorry. Mr.
July 25 order passed by your lordship in this matter. The awarding of cost on the nursing home, leaving aside the other two hospitals, my lord. Of course, my lord, they are responsible. We are not responsible for this. Unfortunately.
Oh, yes, 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 that. So hospitals have been implemented.
I have been implemented. Service has already been made.
Anybody appearing for the hospitals?
Yeah. My lord, sorry.
Yeah.
My lord, I am appearing on behalf of the state as well as the hospital also.
What is the hospital?
Calcutta Medical College and Hospital and Sagar Dutt.
And ESI hospital also.
No, I am not on behalf of ESI.
Sagar Dutt Medical College or government hospitals. And he died in medical college.
Yes, what is your stand in the matter?
May I submit a report of medical college to you, my lord? Calcutta Medical College.
File it properly. This
The
is not
report
a
I
drawing
agree
room.
with the
Yes. Looks like your drawing room, but may not be. File in a proper manner. That's not a report file to be filed in. Let me see that. File it by UFA. What is this?
Have
you gone mad out of your head?
Yeah.
Turn it round. Turn it round. Turn the paper round. What is that? Is this the way to file a report in a court? Has the state gone out of its head or you have gone out of your head? This is the new panel of the state. Is it a joke of some sort? You are filing a report in a court of law.
I apologize.
What is that? Your personal prescription or something like that? Behind what is there behind?
This one is the
File it in a proper fashion. What does it say? What does the report say? You have no liability. Apart from that, what can you
this one
say?
is the emergency ticket of the patient.
Yes.
Okay. He admitted.
What okay?
Okay.
You are not fit to
No,
practice
no,
in the High
no,
Court,
no,
sir.
no. My lord, he was.
I'll record in my order that you should be replaced from the panel. What is your name, please?
Vimal Kumar Sahi.
You are Mr. Vimal Kumar Sahi.
Yeah.
This is the first time you are appearing in High Court
No,
or before any court.
No, no. In Calcutta High Court, I am appearing up to 2008.
What is this? Okay, yeah.
I apologize, my lord.
You are the new face of the state in court.
Yeah. Yes, my lord.
I'm extremely sorry for the state, I must say.
এটা কোত্থেকে শিখেছেন?
You are the only one who has to answer the medical college and then this other hospital, Sagar Dutt. Yes, what Mr. Bhattacharya, just please remind me just
The
the.
lordship's order is quite explicit. My lord. The lordship has recorded the entire
What
thing.
are the facts? Just tell me once.
The petitioners, the victim was brought in the nursing home of the petitioner at 10 o'clock in the morning.
Mr. Chatterjee was for
Midnight.
the petitioner.
No, I'm for the respondent number 3. Victim's mother.
Yes, yes, right.
Victim's
That's right.
mother.
Right.
A victim was brought in the hospital, in the nursing home at 10 o'clock in the morning and recommended by ESI hospital as having some sufferance in the heart. But we tested him and we found that he was a COVID patient. We had no COVID permission for treating the COVID patient. Accordingly, we referred it back to him. He was sent to the Sagar Dutt Medical College, who is a notified COVID hospital.
But the Sagar Datta said, we have no bed. Again, he was returned in the morning to the ESI. ESI has again referred him to the Calcutta Medical College Hospital. He went to Medical College Hospital at 1 o'clock in the afternoon, and Medical College Hospital admitted him at 4 o'clock, and at about 9 o'clock or 9:30, he expired.
Yes, file a proper report. You are for the medical college and?
Yes, my
And Sagar Datta.
And Sagar Datta. Despite service, none appears for the what was ESI hospital. Full stop, next para. However, comma, the Sagar Datta Hospital as well as the Medical College Hospital, Calcutta Medical College Hospital are represented through counsel. Full stop. A report is being sought to be filed by learned counsel for the said added respondents, comma, which is marginally better than the personal notes taken in the chamber of learned counsel, comma, in probably his own handwriting. Full stop, the same is returned back to learned counsel. Full stop, the added respondents shall file a report in a proper fashion, comma, suitable to the dignity of the court on the next occasion when the matter is taken up for hearing. The matter shall be listed on August 25, 2023 under the same heading for such purpose and for passing further orders. I'll consider the report and I'll direct the circulation of that. Go through that. I'll redirect the matter to be heard by the authorities, or I'll decide from here. Yes.
Only one thing, my lordship. Our case was, my lord, only within 2 minutes they have written in a check. Yes,
Mr. Bhattacharya,
hospital and stated COVID positive, not even RT-PCR test, my lord.
Yes, that remains.
For that reason, my lord, I suffered a lot. Seeing that cheat.
No, in your complaint, the Sagar Datta Hospital and Medical College are not there.
My lord, my complaint was only, sir, a minute, sir.
Yes.
Only as they have written in that sheet that COVID positive, no other hospital entertained my son. But the fact is, my son went to admit in the hospital only for some breathing trouble, some kind of respiratory problem. But my lord, no minimum medical facility was allotted to him. Ultimately, he died.
So any allegation is made against the others?
No, my lord. I have stated that.
So the case then only hinges on whether they are writing of COVID.
COVID was not disputed that he is not a COVID affected person, and that are notified. Sagar Datta is a notified COVID.
That is on the merits.
CMOH himself, I have shown. I can show once again page 63, 64. The CMOH himself shows them why you have written COVID positive in such a fashion. They have said, they have replied the show cause.
Mr. Chatterjee, there is a difference between a negligence and a negligence to such an extent that causes the death of a patient.
Yes,
there is a difference between them. If it's a cascading effect, if it's indirect, then they may not be indicted with the death of your son.
Direct, mind.
How direct? Suppose I say you have COVID and you actually have COVID, and you are taken to other hospitals. Mr. Chatterjee, that is not of an equal footing. It is also unknown why you have not implemented the other hospitals as part.
My lord,
just because you have your view is also a bit, limited.
2 complaints I have lodged. One is before the
patient is taken to several hospitals. He is refused everywhere on the ground of COVID without themselves checking it. The others also did not check. Just because of their report, they are sacrosanct.
There was no regulation, no guideline. Only
no, Mr. Chatterjee, there need not be any guideline for a medical emergency. A person is suffering. He is brought to several hospitals. The hospitals rely on a sheet of paper given by one hospital, and he is so sacrosanct that they agree to that. They don't independently check.
I bow down, my lord. 2 complaints I have lodged.
You have not even lodged any complaint against them, you are saying, medical and Sagar Datta, because they are government entities.
2 complaints.
Yes.
Before the local police station, there I have written everything, including the names of the hospitals, as well as I have filed a complaint before the Health Regulatory Commission. There also I took the names, but my lord, my principal allegation was against them. Against all other hospitals, I have allegations. But principal allegation was against them. And my lord, before the Health Regulatory Commission,
refusing you on the ground of COVID may not be of such a stature that Mr. Chatterjee that led to the death of your son.
health
May not
my lord,
be,
no
may or may not.
oxygen was given. No minimum oxygen was given. Ultimately, he died due to
Died in the evening, late night.
Huh?
Died in the late night.
died in the late night, but from the morning,
On
he
10
did
o'clock.
not get any kind of.
How long
medical
did you stay
facility.
behind in front of his hospital?
Half an hour
No. From 10
to 10:30.
45
In the morning.
in the morning. They,
And throughout the rest of the day, you went to this hospital from that
I
hospital to that.
went from one hospital to another hospital. Ultimately, most probably before medical college, I threatened that I shall commit suicide. Thereafter, medical college was bound to admit my son.
And Mr. Chatterjee, there is no mention of a complaint against medical college in your complaint.
I have
Why?
mentioned. I have
That is
mentioned.
also
I have
suspicious.
mentioned. Yes, I have mentioned. I am not saying that I have not mentioned, but my case is,
Anyway,
had it
No
been the
proceeding
case
was
that we
initiated
have
against them.
written that my son is suffering from COVID, my fate would have been otherwise.
or maybe they because they are more vulnerable being a private hospital
Not
because
that
they are
my
state entities, so you are afraid to.
No, not
Medical
that.
throughout the day, we were before medical college, you were before Sagar Datta, you were before ESI or whoever, and before them you were for half an hour. And because they write COVID, the others say that sacrosanct you have COVID, and I don't admit, and you don't lodge a complaint even. Mr. Chatterjee, it's a bit doubtful. I am expressing my mind.
I bow down, my lord, but
It
my
affair
health
now.
regulatory commission heard them also.
Anyway, let them file their report. If
My
if you are satisfied, I am satisfied.
My lord. I shall
But
try-
Midland, this hospital, what is your name?
My name is Midland Nursing Home.
This Midland cannot
Nursing home.
solely be liable, Mr. Whoever they are.
I am not at all liable. I can satisfy Lordship.
Even maybe
May I make a prayer, my lord?
He's
Lordship?
also liable.
Lordship.
What?
No, you are wanting me. I have a soft,
Consider
soft
that.
target to you.
Yes, call.
I am very.
Not at all.
I have a soft target.
Pass over matter, item
One
9.
prayer I am making. Lordship had fixed you on 25th. Would your Lordship kindly fix it on 26th? I have a personal problem on 25th. Well, kindly fix it on 26th. Very next day. 26th.
Every matter, if when I fix the matter, no, let it be on 25th.
On
Come,
25th,
come.
no, I have very.
Whatever. Come on that.
I will be out of station.
No,
my
Mr.
lord.
Bhattacharya, come on that.
I can
Next matter,
come on
please.
that day. My
No.
lord. My Lordship will kindly.
No, in every matter, I cannot accommodate counsel.
Lordship is not accommodating me, my lord. I am that day.
You have said that I am not accommodating you. It will be on 25th.
I
Call on the next matter 9. Who is appearing? Yes.
Item 9.
There is an interim order.
Mr. Bhattacharya is appearing, leading you.
He's reading me.
If he has not yet come, then what should I do? Take up the matter or relegate it to some other day? But it cannot be under the upgraded matter list now.
Now, Miller, there is an interim order.
Yes.
Miller, my junior filed an application for early hearing. My lord was kind enough to grant permission. That's why the matter is at the top. Miller, there is a
My lord deems fit, I can start.
policy matter. The interim order is there. Lordship kindly, till date, I have not been able to make my submission. My learned friend is
Very well, then I'll take it up tomorrow.
Lordship. ঠিক আছে?
Not today করে রেখে দাও, কালকে থাকবে এই list.
Then I request my learned friend kindly, please complete this.
No, your learned friend is ready to start, but I don't want to hear it piecemeal. He will half argue. The next half will be argued by Mr. Bhattacharya. He'll repeat again whatever your learned friend has said. I don't want that. If tomorrow Mr. Bhattacharya is not available, he will start and end. Yes.
Item 13.
Yes, please.
My lord, I am for the bank. Right. My lord, on the last
status.
You are for the state.
My lord, may I permit to submit? My lord, on last occasion, a direction was upon me to file compliance report. Being
Yes.
a disbursement authority, we just get the sanction order from the AG Bengal, the sanctioning authority. And total amount for processing is 9,22,383. My lord, in process. So, my lord, I am seeking.
So this is for family pension.
Yes, my lord.
You are the employee of the state.
Wife of the employee.
Yes. I'm sorry.
Area family pension was due, my lord.
After filing the.
Bank is, you are for the bank.
I am for the bank.
You are not the disbursing authority.
Yes, my lord. I am the disbursing authority. There the sanction authority is. As
The sanction has been given now.
Sanction has been given, but we.
So how soon can you disburse?
My lord, end of this month, the amount will be disbursed.
Fair enough.
This is in process.
Learned counsel.
Within 31st,
I'll record that. I'll put it on a date after that and
Yes, I am great.
thank you.
Hello, I am acting for the Office of the Principal Accountant General. We have
Right.
already issued the authority. Madam.
You have already
Yes.
sanctioned. Learned counsel for the bank files a compliance report, indicating that the sanction order for disbursal of the additional amount of arrears to the petitioner has already reached the respondent bank, and the bank is agreeable to disburse the relevant amount to the petitioner by the end of this month. Full stop. Hence, the matter, let the matter be listed on September 5, 2023 at the fairly at the top of the list for passing final orders.
Okay.
Full stop. The compliance report filed today be kept on record. Thank you. এটা উপর দিয়ে একদম উপর দিকে দিন।
I'm good.
Thank you.
Fixed matter. Item 14.
Yes, Mr. Attu.
Lordship has heard Mr. Chaudhary, my lord. This was, my lord, the challenge to, my lord, the issuance of the lookout circular.
Oh.
And Mr. Bhattacharya, Mr. Bilodal Bhattacharya was representing, my lord, two of the respondents and Mr. Abhishek Go, because there were two originating agencies and they were really required to be heard today.
Mr. Guha and Mr. Dotto.
Mr. Bilodal
You.
Bhattacharya.
Was- Who is respondent 3?
Bank of India, man.
So you are also one of the originators.
No, I am not the originator. Bank of Baroda and, my lord, SFIO were the, my lord, two originators. And Lordship was, my lord, Mr. Chaudhary had placed those, my lord, judgments in Vishamba Saran matter. Lordship has possibly taken note of, my lord, those
Yes,
judgments.
Judgments you handed over also.
Yes, yes.
Yes,
we
it's
had.
already there.
So, my lord, we had made our submissions. It was really for the Bank of Baroda and Mr. Bhattacharya to.
You are Baroda.
I am for this 101, 6 and 7, my lord. I'm led by Mr. Bhattacharya.
You are for the SFIO.
Yes, sir. But led by Mr. Bhattacharya.
Yes, what is your argument?
In last occasion, Lordship was pleased to direct us to file the LOC. Lookout circular.
No,
Copy
not
of
the
the
lookout
LOC.
circle, the request for filing there.
Request.
Where is that?
In a line with Mr. Bhattacharya, my lord.
Mr. Bhattacharya is
I
the
have a
counsel
copy.
in the matter. So he is carrying the LOC, the request also.
No,
You
no.
are also to file the request for.
Yes, Your Lordship, I have been led by Mr. Abhishek Go. He is stuck with some another matter in different courtroom. Your Lordship, kindly keep it at 2 p.m. He will be there, Your Lordship.
2 PM কিছু fixed আছে? নেই তো? I'll keep it at 2.
Very well.
2.
Mr. Bhattacharya, 1 minute.
But then Mr. Guha won't be there again, my lord.
2 PM. I'll take it up at 2.
Great, Your Lordship.
Please come prepared with your requests.
Yes, Your Lordship.
Not request for adjournment. Request for LOC. Next.
Upgraded matter. Item 15.
My lord, I appear for the petitioner, my lord, in this matter. 2 p.m. right?
2 p.m.
He conveniently comes now. He knows that the matter has been called on.
No, no, but the next matter in court 1 was mine, so I was coming from
So
there.
come back at 2 in a more free mind and.
But it may be your lordship's pleasure, my lord, to take it up now, my lord. From 2:30, my lord, the contempt matters.
You'll be released before that.
Great.
Maybe I'll pass the order before that.
I'll be there.
No, not that, but I'll release you at least before 2:30.
My lord, I appear for the petitioner in this matter. I had mentioned this matter and lordship was kind enough to upgrade it.
15 also.
15.
Yes.
Last Monday, I got a rejection. So, my lord, it's balanced now. My lord, kindly comes to page 73. My lord, that
For
is.
the other side.
My lord, I have given notice, my lord. While mentioning also, my lord, I gave notice. They had received it.
Very well, yes.
They copied it.
Yes, yes, Mr. Oil Manager. State is there, WBIT.
State is there. It's
But
really,
it's-
my lord, for disbursement of, my lord, industrial promotional assistance under, my lord, 2000 scheme. My lord, the rejection order, my lord, proceeds on the premise that they had the, my lord, the grounds of rejection I would demonstrate is really under the, my lord, 2004
State is not appearing in so many matters from the morning. And one matter state appeared and I rebuked so much that he will not appear again.
My lord, if this lordship
The
has
learned
to
counsel
hear-
was, he thrice said, okay, I okayed the okay for the first 2 instances.
My lord,
For the third instance, I rebuked him. And he was handing up the note. I mean, it was his personal note probably. I recorded that in the order as a report, quote unquote. So now probably the state would go unrepresented. before.
States.
Anyway, it's easier for me to pass this.
But
Unless
but again, my lord, the ground.
if it's a revenue, if there is a revenue repercussion on the state, I'll be cautious
It
because
would
my
be-
money is
it would
also.
be Because my lord, my prayer is ultimate prayer is my lord disbursement of my lord industrial promotional assistance. My lord, the rejection order I can show my lord that the rejection order.
You argue your case. What can we do if the state does not, if it chooses not to appear? You move your matter.
Very well, my lord.
We cannot wait in every matter for the state. to
Very well. My lord. Kindly comes to my lord impugned order. I show your lordship the scheme first, and then I'll come back to the order, my lord. My lord, the scheme is of my lord 2000. My lord, kindly comes to page 78 where the scheme starts. The relevant portion is my lord, page 84, lordship may take first the definition of a mega unit. I am a mega unit, my lord. I had, my lord, started, my lord, a plant. Initially, my lord, the idea was to start the plant at, my lord, Shakrail, Howrah. It's a, my lord, cement manufacturing unit. But then, my lord, I shifted it to, my lord, Farakka. Now, I had, my lord, so far as the, my lord, setting up of the plant is concerned, there is no dispute. I am entitled to, my lord, fixed capital investments under the scheme. My lord, I have satisfied the ingredients of the scheme, and my lord, there is an eligibility certificate. And in terms of that, my lord, when I applied, my lord, it's really, my lord, for return of, my lord, the VAT paid for the previous year, 75% of that amount I get, my lord, after, my lord, the Department of Commercial Tax, my Directorate of Commercial Tax certifies. And I have, my lord, in terms of this scheme, also, my lord, received part of the, my lord, disbursements in the form of IPA. Now, my lord, kindly takes page 84, Roman 13 first. This is, my lord, the definition of mega unit. It means an eligible unit of special characteristics set up on or after the 1st January 2000 with investment exceeding 250 crores, 25 crores with effect from 1st July 2001. And the only other definition I bother your lordship with is at page 85, my lord, Roman 20, fixed capital investment. My lord, at the foot of the page, my lord, page 85. Fixed capital investment means investment made in land, building, plant and machinery and equipment installed for pollution control measures of the approved project of the eligible unit on or after the 1st April 99, subject to other conditions laid down in paragraph 6 of the 2000 scheme. So, my lord, this expression land and building is no longer there in the scheme subsequent to 2000. My lord, from 2004, there were other, my lord, schemes. This expression, whether it would, my lord, include the investments made in land and building, that's conspicuously absent in the other schemes. Now, my lord, kindly takes the investment which or the subsidy which I am entitled to, my lord, receive as per the scheme. It's,
This
my lord,
scheme is
mentioned.
still on. This scheme is still on.
As on date, my lord, it is not there. My entitlement is for a
Yes, please.
period when the scheme was on.
Very good. Yes.
My lord, page 90, my lord, the definition of state capital investment subsidy. My lord, it says an eligible unit located in Group B area set up in the state on or after 1st January will be entitled to state capital investment subsidy at 15% of the fixed capital investment subject to a limit of 150 lakhs. And after that, my lord, clause 9, lordship sees interest subsidy. These are the various forms of subsidy which a, my lord, eligible unit is entitled to receive in terms of the scheme. My lord, turns the page 91, waiver of electricity duty, employment generation subsidy, all this. Now, my lord, for the petitioner, there is a special package. My lord, before I take your lordship to that package, my lord, I must show your lordship the relevant clause with
State, but not in this matter, my lord. If I may take the number, I will communicate that. So
He's
that
the sole crusader actually. From the morning, he's trying his level best.
I can come back otherwise.
Perhaps one of the states.
Mr. Banerjee is, my lord, leading me, my lord, in this
Yes.
matter.
Well, perhaps one of the states, there should be at least someone, at least to their knowledge, the matter should be heard because it's a question
Exactly.
of
Yes.
having that incentive under the scheme, and quite naturally, they're not very keen on
Are we done?
There may not be an incentive in this matter for the state.
disbursing any incentive. I'm sorry, my lord.
that case,
There may not be any incentive for the state in this matter.
Yes.
As the thing goes.
Yes.
What is your full name, please?
Devopriya Chatterjee.
So I can regularize your appointment to take it. You go through the matter, come back when? Tomorrow? Day after?
Day after.
Day after tomorrow, I can keep it day after tomorrow.
Only that, my lord, if it retains its position in the list, my lord, since I had
It's appearing
mentioned
under
about-
some heading, whichever, some of the,
upgraded it.
either of the headings, yes.
Upgraded, my lord.
Your Mr. I'm sorry,
Devopriyo Chatterjee.
Devopriyo Chatterjee. Although Mr. Devopriyo Chatterjee is on the state panel, comma, he has not been engaged in the present matter, but is present in court, full stop. Since the matter was fixed fairly at the top of the list in view of the urgency involved, comma, and none appears for the state when the matter is called on for hearing, comma, the state shall regularize the appointment of Mr. Chatterjee as learned counsel to represent the respondents in the present matter. Full stop. In order to enable the respondent to properly contest the matter, comma, the same is adjourned till August 24, 2023, when it will be listed under the same heading. Or it will keep position. It will
Grateful,
return.
I'm grateful. I'll give him a copy, my lord, of the.
Please give Mr. Chatterjee a copy and tell him his points also.
Yes. Next.
State has not been
heard.
Item 16.
I'm told the other matter which my lord had also similar matter.
Dalmia Cements. Lordship had, my lord, passed an order directing, my lord, payment of, my lord, IPF around 160 or 180 crores. So they have preferred now appeal. That state was not heard.
Yes, that is the difficulty.
My lord, I beg to appear on behalf of the petitioners.
Oh, not the
16.
state, yes. Right.
State affair.
No, it is 16.
No, it is 16.
For the state? No. You'll have to put up an invitation for the state.
But I have even.
Are they boycotting this court or the entire high court? Nobody is appearing for the state from the morning. Apart from Mr. Chatterjee, who was appearing.
2022 writ petition, my lord. After, my lord,
I think give a notice because that may be the only ground for the state even. I mean, that nobody appears for the state when the matter was called on. He's the sole crusader, lone crusader, I must say. Not sole crusader, lone crusader.
My lord, if
From the morning only he is there. And one other person was also there, but as good as not being there. Give another notice to the state in writing. I'll put it when? Tomorrow, day after tomorrow, whenever.
Day after tomorrow.
What is the matter about?
My lord, this is, my lord, second round of writ petition, praying for a direction upon the registering authority to hand up my registered deed, which they have kept under their custody on the pretext of pendency of a case, which got, my lord, disposed of.
So where is the document relating disposal of that case?
Yes,
Have you annexed?
my lord, kindly come to page 71. They have, my lord, in the earlier petition, they have taken a stand. There is a police case pending, and that case, my lord, got disposed of.
Police case?
Yes, my lord. Police case was pending.
What is the deed about?
My lord, kindly comes to it is, my lord, deed of conveyance, my lord.
Deed of conveyance. What is the nexus with the police case?
My lord, kindly come to page 64.
Police case regarding forgery regarding that deed.
That, my lord, we are not party to that case, my lord. We are not party to that case. My lord, kindly come to page 64, the earlier order of the.
No, I don't understand. It was you applied for registration of that.
My lord, we have got registration. Now, my lord, IGR receipt has been given, but we have not been handed over with the original deed of conveyance from
Nothing has been communicated to you regarding deficiency in court fee in
no,
stamp or.
My lord, I have been issued the IGR receipt.
IGR has been.
IGR has been issued. My lord, kindly come to page 64.
64, yes.
This is the one of the earlier writ court order. 20th June 2019, my lord.
Yes.
Not the third paragraph. The respondent number 5 in his affidavit in opposition to the writ petition has disclosed that those deeds are involved in this pending Ashok Nagar PS case number 184 dated June 7, 2007 under section so and so of the Indian Penal Code and section 18 of the Registration Act and are vital piece of evidence in the criminal case. That being the position, petitioner are not entitled to get back those deeds at this stage. So, my lord, thereafter, my lord, I have, my lord, obtained the court's order and the case information report from wherein, my lord, it is appearing the case got disposed of way back in 2013, my lord.
Where is that? That is page 71.
Page 71, my lord. And my lord, thereafter, my lord, I have also obtained this certified copy of the original order of the my lord court.
Did the respondents appear at any stage in this matter?
No, my lord, this is the first time, my lord, it is being moved after 2022.
Oh, then you give another notice.
My lord.
None appears for the respondents at the time of call, full stop. Since the matter is appearing after quite a long time, subsequent to filing of the same, comma, the petitioner shall serve, you have already served copies of the writ petition.
Yes, my lord, I have, even my lord, before my lord mentioning,
File the writ, yes, that.
before my lord mentioning also, I have served them, my lord.
Serve another notice on the respondents indicating that the matter shall be listed under the same heading on September 5, 2023, when the petitioner shall file an affidavit of service to that effect. You will give only a notice now. No copy of the writ petition. It will appear on that 5th of September under the same heading.
I am grateful.
Our affidavit of service filed today be kept on record. Thank you.
17.
May I please, your lordship?
Yes, please.
Lordship, petitioner bank is aggrieved because of non-disposal of section 14 application, which is pending since 13th of May 2022. If your lordship kindly straightway come to page number 24 of your lordship's brief.
Have you stated anywhere there is no order of injunction or stay from any court? In these writ petitions, please just mention one line that there is no subsisting order of stay or whatever.
Lordship, shall I file a supplementary affidavit to that effect? Is it required? Because
No, if you have the instruction in this case, I can record your instruction.
Yes, lordship, kindly record my submission.
Very well. The innocuous prayer made in the writ petition is for early disposal of an application under section 14 of the SARFAESI Act 2002. Full stop. Despite service, none appears for the respondents. The affidavit of service filed today in court be kept on record. Full stop. On query on court and upon instruction, learned counsel for the petitioner bank submits that there is no subsisting order, restraint order debarring the magistrate from deciding the application under section 14 as of today. Full stop. Next para. Since the petitioner is justified in submitting that the application of the petitioner bank is pending for quite a long time, comma, much longer than the statutory outer limit of 60 days, comma, WPA 20545 of 2022 is allowed, comma, thereby directing the respondent number 2, that is the district magistrate, district North 24 Paraganas, to dispose of the application under section 14 of the SARFAESI Act 2002 pending at the behest of the bank against the private respondents at the earliest, comma, positively within 3 weeks from the date of communication of this order to respondent number 2. Full stop. The parties shall act on a server copy of this order without insisting upon prior production of a certified copy. Thank you. It to Hathi diye.
Grateful, lordship.
Thank you.
18.
Yes, please.
I am appearing on behalf of the petitioner.
Right.
The affidavit of service.
What does the envelope
The
say?
private respondent has not been served. My lord.
Not served properly?
Served properly, my lord, but she didn't accept it, I think so.
If it is refused, it is good service. Unclaimed, yes. What is the matter?
My lord, the matter is revolving around the Senior Citizen Act, my lord. My petitioner is a senior citizen. He, along with his wife, have been thrown out from their own residence by daughter-in-law, who is the private respondent, my lord. And my lord, the property is in custody of the daughter-in-law at the moment, and I am rotating, my lord, outside, and I am staying continuously in my relative's
Son
house.
is also living with her.
Son is not living with her. She is living only alone.
No,
My lord, the
son
son is living elsewhere. My son is not staying with me. He is living elsewhere.
So son, his relation with his wife is estranged.
Yes, my lord.
Anyway, yes, then?
My lord, I have moved against this. I have moved a petition before the SDO. My lord, the SDO did not even record my submission. My lord, in page number 16, my lord, the order has been passed. Page number 16, the order has been passed, but my lord, my grievances have not at all been recorded. It has been said to move before the
it is civil in nature, so that I can move before the civil court. But my lord, I have been thrown out from my own residence by daughter-in-law after grave torture, my lord.
Where is your application? You have not annexed it. What was the previous order of a coordinate bench?
My lord, after this, yes, my lord, I'm coming to that. My lord, after moving, after getting this order, I have preferred an appeal before the DM. My lord, as per section 16, subsection 6, the best endeavor should be done by the DM to pass an order within a month. My lord, it was delaying and I am staying outside. So for expeditious disposal of the application, I have moved that writ petition, my lord.
After that, that has been decided.
That has been decided and the SD order was upheld. But the thing is, my grievance have been recorded in that appeal order, my lord. It is page number 24. That
So
I have been.
now you have challenged that appeal basically.
Appeal.
The appellate order.
Appellate order.
Let me
my
see
lord.
that. Yes. Where is your application, please? Have you got a copy of your application before the first authority?
No, my lord, I haven't annexed.
We have to look into it. Otherwise, how can you decide whether they are correct or not? They are saying it's a civil dispute. Whether you have raised a purely civil dispute, we have to see the application for that.
My lord, I can, my lord. I will submit the
You
application.
got a copy with you?
At the moment, no, my lord. At
Then
the moment,
that is the basic thing which I have to annex.
at the moment, no. My lord, that has been raised in the appeal order, my lord. In the appeal order, it has been addressed.
Let us see that.
Page number 24, my lord.
Under which provision of the act are you coming?
Section 4.
Just
my
show
lord,
me,
the appeal-
show me the act once. Yes, thank you. Section
16.
16 is appeal. No, the original application was filed under which provision?
Section 4.
You say it's your property or his property?
My property.
So you filed an eviction suit simpliciter. Why shouldn't it be heard before the civil court?
My lord, civil court is barred by jurisdiction, my lord. As per section 27 of this act, civil court is barred by jurisdiction.
No. Civil court is barred by jurisdiction if this authority has the power to adjudicate.
Yes, my
Now
lord.
here it's a simpliciter suit for suit for eviction.
My lord, may I submit, my lord, one judgment, reported judgment of
Yes,
a coordinate bench.
Yes.
It is reported judgment, my lord. It is AIR 2022 Calcutta 192.
Yes.
My lord, my lord, para 9. My lord, para 9.
Yes.
Page number 6 of 7. However, the right of a senior citizen to exclusively reside in his own house.
Para 9.
Para 9. Page number 6.
Yes.
My lord, however, the right of the senior citizen to exclusively reside in his own house must be
That is the
viewed.
para 9 of a different judgment. It has been quoted here. It's actually
Yes.
the para 13 of
Yes,
that
my lord.
judgment. Anyway, let us read. However, the right of senior citizen.
Yes, viewed from the prism of Article 21 of the Constitution of India. My lord, to compel a senior citizen to approach either a civil court, the jurisdiction which is anyway barred by Section 27 of this Act, or to take recourse to a special statute like 2007 Act would in most cases be extremely onerous and painful for a person in the sunset days of life. My lord, the court is therefore of the view that the principle of alternative.
Yes, this is binding on me. I'll rely on this. You are right.
And my lord, another paragraph, my lord,
Yes.
the paragraph number 14, my lord. In view of the above decision of the court, which is in consonance of the previous decision of a Supreme Court, which is 2021 Supreme Court, my lord, I could not bring the printout of that because of my printer was not working
No
properly.
difficulty. Yes.
Read court under 226 has the jurisdiction to evict sons and daughter-in-law from the residence of senior citizens, my lord. My lord, one of my prayer is eviction of daughter-in-law and reinstatement of my
Eviction from here I won't grant. I'll remand the matter to the authorities. I'll set aside the order. I'll say, let me just go through the judgment once.
My lord, may I submit, my lord, para 17?
Yes.
Para 17, my lord. In respect of a discomfort expressed by a senior citizen towards his children, a single complaint is good enough evidence. Further, there is no disputed question of the fact in the instant case that is the house admittedly belongs to the father of the writ petition. Here it is a purchased property by the writ petition.
The private respondent filed her objection to your application, or it was set aside at the dismissed at the outset.
She has never come up.
So how can you say in your case it is an admitted position?
My lord, I have
admitted position can only be when somebody files an objection.
Yes, my lord.
She did not get that opportunity because at the outset your application was turned down.
She was served every time, my lord. She is not receiving the same. Be it SDO code, be it the appeal order.
No, I'm not at one with this finding. In this case, this is not applicable. In your case, I can at best remand it to the trial court.
My lord, at least that they should try on the basis of this point, my lord.
I don't even know whether on facts I haven't taken evidence even to know whether she's your daughter-in-law or not, or she's the owner of the property or not. I don't know that.
My lord,
unless I take evidence, at least prima facie evidence, I cannot decide that. And writ court is not the right forum for that.
But it is even my lord, it is mentioned in one judgment of the Supreme Court, my lord.
Yes.
I can quote the judgment.
The writ court will take evidence.
My lord, particularly for this one, my lord.
You are very well prepared. Very good. Yes.
My lord,
No, please cite that.
2021 SC 170.
Have you got an extra copy of that, or should I?
No, my lord, it is extra copy. It is your lordship's copy, my lord.
Hand
But,
up?
my lord,
Yes.
that Supreme Court judgment, I could not bring the printout, my lord. I could not bring the printout. I can
I'll
give
try
it.
to find it out here. Yes.
I
What
can
is it?
give it.
What is the
AIR
judgment?
2021 SC 177.
Give me some time.
My lord. My lord, 2020 SCC online.
No, AIR, give the AIR.
AIR 2021 SC 177.
This is for what proposition?
My lord,
it's a longest judgment.
my lord, it is the longest judgment because, my lord, even if we consider that the wife has filed a domestic violence case, because her right is protected by Domestic Violence Act. And my lord, the senior citizen's right is protected under this act, my lord. If these two acts come in collision.
That is not your case here.
No, my lord, I'm just, even in case, my lord, her right, my lord, this act will supersede, my lord. This is the proposition.
There is no
of this
doubt
judgment.
on that. Here, the courts below have not held that this act will not supersede, or I am also not on that. That question has not come up yet.
My lord, Because my lord, the eviction of daughter-in-law, the question of eviction of daughter-in-law can be done because even if she
No, I'll
she's-
go by this that the court cannot relegate it to a civil court simpliciter because that remedy is available. That has been held by the Supreme Court as well as by the coordinate bench. Whether this act will override the other act, that question has not even cropped up in this case.
No, my lord, the point of eviction, I was just talking, submitting the point of eviction, because my lord, even if.
No, that is not an issue here. As yet.
My lord, I am roaming outside throughout, my lord, along with my wife.
Act autonomy. Despite attempt to serve the intended service on the private respondent has failed since the envelope has returned with the endorsement within double inverted unclaimed, comma, which tantamounts to good service. For some next para, the petitioner has challenged an order whereby both the forums below, comma, lastly, the appellate authority within bracket district magistrate, bracket closed, have rejected the application of the petitioner, comma, who is a senior citizen and allegedly the owner of the property concerned, comma, under Section 4 of the Maintenance and Welfare of Parents and Senior Citizens Act, comma, 2007. Full stop. Both the courts below have proceeded on the sole premise that the remedy of the petitioner lies before a civil court and, comma, as such, comma, have dismissed the petitioner's application at the threshold. Full stop. Next para. Learned counsel for the petitioner places reliance on a coordinate bench judgment reported at AIR 2022 Calcutta 192, comma, inter alia for the proposition that the right of a senior citizen to exclusively reside in his own house must be viewed from the prism of Article 21 of the Constitution of India. Pushed up to compel a senior citizen to approach either a civil court within bracket the jurisdiction of which is anyway barred under Section 27 of the 2007 Act, bracket closed, or take recourse to a special statute like the 2007 Act would in most cases be extremely onerous and painful for a person in the sunset days of life. Full stop. The court observed that the court is therefore of the view that the principle of alternative remedy cannot be strictly applied to senior citizens and a writ court must come to the aid of a senior citizen in a given case. Full stop. Next para. The court, comma, while deciding the issue, comma, considered the question of shared household under the Domestic Violence Act 2005 and had observed in the facts of the case that in respect of a discomfort expressed by a senior citizen towards his children, comma, a single complaint is good enough evidence. Full stop. Further, comma, there are no disputed questions of fact in the said case, that is, that the house admittedly belonged to the father of the writ petitioner. Full stop. There was a decree for divorce, comma, albeit ex parte. Full stop. In such circumstances, comma, the writ court proceeded to grant an eviction order. Full stop. Next para. Learned counsel also seeks to submit that in the circumstances of the present case, comma, the petitioner is the exclusive owner of the property in concerned and has been ousted by his daughter-in-law, that is the private respondent, unlawfully. Full stop. Next para. Although the parameters of the judgment cited before this court are somewhat different, comma, inasmuch as the writ court itself, comma, in the said case, comma, directed eviction without relegating the petitioner to any competent forum under any statute, comma, the principle therein was that a senior citizen cannot be compelled to run from pillar to post, comma, having complained of being ousted from his own property by his children stroke in-laws. Full stop, next para. A perusal of the definitions as given in section 2 of the 2007 Act shows that relative means any legal heir of the childless senior citizen who is not a minor and is in possession of or would inherit his property after his death. But your daughter-in-law does not satisfy this.
Which one, my lord?
I'm sorry, দাঁড়াও এই পর্যন্ত থাক বস। Your daughter-in-law is not your legal heir.
Space succession is maybe.
No question of space succession. Is your son is alive? Your son is there, fully there. You are alive.
Well, in between them, there is a matrimonial dispute is going on.
So you are not a biological, adoptive, or stepfather or stepmother.
No, my lord, I am the father-in-law.
Father-in-law does not fall within the purview of parent in this act. I'm sorry. I mean, একটু দাও ওনাকে ফেরত দাও। Satisfy me on that. I'm sorry, extremely sorry, because I was going to pass an order. There are two distinctions. One is Justice Mantha held that writ court itself can pass an order. Respectfully, I differ from that in this case at least. There is nothing on record. There it was an admitted position and Justice Mantha directed, he may have directed. But that cannot be the scenario in every case. Then writ court should have started directing eviction in every case. That is not possible
My lord,
without
the
facts.
act is, my lord, the parents and senior citizens. My lord, being a senior citizen, I have been
No,
evicted by
as
the
a senior citizen, if your argument is stretched to the limit, then a senior citizen, just by being a senior citizen, I can file an eviction suit against anybody. Somebody who I feel is like my son, even them.
My lord, here, my lord, the heirs and the successors, the
They have
definition
been
have been
defined in the
extended,
act.
my lord.
Yes.
Have been
Read
extended.
the definition, please.
Parents means father or mother, whether biological, adoptive, or stepfather or stepmother, as the case may be, whether or not the father or mother is a senior citizen.
Here you are not a father or mother of your daughter-in-law.
But I am a senior citizen, my lord, which is covered by this act.
Oh, any senior citizen and every senior citizen has to be against his children. Just let us come to, you have read parent.
I have read parent.
See your, who are your legal heirs?
My lord, legal heirs, my lord, anybody who may succeed.
This has to be
not being my
either a
son and
senior
daughter.
citizen has to file against his legal heir or a parent.
But in both way, my lord, this act is covering, squarely covering the parents and senior citizen as well.
But she has to be your legal heir.
My lord, that is in case of parents, my lord. Here, my lord, as a senior citizen, I have been evicted
If
by
it's a parent,
daughter-in-law.
if I am a parent, then there is no question of legal heir. You are my children.
My lord.
Otherwise, legal heir. It has to be either children or other legal heirs.
My lord. My lord,
you cannot file a senior citizen just by being a senior citizen, cannot go and file a suit against anybody.
My lord, here the name of the act is, my lord, the maintenance and welfare of parents and senior
That cannot be broadened just like anything. I mean,
my lord, here welfare, my lord, means provision of food, healthcare, recreation, and other amenities necessary for the senior citizen, my lord.
This has to be against either your child or your legal heir.
My lord, this judgment is also, my lord, against that as a senior citizen, because it is also against the daughter-in-law.
No, I'll have to affirm it. I'll have to give you legal.
Yes, my lord, this judgment is
Try to satisfy me because I'm going against you. I'm giving you opportunity.
My lord,
Satisfy me right now.
My
Yes.
lord, here, my lord, it is against daughter-in-law. My lord, the judgment of Honorable Justice Rajshekhar Mantha.
Do you have another extra copy of the Senior Citizen Act? আমার আনা ছিল দেখো না, Maintenance Senior Citizen Act আনা ছিল, এদিকে না থাকলে ওদিকে থাকবে, ওদিকে দেখো তো।
My lord, on the first page of the judgment, my lord, it is said that the applicant daughter-in-law has not claimed any right of residence, nor she has alleged violence.
This is not under this act. This is the writ court itself is granting.
My lord, it is under.
Please read paragraph, the paragraph you read.
Yes, my lord, the protection of. Yes,
Here
my lord,
the
it
writ
is-
court itself said I'll grant because under Article 21 there is a right to life and right to reside. Therefore, I'll grant eviction because a
This is
parent
the
has come.
Senior Citizens Under Act, my lord. Senior.
That
citizen-
act has not been resorted to in this case.
My lord, it is,
Please
my lord.
check up.
My lord, it is resorted, my lord.
Read the relevant paragraph.
My lord, page number 5.
No, the paragraph you placed, please read that out. Article 21 paragraph. That contains the crux of the
My lord.
adjudication. No, I'm sorry, the courts were correct. You do not come within definition as per section 4 also.
My lord, in this judgment, my lord.
Yes,
this
I'll
act
refer
has
to the
been taken in
judgment.
point number 9, my lord.
Yes.
It is said that however the right of, again, my lord, I'm reading that paragraph.
I'll quote entire paragraph 9.
Here, my lord, section
No.
27 of this act 2007 has been mentioned. Where
Yes. ওটা কেটে দাও। Learned counsel for the petitioner submits আচ্ছা না প্রথম প্যারাগ্রাফ যেটা ছিল যে despite attempt to serve for envelope has come back ওটা পর্যন্ত থাকো তারপর থেকে the petitioner has challenged orders of both the forums below under the Maintenance and Welfare of Parents and Senior Citizens Act 2007. First up, both the forums turned down the application of the petitioner for eviction of his daughter-in-law, comma, the private respondent, comma, under the 2007 Act, on the ground that the dispute was civil in nature and hence outside the purview of the said forum. First up, learned counsel for the petitioner cites a coordinate bench judgment reported at AIR 2022 Calcutta 192, bracketed নামটা দিয়ে দিও, for the proposition that a senior citizen that in respect of a discomfort expressed by a senior citizen towards his children, comma, a single complaint is good enough evidence and eviction ought to be granted. Full stop. Next para, learned counsel further submits that since the 2007 Act applies not only to parents but also to senior citizens, comma, the daughter-in-law has also to be counted as a relative within the contemplation of the Act for the purpose of seeking maintenance in the form of residence. Full stop. Next para. It is further contended that the Act itself provides for maintenance, comma, which includes residence, and comma, as such, comma, the petitioner is entitled to the relief as sought before the forums below. Full stop. Learned counsel for the petitioner places specific reliance on paragraph 9. Now, on paragraph 13 of the cited judgment, comma, which also quotes inter alia, comma, paragraph 9 of the judgment of Ramapada Bosak versus State of West Bengal and others reported at 2021 SCC Online Cal 2161. Full stop. Next para. Insofar as the cited judgment is concerned, comma, the same pertains to a relief sought for eviction by a senior citizen before the writ court. Full stop. The court, comma, while approving of the judgment delivered in Ramapada Bosak Supra, comma, in paragraph number 13 of the said judgment, comma, refers to paragraph 9 of Ramapodo Supra, where it was observed as follows, colon দিয়ে এই প্যারা 9টা পুরোটা কোট করে দেবে, যেটা উনি কোট করে প্যারাগ্রাফ 9টা। Next para. Insofar as the said observation is concerned, comma, it pertains to the right of a senior citizen to exclusively reside in his own house, comma, which according to the court must be viewed from the prism of Article 21 of the Constitution of India. Full stop. Next para. In the said case, comma, it was observed that a senior citizen cannot be compelled to approach a civil court or take recourse to a special statute like the 2007 Act, comma, which would in most cases be extremely onerous and painful for a person in the sunset days of life. Full stop. Next para. The principle of alternative remedy, comma, it was held, comma, cannot be strictly applied to senior citizens, and a writ court must come to the aid of a senior citizen in a given case. Full stop. Next para. In paragraph 17 of the cited judgment, comma, the learned single judge observed in the facts of the case that in respect of a discomfort expressed by a senior citizen towards his children, comma, a single complaint is good enough evidence. Full stop. Further, comma, in the said case, comma, there were no disputed questions of fact, comma, that is, comma, the house admittedly belonged to the father of the writ petitioner therein. Full stop. There was a decree for divorce in that matter, comma, albeit ex parte. Full stop. Admittedly, in the said case, comma, the son had already taken up separate residence before the writ petition was filed. Full stop. The applicant daughter-in-law therein had not claimed any right of residence, nor had she alleged violence against her father-in-law, stroke writ petitioner or husband. Full stop. The bad blood between the applicant daughter-in-law on one side and her husband and father-in-law on the other was also recorded. Full stop. Next para. However, comma, in the instant case, comma, there is nothing on record to show that the respondent has submitted her version before the forums below.
Yes, my lord, it is submitted before the DM,
Where is that?
before in the DM order.
Full stop. Next para. Insofar as the, where is the first forum order, which is the page number?
Page number, my lord, page number 16.
Insofar as the first forum is concerned, comma, the order of the subdivisional officer and tribunal officer is annexed to the present writ petition at page 16 thereof. Full stop. It is recorded there that the petitioner was present and filed hazira and the opposite party was absent. Full stop. The petitioner was heard and considered. Full stop. The petitioner had submitted that his daughter-in-law, the opposite party in the said case, was not vacating his flat and that he is a pensioner and does not want any maintenance from his daughter-in-law or his son. Full stop. He also submitted that he has not gifted his flat at Rajdanga Main Road to anyone. Full stop. It appeared from the submission, comma, it was recorded, comma, that the matter was civil in nature and is not maintainable before the tribunal. Full stop. Accordingly, the case was dismissed, comma, without inviting any pleadings from the respondent. Full stop. Next para. Before the district magistrate,
25 page number,
comma, both parties had appeared and the district magistrate had decided the issues decided the matter as per direction of a coordinate bench. Full stop. Next para. However, comma, it has to be taken note of that the district magistrate is the appellate authority under the statute in question and not the first forum. Full stop. As such, comma, there was no occasion for any pleadings to be filed by the respondent stroke alleged daughter-in-law, comma, before the said forum for the first time. Full stop. The district magistrate, comma, upon recording the submissions and allegations between the parties, comma, affirmed the finding of the subdivisional officer to the extent that the matter was the subject matter of a civil dispute and ought to be heard before a civil court. Full stop. Next para. Hence, comma, as opposed to the cited judgment by the petitioner, comma, in the present case, it cannot be said that any of the allegations made by the writ petitioner was within double inverted, admitted double inverted clause by the private respondent at any point of time. Full stop. Next para. The present challenge is not an original application by the writ petitioner for grant of eviction by the writ court, but a challenge preferred against the concurrent findings of both forums that the matter is not maintainable before the said forums. Full stop. Next para. The writ petitioner, comma, in the present case, comma, has not approached the writ court for the first time, but submitted to the jurisdiction of the competent authority under the 2007 Act by filing an application under Section 4 of the said Act. Full stop. Next para. Section 2 within bracket double inverted. Section 2 within bracket H of the Act defines within double inverted senior citizen to mean any person being a citizen of India, comma, who has attained the age of 60 years or above. Full stop. Parent double inverted has been defined in clause D, small d of section 2 as the father or mother, comma, whether biological, comma, adoptive, or stepfather or stepmother, comma, as the case may be, comma, whether or not the father or the mother is a senior citizen. Full stop. Next para. In section 4 of the Act, comma, subsection 1 provides that a senior citizen, including parent, who is unable to maintain himself from his own earning or property owned by him, comma, shall be entitled to make an application under section 5 in case of niche Roman I, parent or grandparent, comma, against one or more of his children not being a minor, Roman 2 tarpar, a childless senior citizen, comma, against such of his relative referred to in clause small g of section 2 of the Act. Full stop. Next para. Small g of section 2 defines relative to mean any legal heir of the childless senior citizen who is not a minor and is in possession of or would inherit his property after his death. Full stop. Next para. It is conspicuous to mention that in the present case, comma, the writ petitioner has not preferred the application against his son, but his daughter-in-law, comma, who is neither the child of the petitioner nor a relative of the petitioner within the definition of section 2 within bracket small g of the 2007 Act. Full stop. Next para. Upon a consideration of section 4 within bracket 1 of the Act, comma, it is also clear that the petitioner does not fall within the zone of a childless senior citizen against such of his relative referred to in clause section 2 within bracket small g. The eviction proceeding has been filed. Full stop. Next para. The subsequent subsections of section 4 as well as the other sections pertain only to senior citizens, comma, in case they fall within the contemplation of the definitions of section 2 as well as section 4 within bracket 1 of the 2007 Act. Full stop. Next para. Here the writ petitioner specifically invoked the provisions of the 2007 Act, comma, without being competent under the said Act, comma, to maintain the eviction proceeding against his daughter-in-law simpliciter. Full stop. Next para. As such, comma, there is no illegality or irregularity in the decision-making process of the authorities below in observing that the matter pertains to a civil dispute and the said authorities do not have jurisdiction under the 2007 Act to decide the eviction proceeding initiated by the petitioner. Full stop. As such, there is no scope of interference in the present writ petition. Full stop. Accordingly, WPA 2535 of 2023 is dismissed without any orders to cost. Full stop. However, nothing in this order shall preclude the petitioner from instituting a proper eviction suit before a competent civil court, if the petitioner is so entitled in law. Full stop. In case such a proceeding is initiated, the said court shall decide all issues in accordance with law and also adjudicate upon any interim application, if filed by the petitioner in connection with such suit. No address to pass, urgency.
May I have your lordship's kind indulgence to
Sorry,
mention?
sorry, please.
Lordship, may I mention one application that is appearing in item number 99 in your lordship's daily list, but the urgency is that my electricity connection has been disconnected. My lord.
No mentioning.
Under
that.
compelling
Lordship, I know, but
circumstances.
I'm sorry, no.
Circumstances are really.
Yes, under compelling circumstances, I am
No
troubling. My lord, item number 51, my lord, my read may become infructuous, my lord. If your lordship.
No, sorry, not like
Lordship,
this.
if it may be, because the line has been disconnected today.
May it please your lordship.
Yes, sir.
My lord, I beg to appear on behalf of my lord, the Union of India, my lord. I'm also representing my lord, the Bureau of Immigration and the SFIO. Now, my lord, on the last occasion, my lord had directed me, my lord, to produce, my lord, the request, my lord, for opening of the LOC, my lord. But
Banks were to produce. If you produce, it's all right. I directed you to produce. No difficulty, Mr. Bhattacharya, either of you.
no, because I indicated, my lord, that there are two requests, my lord.
Two requests, right?
Two LOCs, basically.
You are for the bank.
One
And-
at the behest of the bank and the other one at the behest of the investigating agency.
You are also appearing for the investigating agency.
The SFIO, yes, my lord. Right. I am for the one, yes.
Please. খুলে দাও, হ্যাঁ। তুমি চোখ বুজে থাকো আমাকে। Yes, they are not to look into it.
This will be a case which will be different on facts. Insofar as all the other cases are concerned, my lord, which were relied upon by my esteemed senior friend. When those matters, my lord, I term it, my lord, while dealing with those matters as lock, stock, barrel, my lord, bank defaulter matters. But here, there are two branches.
Yes.
Insofar as not permitting the petitioners to leave the boundaries of the country is concerned. One is being a lock, stock, barrel defaulter case, my lord. The other one being, my lord, the investigating agency which is investigating into the alleged offences, my lord. On prima facie, my lord, now, my lord, coming to the conclusion, my lord, that there has been fraud, my lord. I am grateful to, my lord, my learned friend for the bank, my lord. He has also, my lord, helped me, my lord, with applications filed before the NCLT, where, my lord, in very clear terms, it should have been indicated, my lord. But I am having it now with me. It has been indicated that prima facie, it is a clear case where fraudulent activities have taken place. So I'll rely on that, my lord. My lord, before that, আমার এগুলো কোথায় নিয়ে গেল? আরে না কালকে কোথায় এগুলো কোথায় এনেছি? এই যে এটা, হ্যাঁ। My lord, kindly, my lord. Thank you. Take pain, my lord, to go through this order.
Give a copy to them also.
I it kindly takes the third page, paragraph 12 and onwards.
Yes.
It is also stated in para 17. Now, this is one of the application at the instance of, my lord, the SFIO.
So why didn't you put it in your opposition?
My lord, this I said, my lord, I'm grateful, my lord, to Mr. Abhishek Guha, my lord.
So they should have put it in their opposition.
No, they could not have, my lord. This is, my lord, at our behest. I do not know why this was not given to me. And I, in fact, my lord, after receiving these orders, my lord, this is the specific question, my lord, that I had asked. That why were these orders not handed over to me?
These orders were passed before issuance of the LOC.
My lord, these orders have been passed, my lord. There was a direction for service. The clients of Mr.
So this was
Chaudhary-
passed before issuance of
No,
the
this
LOC?
is, my lord, in February, my lord.
After that?
This is in February this year.
So
LOC
this
was-
cannot be a ground for issuance of
No, no, my
LOC.
lord.
We are only considering that.
If,
We
my
are
lord-
not saying that this
No,
person is
my lord,
a
my lord kindly appreciates.
Yes.
But the LOC, insofar as the SFIO is concerned, is an incidence of the investigation which has been undertaken. My lord, the investigation is admittedly not under challenge by way of filing the writ application. Here, the writ application was filed where a direction was sought for on the bank authorities not to detain or the petitioners from not being detained in the airport whenever they intend to leave India. So the action of the SFIO, my lord, it was not initially spelled out, my lord, till I appeared with instructions and said that no, there are two LOCs, one at the instance of the SFIO, the other one at the instance of the bank. So, my lord, there is no challenge as such in the writ application, my lord, insofar as, my lord, the action of the SFIO is concerned. My lord, the investigation aspect has not been challenged till date. It would have been another question, my lord, had the investigation been challenged, because, my lord, that central agency, that complications would have arisen then, my lord. So, my lord, I am proceeding on the fact that there is an investigation which has been undertaken by the SFIO, which is unchallenged, in connection with which, my lord, LOC has been issued, my lord, and the apprehension, my lord, is well established, my lord. That is exactly what I was attempting to, my lord, indicate on the first occasion, my lord, when I appeared before your lordship, my lord, with this writ application, my lord, that there is an apprehension, my lord, that they are attempting not to cooperate, my lord, with the investigation and, my lord, leave the territories of India, my lord. Why this question will arise, my lord, I'll have the answer also, my lord, to ask your lordship, my lord, to take pain and come to page 86 of the writ application straight away. I'll demonstrate, my lord, what type of documents are manufactured, my lord, to basically depart from the country. First is, my lord, page 86. These are the documents they relied upon. This is at the instance of one Benny Trading Company Limited, a trading company having its office somewhere in China. The business is metal export-import business. As per various discussions held between us, you are requested to please come to China sometimes in third week of November 22 for taking the metal business. Please let me know your arrival date and venue so that the necessary arrangements can be made. So this is one document. The other document, my lord, the page thereafter, page 87. So a company, my lord, trading in gems, Vitrag Gems Company Limited. Now they address a letter stating that greetings in connection of our discussion regarding water sports items. Please know that Thailand is one of the greatest tourist hub and water sports are of substantial attraction. As a good amount of deliberation is involved, you are requested to plan your visit to Bangkok in the month of November 2022. So, my lord, a company, a concern dealing with gems, my lord, gemstones, they suddenly, my lord, derive interest.
This is on the recreation front for that conference.
Recreation fund, yes.
That may be, Mr. Bhattacharya. Actually, this recreation is an integral part of these business meets nowadays.
I am saying, my lord, no, they say, my lord, that it is about the business pertaining to water sports activities, my lord. So
no, they are not wanting to do business on that.
Regarding
that's a substantial attraction. Come here for that attraction and also do business with us, which should be in gems.
Yes.
Anyway. Yes.
No, but thereafter, I had indicated on the last occasion on receipt of instruction, my lord, one of the other directors, my lord, he has traveled to Nepal. He is in hiding, my lord, and my lord, the SFIO has tried their ways out, my lord, to serve summons upon him, my lord.
So you have you mentioned these in your?
No, my lord, these are all developments, my lord, which, my lord, as
entire submission, if that is beyond the opposition, after opposition,
my lord, this is, my lord, an investigation is ongoing, my lord. My lord, kindly appreciates, my lord.
That is different, Mr. Bhattacharya. Then citing these, you have to file another, request.
So, my lord, I have produced before your lordship, my lord.
And we have to see this request, the present one, only on in the context of the request made by you.
I am
and
not entering into, my lord, the request in so far as
you cannot. I mean, we should not.
Yes. No, I could have, my lord, but in in matters where I appear for the Bureau of Immigration, in these type of matters, my lord, I just appear, I just sit down, orders are passed, because I feel, my lord, I will not oppose for the sake of opposing. When, my lord, the law has been laid down by your lordships already. But here, yes. The Manoj Jain matter, my lord, which was referred to by Mr. Chaudhary, in Manoj Jain matter, I appeared, I had taken the point that, look here, there are involvement of these persons with cheat fund scams, which the CBI and the ED are investigating. But the difference with Manoj Jain's case was, there was no LOC opening request made by any of the investigating agencies. On the contrary, the CBI court, the special court, was approached in Delhi, which had permitted, my lord, travel to that petitioner for a limited purpose. The purpose was they were getting their son admitted, my lord, in somewhere in UK. That was the purpose. But here, my lord, this case, but in all the cases, my lord, which has been cited, my lord, this case, my lord, stands on a different footing. Here, my lord, the investigating agency itself has made the request for opening of the LOC, my lord. And here it is a case where one of the directors is already in hiding, my lord, in Nepal. And we have now taken it up, my lord, with the concerned, my lord, ministry also, my lord. We are
This
trying.
is Mr. Bhattacharya beyond the pleadings.
But this can be, has to be beyond the pleadings, my lord, because this is an ongoing investigation, my lord. My lord, this, my lord, cannot be, my lord, this is a matter of record, my lord, the order that I have produced, my lord. My lord, kindly takes, my lord, paragraph 13, my lord, what has been stated. The order, my lord, of the NCLT.
Yes.
The fraud is established beyond doubt. Advance monies were paid to related party, and then transactions were not concluded and no steps have been taken for recovering the monies. The directors have siphoned off funds of the respondent number 4 and have parked it in another group company. In the circumstances, the respondent number 1 to 3 directors are liable to pay respondent number 4 a sum of rupees 35 crores together with interest. So, my lord, this is, my lord, prima facie, my lord, established.
3.5 crore.
I'm very bad with, my lord, such big figures, my lord. Yes, 3.5 crores. So as on date, my lord, the investigation.
Come good after these matters came.
My lord,
3.5 crore is nothing.
no, it shocks my conscience as a person. I find that public money, my lord, so far as
3.5 crore, that's your problem.
but the bank defaulters, my lord, traveling to foreign lands. I have come across these type of cases, my lord, seen pleadings.
Traveling to foreign land
in business class, my lord.
Why is that bad, Mr. Bhattacharya?
But public money, my
Half a
lord,
chance you would also do the same.
I will not possibly, my lord, take any loan. I am very
Given half a
scared of.
chance, not loan. But given half a chance, you would take business class and go to foreign.
My lord, business
Why
class,
not?
I have
What prevents you from doing it?
I have no. But business
Why
class
is that a bad thing?
No, bad thing, my lord, no. It shocks the conscience, but it's a matter of morality, my lord, that I have taken public
Morality,
money.
don't say that in a
No,
morality is
not
very
law.
fluid.
Morality
It
is not
changes
law.
from person to person,
Morality, yes. From
situation to situation.
From the aspect of a person who is a middle class Bengali, my lord, it possibly shocks the conscience.
You're not the right person to argue this matter. Neither am I the right person to hear it, but I'm not shocked. My conscience is not shocked by it.
No, I have
We
come
to
across
look
cases that
at the figures, Mr. Bhattacharya, as it is.
no,
I mean,
figures, but
person-
the
if a
affidavit
person
is
can
there.
afford the business class, Mr. Bhattacharya,
No,
why
here-
do we come in the way?
This is another.
Why
that is
should we?
No, that is another case, my lord. The other case I was referring to,
Hmm.
there the involvement was around the bank default was to the tune of around 200 crores. It was a consortium.
I have been dealing with nowadays these LOCs much more than this. 3.5 crore is nothing.
LOC, my lord. Here, my lord, as I was indicating.
So what? How is this a ground for issuance of an LOC? Tell me.
No, my lord, I am saying, my lord, that there is an ongoing investigation. The investigation has
That is not a rider, not a ground in the office memorandum of yours.
Oh,
Ongoing investigation.
No,
is
no,
that
of course
was
it is, my lord.
No,
The bank.
trial. There
No,
has to be a criminal proceeding pending.
My lord, I'll tell
Investigation
you,
is not a
lordship, my
proceeding.
lord. My lord, I'll tell you, lordship, my lord. Let us, my lord, read the memo together, the guidelines together, my lord.
Show me something. Criminal proceeding cannot be equated with investigation, Mr.
My
Bhattacharya.
lord.
Definitely not.
My lord. My lord, first of all, my lord, let us come to, my lord, the authorities who have been empowered, my lord, to issue
There
these.
is no doubt on that. That is, I am satisfied on that in this matter. Neither has Mr. Chaudhary argued on that.
My lord.
So it is only on your economic interest of the country and public interest of the country. Apart from that, if any other ground is there, show me.
Yes. My lord, kindly takes, my lord, page 3 of the guidelines.
Read out the relevant phrase, which is applicable in this
My
case.
recourse to LOC can be taken by investigating agency, which is the SFIO here, in cognizable offences under IPC or other penal laws, where the accused was deliberately evading arrest or not appearing in the trial court, despite NBW and other coercive measures, and there was a likelihood of the accused leaving the country to evade trial arrest. So, my lord, may kindly read this, my lord. My lord, these are disjunctive, my lord. First is, my lord, to evade arrest deliberately. Second is, my lord, non-compliance with, my lord, the non-bailable warrant. Thirdly is, my lord, likelihood of the accused leaving the country to evade trial or arrest. So, my lord, this is, my lord, I say distinctly different from the exceptional provisions, my lord, which has been incorporated by virtue of, my lord, these particular guidelines, that even then, my lord, the National Commission, the banks, my lord, which has been empowered, my lord, that even if, my lord, there is no investigation on, but here, my lord, there is an investigation, my lord. There are two limbs, my lord, insofar as the LOC is concerned. LOCs are concerned, my lord. One, my lord, at the behest of the bank on exceptional grounds. The other one, my lord, at the behest of the investigating agency, my lord. Now, my lord, what the Supreme Court, my lord, the Honorable Supreme Court has said, my lord, that in so far as, my lord, investigations undertaken by the SFIO under Chapter 14 of the Companies Act, my lord, is concerned, my lord, but there is no timeline. It's not time bound, unlike, my lord, the CRPC, and it is having an overriding effect, my lord, over the CRPC also. CRPC being, my lord, a procedural law, but naturally, and the Companies Act, my lord, being a special law. That apart also, my lord, the language, my lord, of, my lord, the sections, my lord, as contained in section 4, in Chapter 14 are concerned, my lord. It makes it explicitly clear that, my lord, overriding the provisions of the CRPC, this specialized investigating agency, my lord, has power, my lord, to, my lord, cause investigation into, my lord, I'll term this as, my lord, money laundering cases, my lord, or, my lord, cases, my lord, to trace out the money trail, my lord. That is the most difficult aspect, my lord. But what was the mensentia legis, my lord, the intention of the legislature when this particular insertion was made, my lord, in the Companies Act? My lord, the most difficult aspect, my lord, which is to be investigated, my lord, by investigating agencies is, my lord, uncovering, my lord, the truth insofar as the money trail is concerned. These specialized economic offenses, my lord. My lord, we have seen, my lord, insofar as, my lord, the cheat fund scams are concerned, my lord, even now, my lord, money trails are being traced out, my lord, by the other agencies, my lord, which have undertaken the investigation pursuant to orders being passed.
To lodge an FIR under the law, SFIO?
My lord, SFIO, my lord, the provisions are completely different, my lord. As I was
Can you lodge an FIR?
No, my lord, it is not
a complaint.
No, it is not FIR, my lord. My lord, the report is, my lord, at par with a charge sheet. And that is there in the provisions contained in the Act. It kindly takes, my lord, section 212 of the Companies Act. 212, subsection 14. On receipt of the investigation report, the central government may, after examination of the report, and after taking such legal advice as it may think fit, direct the SFIO to initiate prosecution against the company and its officers or employees who are or have been in employment of the company or any other person directly, indirectly connected with the affairs of the company. My lord, kindly appreciates, my lord, here, my lord, the offenses are punishable with, my lord, a term, my lord, extendable up to 10 years, my lord. My lord, kindly take section 447, my lord, that specifies, my lord, insofar as, my lord, exactly what has been stated, my lord, in this order, my lord, that I was relying upon. Paragraph 13, my lord, that finding that in para 17 of their application, what has been written, my lord. So, my lord, if that is proved, my lord, that is enough, my lord. Under 447, my lord. Which can extend to, my lord, 10 years. And, my lord, it is essentially, my lord, it is beyond, my lord, any pale of doubt.
Subsection 15 is also there.
Yes. My lord, the entire chapter, in fact, my lord, chapter
15 is what you are saying.
Yes, yes.
That it is framing of charges shall be deemed to be a report filed by a police officer.
My lord, I bow down to that, my lord. I'm grateful to your lordship. In fact, my lord, an analysis of the entire chapter that gives powers to the inspectors also, my lord. They have the powers to arrest also. And my lord, it is beyond anyone's pale of contention that this particular investigation has been undertaken on the ground of public interest, my lord, as was correctly pointed out by your lordship, my lord, on the last occasion when Mr. Chaudhary was arguing. So, my lord, the question is, my lord, it's a very moot point, my lord, whether during the ongoing investigation, an LOC initiated at the behest of the investigating agency, but whether, which is not also specifically under challenge in the writ application as it originally stands, where, my lord, there is nothing spelled out, my lord, in the grounds also, my lord, of the writ petition.
So, Bhattacharya, at the risk of disturbing you, if it is equated with a with a police report. I mean, it's a police investigation. It's equivalent or at par with a police investigation. Even if it was a police investigation, then also can you say that itself tantamounts to pendency of a criminal proceeding? That is what is required. That is the standard
No, no,
required
that is
for
what
this
I
LOC to be
indicated.
issued.
That is what I indicated.
An
Madam.
investigation cannot be equated with a criminal proceeding.
No, no, Madam,
It's a different
recourse,
step.
Madam, recourse to LOC can be taken by investigating agency in cognizable offences under IPC or other penal laws. One of the punishment which is extendable, one of sentence of 10 years, my lord.
Is that the office memorandum annexed here somewhere?
My lord, I have supplied a copy to your lordship, my lord. I have another copy.
I'll just check up. Must be here.
2021 guidelines, my lord.
2021 guidelines.
Yes, on the last occasion, and it was handed over.
Yes.
I'll just.
My kindly takes, my lord, the third page, my lord.
এর মধ্যে কোথাও সেলাই করা রয়েছে এইটা খোলা আছে হ্যাঁ yes got it.
My kindly takes the third page, my lord, serial number 4.
Third page, serial number 4.
A, my lord, recourse to LOC can be taken by investigating agency in cognizable offences under IPC or other penal laws where the accused was deliberately evading arrest or not appearing in the trial court despite non-bailable warrant and other coercive measures, and there was a likelihood of the accused leaving the country to evade trial arrest.
So has that stage arrived here?
My lord, we are investigating, my lord. There was, my lord, reasonable apprehension, my lord, that attempts will be made to leave India, my lord. One of the directors, my lord, he has already left India. He is in hiding in Nepal, my lord. The other two, my lord, what I was indicating, my lord, they have, my lord, attempted to do it, my lord, by filing, my lord, in attempted sanctimony, my lord, by going to the airport. First of all, my lord, by trying to go to Nepal, being prevented, thereafter writing a letter to the bank, and thereafter filing an innocent writ application. Look here, I wanted to travel, my lord, but the bank has possibly initiated something. There is an LOC at the behest of the bank. Therefore, we cannot travel. Therefore, kindly quash that particular decision preventing us from traveling. Nothing was spelled out, my lord, in so far as, my lord, the SFIO is concerned, my lord. And, my lord, the other question, my lord, which my lord, fell for consideration, my lord, regarding, my lord, prior information, my lord, to the persons, my lord, against whom, my lord, LOC has been opened, my lord. But we had handed over, my lord, the other memo, my lord, on the last occasion, my lord, where, my lord, LOCs, my lord, have been, my lord, requested to be kept as, my lord, classified documents, my lord. So that is one, my lord, and again, my lord, the scheme of penal laws, my lord. My lord, this is what the Honorable Supreme Court says in a number of cases. But the concept of audi alteram partem, my lord, is something alien, my lord, to the scheme of penal laws. So, but that is, but in fact, that point has been upheld by our court also, my lord, in many other matters.
Audi alteram partem is unheard of. I mean, it's a foreign concept to criminal law.
To, my lord, penal laws at the stage of investigation. That right arises.
Say that.
Huh, my lord?
Say that at
Yes,
the stage of
That
investigation.
right arises.
Definitely, yes.
So once, my lord, it
That
goes
is the
to
reason
trial.
investigation itself is not a stage contemplated in your guidelines.
My lord, I'm grateful to your lordship, my lord, for
That
the
is the
observation.
stage.
My lord. So, my lord, these, my lord, in a nutshell, my lord, this is another judgment, my lord, that I will be referring to, my lord. আমার judgment গুলো দাও সাহারাটা দাও এটা কোনটা But this is reported in 2022, volume 9, Supreme Court cases, page 794. But this basically spells out the fact that, my lord, any LOC, etc., my lord, these are basically consequential in nature. So this was while dealing with an interim order, my lord. The High Court had basically my lord, stayed the.
Please switch on the mic, that gets switched off. Yes.
My lord.
When sensitive issues are discussed, it gets switched off.
But first of all, my lord, there are 2 points, my lord, which will be, my lord, helping me, my lord, in my submissions. One is, my lord, as I was indicating, my lord, that 212, my lord, there is no mandatory period contemplated, my lord, under the CRPC, my lord.
Yes.
Insofar as, my lord, conduct of investigation is concerned, my lord, paragraph 11, my lord.
Hmm.
That answers it, my lord.
Hmm.
Paragraph 12, my lord, spells out, my lord, the provisions of the Companies Act, my lord, whereby, my lord, it is establishing the fact, my lord, that the SFIO has powers of investigation, my lord, in so far as, my lord,
Definitely, it definitely has.
the powers of
Definitely it
inspectors
has.
also, my lord. And para 14, my lord, here what the Honorable High Court, my lord, did, my lord,
Yes.
while passing an interim order, it stayed the FIR and also stayed all further proceedings, including the LOCs. So the Honorable Supreme Court, my lord, interfered with the order, sent it back again to the Honorable High Court, my lord. As I was indicating, my lord, the
I mean, why is this helpful to you?
yes, because, my lord, I commenced my arguments, my lord, by saying
Hmm.
that here, my lord, the investigation is not under challenge, but the LOC is
No,
under
it is
challenge.
not. Investigation is going on.
And LOC, my lord, is an incidence, my lord, of the investigation, my lord. So unless and until, my lord, there is not a word, my lord, even spelled out, my
LOC
lord.
is an incidence of investigation that maybe.
No, that, my lord, why, my lord? That is why, my lord, I was citing.
I mean,
No, my lord, all subsequent actions, by all subsequent actions, even, my lord, here in this case, my lord,
Mr. Bhattacharya, if that contention is accepted, the reason I'm saying this is then
my
it will
lord,
be a
kindly,
dangerous.
my lord, kindly
No,
appreciate.
please come to your set of the office memorandum.
No, my lord, kindly appreciates, my lord.
No,
Then
please once come to H at page 6 of that.
my lord.
Now, recourse to LOC is to be taken in cognizable offences under IPC.
Yes.
Details in column 4 in the enclosure reason for must invariably be provided without which the subject. In case no cognizable offence under IPC and otherwise, the LOC subject cannot be retained, arrested, etc.
Yes.
So, when can you say there is a cognizable offence?
No, our request was very different. Our request was
no, then you are putting it on equal footing. An investigation,
No,
you are
no, no,
putting on
there was
equal
no-
footing
my lord,
as a cognizable offence.
my lord, our
This
LOC,
is also a
my
ground,
lord,
yours is also a
no,
ground.
no, my lord, had the LOC, my lord, had the request spelled out detention, they would have been immediately arrested the moment they were at the airport. Here it is, my lord, prevent them from leaving India and inform the person originating the request. It is not, my lord, detain or arrest.
But prevent.
Prevent him from leaving India and inform the.
Bhattacharya, if I don't detain you in the courtroom, but I prevent you from going out.
No, no, my lord, that
So
is
what is the
there.
difference
No, no,
between
that is there, my lord. That option is there also in the guidelines. That option is there, my lord.
Yes, but it's not of a lesser footing.
My lord, it
prevents someone from leaving
no,
the
my lord,
country.
Whenever there is an
No question
apprehension.
of detention. Detention, you cannot detain a
No,
person without
detention can be done, my lord, when there is an NBW. When there is a non-bailable warrant, my lord, the question of detaining or arresting will arise.
Yes, definitely.
Yes. But here, my lord, where there is a suspicion, my lord, as I was indicating at page 4, my lord, that the person against whom, my lord, the investigation is ongoing, there is an apprehension, my lord, that they will be or he will be leaving India, then definitely, my lord, this can be resorted to, my lord. Otherwise, my lord, the very objective, my lord, my lord, of my lord, issuance of a LOC, my lord, but that will get frustrated. I understand, as has fallen from my lord and also from the honorable other
So
judge.
that is different. That is on individual liberty and all those are there. But we are on more serious issues. I mean, you say that a person cannot leave the country if there is a serious apprehension against him. I appreciate that. But I mean, what is the apprehension? How can you enforce it against him personally? Unless you exhaust your remedies for attachment
No,
of
here,
property
my
to
lord,
others.
no, here.
And why is he personally required?
No.
Would you hang him personally? I mean,
no, my lord, they are being questioned, my lord, in connection with the
there
ongoing
is no
investigation.
cognizable offense now.
No,
this person has a right to move about in the country. Why not outside?
No, my lord, the investigation is ongoing, my lord. Insofar as, my lord, cognizable offense, my lord, the arrest is concerned, my lord, that power is also there, my lord.
Arrest?
The inspector also has a power, my lord. The investigating agency.
This is not
also,
an arrest under.
we have not arrested, my lord, because, my lord, but that stage may not have arrived till now. My lord,
If you could have arrested Mr. Bhattacharya, you would have arrested.
If we.
Because you could not arrest, you did not arrest.
If we intend to arrest, my lord, with the progress of investigation, my lord,
but that will prevent a person. You remain there in the pen till I catch you and sacrifice.
No, my lord, kindly appreciate.
This is not done.
No, my lord, but
he's a citizen of India. Definitely, you may have serious apprehensions.
Unfortunately, my lord, another citizen of India is now in hiding, my lord, being a director of this company in Nepal, my lord. He is, my lord, not cooperating with the investigation. And my lord,
he cannot be cited as a reason for interdicting this person.
No, but No, but my lord, this has happened, my lord.
Unfortunately, there are many people who are not in hiding, who are in open daylight, roaming about in the country, who should be behind the bars.
My lord,
So
here, my
we
lord,
cannot draw analogies here.
no, no, but my
Many
lord,
people
here,
are there roaming around proudly, who should be behind the bars.
my lord, here we are dealing with the case of my lord Kohinoor Power. Now, one of the directors of Kohinoor Power is in Nepal, not cooperating with the investigation. And insofar as, my lord, the other two are concerned, these two, my lord, one tried to go to Nepal, he was prevented. But thereafter, these two documents,
In
my
your
lord,
request, have you mentioned these?
yes, yes, in my request, I have mentioned this, my lord. Kindly see, my lord, the white envelope, my lord. We have indicated, my lord,
It is out of the bag now.
my lord, we have indicated, my lord, the file number, etc., my lord, on the basis of
That
which
you have
the
indicated.
investigation has been undertaken.
Let me check.
This was done, my lord, on the basis of the old pro forma, my lord. And my lord will find also, my lord, at the second page, my lord, towards the bottom, my lord. The request was not to detain, my lord, not to permit the person to leave India and inform the originator.
No, but your under criminal case, you say FIR number.
No, no, that is the format, my lord. That is the old format. That is the old format which requires this, my lord. But we have
That is the
provided.
entire request.
Yes, we have my lord, we have provided, my lord, the details, my lord, on the basis whereof the F number, etc., my lord. On the basis whereof, my lord, the investigation was commenced.
Very well. You can you put it in a short written notes of arguments, Mr. Bhattacharya?
I can, my lord.
Just do that so that it's on record. I mean, your arguments,
My lord,
because this is on a serious footing. More,
no,
your arguments are wider than the other matters.
No, no. Here I said, my lord,
undoubtedly, because you are the immigration authorities. Not only that, you are for the SFIU.
Immigration authorities, my lord. There, I'll tell you, lordship, my lord. Since, my lord, I
They
did not have
they wash off their hands.
No, no, no. It's not like that. I'll tell your lordship, my lord, what happens, my lord. But they are more like, my lord, rubber stamp authorities, my lord. Once, my lord, the LOC is issued.
It should be the.
No, no. I'll tell your lordship. No, no. I'll spell out the process, my lord. There is a software, my lord. So once LOC is issued, my lord, it gets updated in the software.
Yes, exactly.
Now,
You
once
said
the
that
passport is presented, my lord, now the passport is put under that particular scanner machine. Now, then, my lord, whether there is an LOC or not, that pops up, my lord, in the computer window.
Yes.
And it is on the basis of whatever pops up in the computer window, my lord. Then, my lord, my lord, immigration officer, my lord, he takes action, my lord. The other case, my lord, where, my lord, the immigration stamp was cancelled without prejudice. So that is the procedure because it popped up, my lord, after it was presented.
Well,
my lord.
Yes, bank.
Yes. Here also, other than the other.
In fact, this is an exceptional case where your request is much more elaborate.
Exactly. That is what I was.
Appears to have been settled by council.
No, but I stand grateful to Mr. Guha. Had he not informed me about this particular
Make
order,
your pollution public.
About this particular order.
Yes, yes, Mr. Guha.
The Lordship kindly takes up the lookout notice, the reasoning part. And my lord, this particular reasoning, it's a detail what I'm not reading.
The reasons for LOC.
Reasons for LOC of the bank's LOC.
But,
Yes, please, right.
My junior is here. May I take?
Yes, yes, absolutely.
230 matter is.
Absolutely. Yes.
May I just come?
Please.
If my lord kindly comes to this internal page 2 or the running page is on top, it's written as 4.
Yes, 4.
So my lord, if I may spell out the entire reasoning part, if I may read out.
Yes, yes.
Messrs. Kohinoor Power Private Limited, a private limited company, has availed the credit facility from our India Exchange branch, Kolkata, under consortium banking arrangement for setting up 66 megawatt coal-based thermal plant. The company was sanctioned by a consortium bank facility of rupees 244 crores. Our bank was 75 crores in the year 2010. Mr. Vivek Duggar, Mr. Vijay Votra, and Prashant Votra are the directors of the borrower company and also the guarantors to the limit granted to the borrower. Due to non-completion of the project by the borrower, the account was classified as NPA with effect from 1st September 2015 on 29th of January 2018. 18 having an outstanding balance of 74.52 crore due to bank. One of the operational creditor has filed the proceeding before National Company Law Tribunal, which was admitted in 2018. Due to non-receipt of resolution plan, NCLT ordered for liquidation of the borrower on 28th of June 2019. Now, my lord, kindly mark this portion. During CIRP, forensic audit was assigned to Messrs. Cabra and Company, who pointed out the following irregularities in their forensic audit report. My lord, my entire basis is on the basis of this forensic audit report.
Have you got a copy of that?
My lord, I'll try and assist my lord on the.
You are sure there is no disclaimer clause there in the forensic audit report?
My lord,
are you sure?
That disclaimer clause generally there, it lies there in all the report, but these are the observations of the forensic auditor. My lord, if being a
There's a
bank,
disclaimer clause. Not one disclaimer clause. It is there in the beginning, at the end, in the middle.
definitely, but at the same time, if I may, my lord, say this, if at
But
the
you
same
rely on these forensic audit reports like this.
well, what is otherwise, if I may put this question to
What
myself,
else? What else? is
what else? What are
nothing else? A recovery proceeding? Get an attachment order? Put the person behind bars for financial
Well,
fraud?
because of this IBC proceedings, there are norms that you have to carry out forensics. During forensics, these are the
I appreciate the
preferential
forensic audit report, but that is important for the IBC proceedings, for the CIRP proceedings.
for the CIRP, but to
Cannot
bring
interdict
out,
a person's liberty.
bring out whether during this transaction, why this company was put to
You
this
are
position.
absolutely right. Forensic audit report is one of the basis. It is one of the components, definitely.
Know the reason for putting this company into this position.
But that is a part of that is place primarily reliance on that for an issue of for a request for issuance of LOC.
Because from the forensic report, it can be carved out what kind of fraud that has been committed, which cannot be in an open eye. And those are the points that has been mentioned in
This point of time on the forensic report, it is one of the components of evidence, if I may say.
Yes,
I mean, one of the components of evidence at best, a part of the record, not a
that those are
clinching
the
evidence.
findings, that basis which the company has gone into.
Yes,
this
those
thing.
are the findings.
And
Those
they
are
have
prima facie
siphoned off
value.
money. They have done this. So those are in the nature of a fraud.
In
that
a
has been
civil
committed.
suit, that would be only a piece of evidence, even in a civil suit, let alone a criminal proceeding, which has to be beyond reasonable doubt. No, this person is being resisted from leaving the country. I mean, leaving the country. Why are you so paranoid about it?
Well, as I submitted
It's
on the
just like paranoia. I mean, you cannot leave the precincts of the country.
No, my lord, what has happened is the government has issued a directive.
In fact, sometimes it's safer for the people who want actually to commit frauds to be within the country. That's easier. They remain just under the light. It's easier to remain there. They would never be caught because of the glaring light just above them.
But my lord, since then
you cannot improve that situation. Neither
cannot,
can
my lord, I
we
told,
cannot do that. But forensic audit report, can it be a ground for issuance of LOC? So,
these are the basis for
can you
issuance of
support
LOC.
this? I mean,
Because that is my reasoning. I cannot improve my case. What is there in front of my lord. These are the basis. These are the 6 grounds based which the bank thought that there has been a fraud that's been committed, and as such, this.
But it's much more elaborate than the other ones. That I
because
must
those cases are only willful defaulter. I don't even, my lord, I don't have to make any
in those
submission.
cases, there are also forensic audit reports which have not been quoted there. Here you have taken the trouble of doing that. Actually.
But here, actually, certain fraud that's been committed. Maybe SFI.
No, the allegations may be very serious.
Allegations are there, and that will transfer from an order of NCLT also, which my learned friend must have
Mr.
placed,
Bhattacharya, please there.
wherein it has clearly been indicated that it shows that fraud has been committed. Now, my lord, keeping in view of these observations and the report, my lord, and this reason for issuing the LOC, my lord, I completely leave it up to your lordship, but this is what is their best available record and the current situation. And my lord, a notification is there. Government has granted and issued a notification whereby government has stated what measures can be taken by a public sector bank if they falls within the limit. My lord, we were within the limit, and as per our understanding, this lookout notice was issued by the concerned person as directed in the notification. Those are my respectful submissions.
This is the last. This office memorandum is the last one. 2021.
Yes, my lord.
There is no dispute on
and
that.
Thereafter, my lord, only this 2022 that which says that LOC can't be given to anyone. Only that Most probably November 20.
Yes, that's secret
8th
part.
April 2022. Exactly. madam.
Confidential and all.
Confidential. Those are the subsequent.
Very well, yes.
And nothing beyond that.
Thank you, sir.
Grateful. madam.
Yes, Mr. Chaudhary, reply.
First, kindly come to the order of the NCLT.
Yes.
This is nothing but an ex parte order 39, rule 1 and 2. Lordship will see para 2 first. This IA has been filed by the Union of India through Serious Fraud Investigation SFIO, seeking exemption under Rule 14 with 23.5, which is, my lord, dispensing with prior notice. Keeping in view the facts and circumstances and emergent nature of reliefs claimed, we exempt service of advance copy of the petitioner upon respondent. Then, my lord, kindly straight away come to para 13, which was relied upon. Fraud is established beyond doubt. Advance monies were paid to related party and transactions were not concluded, and no steps have been taken for recovery of money. Directors have siphoned up funds, respondent 4, and have parked it in another company. In these circumstances, 1, 2, 3 directors are liable to pay 3 crore 50 together with interest. Well, this is nothing but under the IBC, fraudulent transaction, and my lord, section 66 and section 45. Well, this is just akin to the earlier proceedings we used to have under the Companies Act. Well, this forensic audit terminology, the fact forensic has been introduced has, my lord, given a new color to it. But legally, my lord, it is the same.
So they are actually forensic.
Whatever, my lord.
Yes.
Yes,
That is the purpose of
it is-
issuing LOC.
It is mostly relating to sick companies or companies who are.
So they are sick of you living and going to foreign countries. So that's why that is the purpose of issuance of LOC.
Well,
Forensic report has to be there.
Well, earlier, my lord, when we had Companies Act 1956, my lord, even before.
This is at the inquiry stage. I mean, I don't think this is a clinching something against you which can.
No, I'll come to this. My lord, I'll first explain. Your lordship will recall,
Yes.
in any company, when it goes into liquidation,
Yes.
the role used to be played by the official liquidator.
Right.
The official liquidator, my lord, because of the corporate cloak, the directors could not be held personally liable. So the official liquidator, my lord, just like a suit, had to file the proof of claim. And my lord, like a written statement, the response would be filed. Then an auditor would be called. No, my lord, adjective prefix, no prefix was there. An auditor would be called who would give evidence to the effect that how from the accounts of the company it is being shown that directors have removed the money for their personal interest. If that could be established in the court of law, a civil decree would have been passed, making the directors personally liable.
Yes.
What is before your lordship is exactly that. It is just under the provisions of IBC, nothing more than that. Now, my lord, subject to correction by my learned friend, and this was not there. I have taken instruction immediately after this was relied. This is on 7th February 2023, past ex parte. We have filed a recalling application in the NCLT, and I am told that is pending. That, my lord, Mr. Gohu will correct me. And in any event, they are protected by the interim orders. There are interim orders which is there. But, my lord, this has nothing to do, so far as the memorandum is concerned, neither can the Serious Fraud Investigation Office take help of this. Because, my lord, the original opening argument which I have made, my lord, was unanswered by Mr. Bhattacharya, my lord. That is, the stage up to subsection 4 of 212 of Companies Act is only reached as of now. Lordship would recall, I had shown your lordship, right, how serious fraud investigation, what is the definition? It's a creature of the Companies Act 2013. The Act defines it. The Act codifies the steps that is to be followed. All that has happened is investigation. And in my petition itself, I have disclosed that other than page 35, that is the email of 2020, not a single notice, not a single summons has been issued by the Serious Fraud Investigation Office. And that 2020 email, I have replied 5 times. As and when I have got documents, I have sent it to them. After that, well, there is no query, nor has Mr. Bhattacharya said that, no, this is the summons he has avoided. There is no allegation of not responding to a letter also. Nobody can say I have not responded to the letter. On the contrary, after September 2020, all documents in my custody have been given. You have preferred an application, I have taken out. This is at the end of the day, I have a civil remedy, I am pursuing it. If I am able to get this order set aside, some attachment and injunction from my properties will go and my personal liability will go. That's all. Nothing more, nothing less. It does not take care of any of the clauses under the agreement. And if Lordship takes 213, well, subject to repetition, subsection 4 is when the investigation will commence. Director, serious fraud shall cause the affairs of the company to be investigated. Who shall have the power? So investigation stage, all that has happened is he has written me a letter. I have responded, not once, but 5 times, giving all the documents. Thereafter, nothing has been shown. And my lord, this director who's been said he is hiding in Nepal, my lord, for their information, if they would have put it in affidavit, I would have said they are not the petitioner. He is a resident of Nepal, a citizen of Nepal. That Dogra, Vivek Dogra, Duggar, he is a resident of Nepal. Not
The one
hiding.
who is hiding in Nepal.
What is being said? We were not allowed. While going to Nepal, one of the directors faced it. But one, my lord, which is being alleged hiding in Nepal, he is a citizen of Nepal.
So he may be hiding there, yes.
So he is in his own country. No question of hiding. And if they have any grievance,
Nepal does not impress. Nepal does not impress.
I am saying if
It is very close.
if they have any impression, if they have any grievance against Mr. Duggar, if LOC or similar, they keep.
Nepal, even Mr. Guho can go and catch him and bring him. Nepal is not very
So,
far.
so my lord, my first submission is that even after, my lord, the so-called sealed envelope and all that, this notification, my lord, now that I am aware, time has come to challenge this also, because my lord, now Supreme Court has come down very heavily. My lord, this sealed envelope business has to stop. Especially when you are
circulars were never challenged. The last circular has to be challenged.
I was not aware, so I am also not.
He was also not aware before this matter. Actually,
Yes, I will.
No, the matter before this. I mean, Mr. Guho probably pointed out.
Because when a Supreme Court is repeatedly saying when you are dealing with a person's life and liberty, you just can't hand over sealed envelope concept where, my lord, I don't have an opportunity to deal.
That's true. That's true.
Now, my lord, second, assuming for a moment what has been written in that sealed envelope, my lord, the contents, my lord, whatever reasons have been read out, my lord, I have shown your lordship the affidavit. If there is anything contrary to the affidavit, my lord, it should be discarded.
Mr. Chaudhary, what the authorities do not understand is the moment you place a sealed envelope before the court, the first psychology, human psychology, is to try and defend the person who is not getting a right to look into the envelope. Just like an expertise stage.
Correct, correct.
I mean, the first, the knee-jerk reaction, if I may use the expression, of the court is always to protect the party who is not represented. So that is the deterrent against an ex parte order. That's why we try always to rope in the other side also.
Correct, correct.
That's one of the reasons why you should not put in these secrecy guidelines everywhere. I mean, the moment I see that there's something which you cannot deal with, then there's an instinct of the court to protect your interest. I mean, the one who is not looking into.
Correct.
Although we have to overcome that consciously while passing an order, if there is anything in that
No, my lord,
serious,
my lord,
but that's the first reaction.
I can well appreciate, my lord, there
I
may
don't know
be,
why these clauses are being
my lord,
brought in.
there may be certain situations when dealing with national security, you are making disclosures
No,
on defense.
definitely.
That is a different aspect.
You don't have
also.
a right to disclose.
But when lock, stock, barrel, now, my lord, investigating agencies producing reports in sealed envelope, my lord.
I mean, this is the best request for an LOC which I saw up to now. I'm being
Yes,
very candid.
it is very.
And this also, what does it do? It quotes certain clauses of the FAR. And what better can they do? I mean, Mr. Guho was right on that.
My learned friend, unknowingly by reading from that, has
No, knowingly, he knows because that is, he tried to counteract that knee-jerk reaction of mine.
He has read it
So he
out, but
wanted to put it
whatever
on record so that you can deal with it.
whatever little I have heard, my lord, 3 things emerge. That I have taken money, the company has defaulted, or the business has defaulted, and there are proceedings pending, and there is this order.
The name of the auditor is there. That may be a source for the.
Now, so far as forensic audit, the provisions of the insolvency,
these are.
the provisions of the insolvency code provide for a forensic audit. All cases of IBC where they want to recover any money from the director, there has to be a forensic audit. There is nothing special in the forensic audit. And none of these guidelines are not being followed. It is really, all these cases have happened at the cost of repetition, what I had said, those two names. Because, they are conscious and they want to avoid any, controversy. This is being done mechanically.
One of the two names you should not take.
It's better
You
not
will
to
be in
take.
trouble.
It's better not to take both.
So yes. Anyway, so
The
this
name of the company for the other one is a better one, Kingfisher.
No, but I actually wanted the written notes of argument because I have got Mr. Gho's arguments are
can
very
do
clear.
that. I shall do
Your arguments are also very specific.
Yes.
I mean, I can do without written notes of
No,
argument.
Lordship wanted that.
No,
shall-
Mr. Bhattacharya, yes, argued on certain aspects of the matter which are new dimensions. The 213 effect of 213 and all this, which I'll have to deal with. So that's why I have actually asked him to.
Just one more minute. Well, at subsection 13 and 14 would show 14 stage has not yet come. Central government will direct SFIO to initiate prosecution.
Mr. Chaudhary, even if it comes, let us come to 15. What does 15 do?
Correct, Lordship, I am not repeating.
15 equates that report with a police investigation report. Now, if that be so, you cannot put it on the same footing, a police investigation report and the criminal trial where you are held to be an offender. I mean, it's just next stage of the same investigation process. You cannot put them at par, even in this office memorandum.
And nothing has, after beyond subsection 4, nothing has traveled. And still they are saying, I am investigating. And SFIO, it sounds, the reason why I am dealing more with SFIO, he has been very candid. This is the standard case of the bank. We can understand that. But SFIO, there is nothing special about SFIO other than the name. It's another investigating agency under the Companies Act.
Yes.
And it has to, whatever obligations are there with CBI, with the police, with the ED, SFIO, the obligations are he has to conduct the investigation. Investigation report placed to the government. Government will direct you initiate prosecution. Prosecution will be initiated, then FIR and all these.
Yes, exactly. I mean,
so this is completely premature. But I'll put in a note.
Please put in a short note. How soon can you do that?
2 days.
I'll keep it after 2 days.
Very well. My lord wants me also to put in a.
You can or you may not also, Mr. Go. Your entire case is on this.
Exactly. My entire reasoning part and everything is on
because Mr. Bhattacharya is appearing for SFIO, not only SFIO, also the immigration authority. I mean, he has a different dimension. It's actually Mr. Bhattacharya whom I want to file that.
Very well, very well. Then I'll not trouble my lord.
Learned counsel, hearing is concluded. Learned counsel for the parties are requested to file written notes of arguments, if they so choose, on the next returnable date. The matter shall next be listed on August 24, 2023.
Great.
Please come back on that date. It had to be mentioned. It will appear as to be mentioned. I'll just take in the written notes and.
Great.
It a book. Book? No. হ্যাঁ তাহলে একটা লিখে দিন be listed as to be mentioned. আচ্ছা এটা খুব সাবধান বাবু, এই ডকুমেন্ট গুলো কিন্তু হারানো যাবে না, কোনোটাই হারায় না তো, কিন্তু এইগুলো কিন্তু খুব সাবধান। আমার মনে হয় ভরে দেওয়াটাই বেটার হবে। যার জানো তুমি একটা কাজ করো, এটা এর, হ্যাঁ রাইট, এটা এর, না না আমি ভুল করছি, ভুলেই যাবে গো। ব্যাংকে, এটা ব্যাংক, হ্যাঁ এটা ঠিক বলেছি, হ্যাঁ এটাই, এগুলো আলাদা, ঠিক আছে, থ্যাংক ইউ। দেখো
Item 19.
Lordship, I appear for the petition. This is my affidavit of service, Your Lordship.
all have been served.
May it
Yes,
please
Your
your lordship, in this matter, I am appearing for state, my lord.
I am only seeking for a direction upon the learned district magistrate to dispose of my section 14 application, which is pending from March 2022, Your Lordship.
You are prepared in this.
My lord, due to the backlog, my lord, the matters could not be taken up, my lord. The matters are gradually taken up. So whether this matter has been taken up or not, for that I need instructions, my lord.
I'll dispose of
My
it.
lord, may
I am for the forward. I have
Yes,
something
what do you say? Should not be disposed of.
But the proceedings are going on, my lord, in the already in the DRT, my lord, that has not been disclosed in the.
Have you obtained any interim order?
No, Lordship.
Not, my lord, but the appearance.
Losses with the outer limit is 60 days,
The interim order.
30 plus 30.
But
Under section 14, the time limit is 30 days. Within 30 days, it has to be decided. It can be extended up to 30 more days.
my lord, it has been filed within the date, my lord, next date
Not
is.
filed. The 30 days is 60 days is long over after filing of the section 14, which is to
Yes,
be
Your
completed.
Lordship, more than a year has passed.
My lord.
Then a year has
And
passed.
in any event, in section 14, the borrower has no right of hearing, at least, Your
In
Lordship.
that even, my lord, the proceedings will be, my lord, get frustrated, my lord. It will become
Not
infructuous.
When did you
taken
file
in-
the proceeding?
No, nothing has been served upon the bank.
My lord, it has been served, my lord.
When did you file it? Give me the approximate date.
15th of February 2022.
22. 22.
2022.
And you filed your section 14 when?
Section 14, it's filed on 15th March 2022, Your Lordship.
You couldn't obtain an interim order till now.
No, my lord. Unfortunately.
No step,
But-
nothing has been to
but-
repay the
But there is no
outstanding, Your
reluctance
Lordship.
on the part of
At
They cannot wait
eviction-
indefinitely. Guys.
reluctance, your lordship would appreciate.
I'll
that
record
is
your
no-
submission, but that cannot be a ground.
Well, they have been notified. My lord, the
You have got
petitioner has
sufficient
been
time to
notified.
obtain an interim order, sir. More than a
My lord, that is.
could not
but-
be done. We could not obtain an interim order. Could not be done. What else can do? No. Learned counsel for the petitioner bank submits that the application filed by the bank under section 14 of the Surface Act 2002 is pending for more than a year, comma, although the statutory outer limit is 60 days. For sub next para, learned counsel appearing for the respondent number 2 submits that due to substantial backlog in the office of the said respondent, comma, the present matter could not be disposed of within time, full stop. However, comma, further instruction is required regarding the present stage of the application. So next parallel counsel appearing for the respondents numbers 2, 3 and 4, comma, that is the borrowers, comma, contents that an application under section 17 of the Surface Act 2002 is at present pending at the behest of the borrowers before the debts recovery tribunal. So as such, comma, it is submitted that in the event the application under section 14 is disposed of prior to adjudication of the same, comma, the challenge preferred by the borrowers would be rendered infructuous. For sub next para, upon query of court, comma, it is submitted on behalf of the respondent numbers 3 and 4 that the application under section 17 was filed in the earlier part of the year 2022. Full stop next para. However, comma, till date, no ad interim restraint order has been obtained by the respondents borrowers in connection with the said challenge, comma, despite having got sufficient time to obtain the same. Full stop. As such, comma, the law does not permit the district magistrate to wait for an unlimited period in order for the borrowers to get an interim order in a proceeding under section 17 of the 2002 Act. Full stop. In any event, comma, the statutory outer limit is long past. Full stop. As such, comma, WPA 3040 of 2023 is disposed of by directing respondent number 2 to decide to dispose of the pending application of the petitioner bank under section 14 of the Surface Act 2002 against the respondent numbers 3 and 4 as expeditiously as possible, comma, positively within 3 weeks from date. Full stop. No rest to cause administrative. Sorry. Yes. Next.
Much obliged with your
Thank- No.
I took your Lordship, item number 20 is the similar matter, Your Lordship. Your Lordship would.
20 call karo to.
Item 20,
I pay for the.
Borrower has been
petition.
served.
Yes, your lordship, everybody has been served.
For the state. State.
My section 14 application is pending from 8th March 2022, your lordship.
The grievance of the petitioner is that the petitioner's application under section 14 of the Surface Act 2002 is pending since March 2022.
Lordship.
Footstep next para, heard learned counsel for the parties, footstep, despite service, none appears for the borrower, although the state is represented through counsel. Footstep next para, since the statutory period is long over, comma, being 60 days from the date of filing of an application under section 14, comma, but the application of the petitioner has not yet been disposed of, comma, it is desired that the same shall be disposed of by the magistrate within a limited period. Footstep next para, accordingly, WPA 3046 of 2023 is allowed, comma, directing respondent number 2 to dispose of the application of the petitioner bank pending under section 14 of the Surface Act 2002 against the respondent number 3 as expeditiously as possible, comma, positively within 3 weeks from the date of positively within 3 weeks from this date. Full stop, no address to cause, urgent certificate copies. Do it within 3 days, please.
Deeply obliged.
Thank you. Ever original side.
Original side matters, any mentioning? Listed matter item number 1.
I am for the petitioner matter.
Yes.
Lordship, this matter relates to a
LIC, life
LIC.
insurance policy.
This matter relates to a insurance policy. My daughter had an insurance policy. She assigned it to her mother. Mother died, leaving behind a will.
Leaving behind a will.
Will. Under the will, the petitioner is the beneficiary. The will was probated. The will was probated. There was a mistake in the policy number in the affidavit of assets that was subsequently amended.
No, daughter was the policy holder.
Daughter was the policy holder.
After daughter,
daughter assigned it to the mother.
Assigned to them. Right.
Assigned it to the mother. Mother died.
She left a will. You are the beneficiary.
I am the beneficiary. But now, after the maturity, I am claiming the money. LIC says that but one after the other, they say that give me the original will. Well, the original will was lost. There is an FIR to that effect.
No probate, naturally.
No, probate was granted. The original probate was lost.
Oh, I see.
The probate was lost. We obtained the certified copy. We handed over the certified copy to them. But they still don't release the money to us. This is my basic grievance. I am the beneficiary.
Was the LIC policy specifically mentioned in the will?
Yes, yes. No, not specifically mentioned in the
All
will.
properties.
All
movables.
properties. My lord, it mentions, I'll just show to Lordship. My lord, Lordship will kindly come to page 39. My lord, it says that, my lord, Lordship will see.
39 years. C.
C. Your Lordship will.
I'm seeing C.
Yes. Lordship will kindly see the words, my lord, 4th line. Provident fund, account, loan given, receivables, as well as my movable fixed assets, ornament, jewelries, personal and other movable assets will belong to my husband, Mukesh, absolutely. If my husband dies before me, in that case, all the movable assets will be bequeathed in favor of my only son, Abhishek, absolutely. My lord, the husband remains. The second part does not come into the question. My lord, this is the situation. But
what about the assignment of by the daughter?
The assignment is at page 28, your lordship. 27 and 28, if your lordship kindly takes.
So this is in the format of the corporation.
It's their own format. But I give to them. There is no objection to this. Now, when the beneficiary asks for the money, after the maturity, they say that, my lord, give me the original will. We give them the certified copy. The original will is lost. The police complaint is there. My lord, the
certified copy you have produced.
Certified copy I have produced. But this is the
Yes, Mr.
My lord, we have no problem, my lord. Only one hurdle, my lord, which we are facing. My lord, the executor was, my lord, if my lord turns to the will for once. My lord, the executor named is Mr. Salen Bansal. My lord, kindly turns to page 49, typed copy of the will, my lord. Soilen Bansal, Salen
Salen. Page 49.
Page 49, my lord, paragraph.
Soilen Bansal, yes.
Yes. My lord, under the Indian Succession Act, my lord, we being an authority, my lord, kindly see section 333. So that is the only objection I have. If they can produce this, my lord, we have no objection.
It was never distributed by the executor.
Yes, my lord,
Inventory
final
filed.
assent has to come.
The inventory has been filed, page 90, page 71, I apologize.
I'll check.
My lord, may I have.
Yes, please hand over you.
Madam, will you have
Nothing.
assent by the executor has to come, my lord, the last one, 333. my lord. Otherwise, my lord, the title is not perfect.
Thank you. এটা ওনাকে ফেরত দিয়ে দিন তাহলে। One relaxation is there.
Yes, my lord.
In the section itself. Unless the nature or circumstances of the property require.
And my lord, this Soilen Bansal, my lord, is not resident of Kolkata, he is residing at Maharashtra, if I am not wrong, Mumbai.
Yes, can you produce something from your executor?
My lord, my instructions are that the assent has been filed before the department. My lord, the inventory list is there, which has been filed before the court after the probate was granted. We have to be filed in terms of the original side rules.
Inventory list is not exactly assent. Although
my lord, the entire exercise is complete. My lord, I have asked for a prayer to produce it because it's in the same court in the original side itself. The probate was granted by this honorable court. The lordship will call for the record if so required. My lord, if there is any doubt in the mind of this honorable court, my lord, the lordship will call for that record of
The original
PLA.
assured is living. My lord, and my lord, as the original assured was living, my lord, it has been assigned to the mother. Now, mother gives a will in favor of his husband. Now, my lord, that's perfectly fine. We are not disputing that. But the assent has to come. Otherwise, my lord, we will be in a trouble. My lord, if this assent doesn't come from the end of the executor. Because he has to, my lord, because
the executor.
Because the will, my lord, doesn't contain the policy itself. My lord, it's a part, my lord, later on being in the assent, in the affidavit of assets might be. But it's not forming a part of the will. My lord, the mother doesn't specify the policy number in the will.
May I just humbly submit one thing? When a probate is granted, citations is issued. The daughter was issued the citation, the affidavit of assets was given to the daughter. When no objections were raised, this was passed. The probate was granted uncontested as a non-contentious cause. Perhaps LIC cannot go behind the probate today.
No, I'm not going. You know, I'm
But
saying that's why.
They say that the original policy holder is still alive. That is their will. They have granted. She has assigned it. Now the mother has expired. The father. It's within the family, and no, it's an uncontested will, uncontested probate. It's a non-contentious cause. The probate was granted. And the assent to legacy is a mere formality. The probate provides for that. The probate provides that I am the beneficiary of all of the assets. But perhaps it doesn't lie with the LIC to go behind and say that I will not give you.
Last objection টা দেখাতো। In ombudsman না, ombudsman। কত page হবে? করতেই পারছি না। But that was even not the case. Kindly, Lordship will take page 126 for a moment.
অসুবিধা কি থেকে একটা চিন্তা আসলে আমার কোনো অসুবিধা আমি তো অবজেক্ট করছি আমি তো বলছি উই আর নট অবজেক্ট না লিভিং এর অথরিটি এই জায়গাটায় পারফেক্ট না হলে আমরাই পরে ফেসতে হবে
Can you produce an assent of the executor?
I can produce that.
If
But it
if
should
it's
be
a
filed with
notarized
the-
document, if you can send from Bombay or wherever he's residing, I can keep it after 2 weeks. Because there is some doubt, 332, if you come to section 332, the first illustration, I mean, it's similar. Bank has no authority to deliver the securities nor be a right to take possession without the assent of the executor.
Without the assent of the executor. May I just?
There is
Madam, if
some
you-
doubt.
Madam, yes.
So it can be resolved. If you cannot, then we can go into that question and I'll have to decide.
No, Lordship will kindly also consider
Yes.
333 2.
Maybe verbal, yes.
My lord, and that is nowhere their case even, my lord, prior to this, today, this point on the has been taken. Lordship will kindly take page 126 for a moment.
It may be either express
or
Here it is
implied.
not express or implied from the conduct of the executor or administrator. What do we know of the conduct of the executor? And if he gives in writing, even if a notarized document is given, that would suffice.
But I will have to. But may I put it this way, my lord? My lord, they might be apprehensive of the fact there might be a counter claim or a counter from somewhere. I can provide them an indemnity of equivalent sum if they are ever faced with it. But in that circumstance, they will be protected.
My lord, may I just indicate one thing, my lord, what he's saying, my lord, that can be done, but only problem is if assent is not in the probate code, the probate is not complete. My lord, there is a provision, the probate takes a back seat if there is no assent. Because the title doesn't get perfected.
That may be verbal also.
Yes, verbal. That's why I'm saying let Silent Bansal Millard communicate by letter from Maharashtra through email to us. Problem ends there.
Do you have any difficulty there, Mr. Kore?
No, I
Can
don't
you
have
take
any
instruction on
difficulty,
that?
but my lord, Lordship will kindly appreciate for 5 lakhs today if the brother-in-law of the petitioner, the executor is the brother-in-law of the petitioner. I have specifically taken an instruction on that. It is within the family. But what my learner, and also that is not their case even. But Lordship will kindly take page 126 for a moment. They always wanted the certified copy. They wanted the certificate. May I put this question? A seal has been granted by this honorable court on a will. And they say, no, you get one more thing from there. The question of perfecting the title, it can be implied, it can be non-implied, it can be within the, but there is no objection ever.
332 is also very clear. The assent of the executor or administrator is necessary to complete a legatee's title to his legacy.
My lord, Lordship will kindly.
You are the legatee.
My lord, Lordship will kindly. The legatee will be the daughter. No, the daughter's
You have
son.
got it.
The daughter's son and the husband.
You are the legatee. The legacy has been given to you.
A legacy has been given to me by under the will. I'm the beneficiary to the will.
Yes, beneficiary is the legatee here.
Yeah, Lordship will kindly.
You are the legatee.
I am legatee.
For your title to be complete, the assent of the executor or administrator is necessary to complete a legatee's title to his legacy. You are claiming a legacy on the basis of that will.
But that
or probate.
That is perhaps in my understanding is that is during the completion of the probate or the administration of the assets. Once the administration has been completed, and the same is with the department. My lord, perhaps that portion has come to an end. My lord will kindly appreciate a situation where the maturity would have taken 5 years from today. Then in that case, my lord, the administration and I would be having the right in claiming the maturity amount. But and the similar situation has happened. Will probate have a presentation? But and the probate was granted in 2017.
I'll allow your application. I'll allow the request. That will safeguard all your.
Yes.
The petitioner contends that the petitioner's daughter had opened a policy with the respondent corporation, which was subsequently assigned and gifted to the petitioner's wife. Full stop. On the demise of the petitioner's wife subsequently, she left behind a will where the petitioner was the beneficiary. Full stop. A probate of the said will was obtained in the year 2017. Full stop. Thereafter, the petitioner applied for disbursal of the amount of the policy in respect of the policy in favor of the petitioner on the strength of such probated will. Full stop. Next para. Since the original probate had been lost, upon being asked to do so by the LICI, the petitioner obtained a certified copy of the same and produced it before the LICI. Full stop. However, subsequently the LICI has not disbursed such amount, for which the present writ petition has been filed. So next para. Learned counsel appearing for the LICI places reliance on section 332 and 333 of the Indian Succession Act 1925 and submits that.
Lord, may I just say one thing, Lord? I would thank my learned friend, Lord. There was an amendment carried out in the probate. Initially, the policy number was different, in which the affidavit of asset was filed.
6 and 8.
My lord, that has occurred. My lord, that created much more confusion and called for the assent.
I don't understand.
My lord, the policy number was, my lord, last ending with 1.
After the arguments are over, I'm passing my order, Mr. Chatterjee.
My lord, I'll just clarify. There was a mistake in 116 was written as 8 in the affidavit of assets. When I submitted the affidavit of the probate and the affidavit of assets, they said that
probate was granted in respect of the right policy number.
No, policy thereafter that wrong policy number. Thereafter we filed an amendment application before this court with the policy saying that this policy was number was, but the 6 and 8. I can show it to your lordship.
No. After the probate was granted.
After the probate was granted.
What did you do after that?
I filed an amendment up to the application to the affidavit of assets. That was allowed, and amendments was carried out. Without,
ঠিক আছে কোনখানটা ছাড়লাম 332 and 333 of the Indian Succession Act 1925 and submits that unless an assent to the legacy is given by the executor, who apparently resides in Bombay, the LICI cannot release the amount in favor of the petitioner on the strength of the will. For next para, it is further contended by the LICI that subsequent to the probate being granted, an amendment was carried out to the affidavit of assets at the behest of the petitioner, which pertained to the number of the LIC policy, which is also one of the reasons for the bank having an apprehension in that regard. Next para. Learned counsel for the petitioner, in reply, submits that the appropriate stage for assent being given to a legacy is prior to the probate being granted. In any event, it is argued that upon the grant of probate by a competent court, the assent to legacy cannot be a deterrent in the LICI releasing the amount in favor of the petitioner. Next para. cannot be a deterrent. না কি বলে অ্যাসেন্ট টু লেগেছে বলুন একটা জায়গা cannot be a deterrent 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 তারপরটা কি বলছেন assent to deterrent deterrent to the petitioner claiming on the basis of the will. Full stop. Next para. A perusal of the will, comma, a copy of which is annexed to the present writ petition, comma, indicates that although the LIC policy in question was not mentioned in specific terms, comma, one of the phrases used in the will was within double inverted other movable assets, double inverted clause, which, comma, obviously, comma, also pertains to the LICI policy. Full stop. Next para. As regards the amendment of the affidavit of assets regarding the number of the policy, comma, since such amendment has been granted duly by a competent court, comma, the same cannot be reopened at this juncture and relates back to the date of grant of the probate. Full stop. Hence, comma, the mere fact of such amendment being carried out cannot give rise to any unnecessary apprehension in the mind of the LICI authorities with regard to the veracity of the claim of the petitioner. Full stop. Next para. Insofar as the assent to legacy is concerned, comma, the language of section 332 is that the assent of the executor or administrator is necessary to complete a legatee apostrophes title to his legacy. Full stop. Section 333 provides, comma, in subsection 1 thereof, comma, that the assent of the executor to a specific bequest shall be sufficient to divest his interest as executor and to transfer the subject of the bequest of the legatee, comma, unless the nature or the circumstances of the property require that it shall be transferred in a particular way. Full stop. Subsection 2 provides that the assent may be verbal and it may be either express or implied from the conduct of the executor or administrator. Full stop. Next para. A composite reading of chapter Roman 8 of the 1925 Act, comma, which pertains to assent to a legacy by an executor, indicates that there is no hard and fast rule that the assent of the legacy has to come in writing or in an express manner. Full stop. Next para. In the present case, comma, the mere fact that the probate was granted as long back as in the year 2017, comma, that too on the probate application of the executor himself, comma, leaves no manner of doubt pertaining to the executor not being opposed to the assent of legacy, assent to legacy. For sub next para, section 335 of the 1925 Act contemplates that, section 336 of the 1925 Act contemplates that the assent of the executor to a legacy gives effect to it from the death of the testator. Full stop. Section 337, on the other hand, comma, provides that an executor is not bound to pay or deliver any legacy until the expiration of 1 year from the testator apostrophe's death. Full stop. Section 337, comma, thus, comma, does not put any fetter to the assent being given either prior or subsequent to the probate being granted. Full stop. Next para. In the present case, comma, from the conduct of the executor throughout, comma, in filing the application for probate, obtaining the probate, and subsequently not opposing the claim of the petitioner at any point of time before any forum, sufficient to indicate that there was implied assent to legacy on the part of the executor. Full stop. As such, the respondent authorities cannot, on the pretext of non-production of assent to legacy specifically, withhold the dues of the petitioner as the legitimate owner of the amount due to the petitioner in terms of the policy in question. Full stop. Hence, WPO 1489 of 2023 is allowed, thereby directing the, which respondent should I direct, Mr. Chair? Respondents, I am keeping it vague.
Yes, yes.
Thereby directing the respondents to disburse the amount due with regard to the policy in question in favor of the petitioner as early as policy number ta diye din. Policy in question na ki bollam? Question bearing number 4151-07180 in favor of the petitioner at the earliest, positively within 3 weeks from date. Full stop. No rest to cause.
My lord, this observation, my lord, should not be a precedence for every case because situation may differ from
The question of
Can-
his lordship has decided
report.
by the affidavit of service. Item number 2, obliged Sri Oshini Kumar Damani versus State of West Bengal and others.
Yes.
Hello, so the petitioner is an LOT, my lord.
Lord, I am for the respondent number 5.
My lord, it's a maintenance society called, my lord, Marshall House, my lord, Owners Association, my lord. They maintain the society. My lord, I have,
Petitioner.
yes, the petitioner is a LOT. He is
Oh,
a-
you are an LOT, right?
I'm an LOT.
Yes.
Now, my lord, there is, my lord, I have alleged.
Mr. Bandapati, you are for?
Lord, I have, my lord, I cannot say I am appealing for respondent number 3 because
But
it will
may
be
I-
barred by section 19. It's not a juristic person, it's not a body corporate, or a no, it is maintainable against that society. I am appealing for the respondent
Lord,
number.
I have for the timing, I have given my lord, I have a grievance. My lord, I have given my lord to my lord a complaint saying, my lord, there is a basically misappropriation of funds and the society is not being managed properly. My lord, I pray, my lord, good, bad, indifferent, my lord, it's my lord prayer that there should be an inquiry. For that, my representation, my lord, I have given a representation. It can be considered, it can be rejected, it can be partly allowed. My lord, those are at page 112, which is, my lord, a complaint dated 20th of June 2023. And the second complaint, it's 7th of July 2023 at page 123. Let the-
123 is more elaborate, I suppose.
Yes, my lord, kindly, my lord, consider it, my lord. That's all my prayer. I have nothing else, my lord.
Very. 112 and
We have a
11
second round of litigation on the order, whatever is the subject.
No, my lord, I have,
112 and 123 pages.
Yes, 112 and 123. So
my
far,
lord, I have objections, my lord. This rate is not maintainable, my lord, on 2 aspects. Section 23, if your lordship says, my lord, that is the power of government suo motu. No applications, no, nothing is required. So they have no legal right, my lord, to ask for a writ of mandamus, my lord, inviting government to initiate an inquiry. That is one aspect, my lord. The other factual backgrounds, my lord, there are suits, my lord, by the, it's a Devottor property, entire Marshall House, my lord, they filed a eviction suit, my lord, against the original lessee. There was a sub-lessee also. My lord, sub-lessee was subsequently added to the suit. They got an eviction decree against those smaller lessee and sub-lessee without making 800 my lord, occupiers of the Marshall House as parties, my lord, to the suit. And there was no disclosure because this property was developed, my lord, at the cost of these 800 my lord, occupiers.
Sir,
My
I am
lord,
all
the
right, I don't-
petitioner claims to be one of those allottees.
kindly have a look.
My lord,
at-
may I just?
My lord, no, my lord, let me.
My lord, this is an execution proceedings, my lord. It is being going on, my lord, before the executing court, but where serious objections has been raised. My lord, the rent has been, my lord, the owners, my lord, or my lord, our, my lord, this, my lord, our landlord, my lord, who was a, my lord, sub-lessee, my lord, he stopped taking rent. Well, the rent was being accumulated.
The civil suit is for what relief?
My lord, eviction.
Evictions of the lazy and the my lord, his sub-lazy. Now the sub-lazy made the constructions, my lord. Sub-lazy made the constructions. My lord, we are the
Come back, please. Yes. Yes, Mr. Wanda.
sub-lazy made the constructions, my lord, at our cost. My lord, we are given, my
That is
lord.
not the merits of that.
No. Then this execution filed, my lord, they wanted to evict all these 800 occupiers, my lord, without, my lord, there being any whisper in respect of, my lord, say such occupiers. My lord,
That's point number 4. Who are you?
my lord, I am the now the occupiers associations, my lord, secretary. I am the president.
So what is your, why are you shying away from this inquiry?
My lord, because it will create a precedent because, my lord, they cannot have an order.
As a section 23.
Take, my lord, section 23.
Where on information received. I have.
And there is certain allegations, my lord, which are,
Thank you.
my lord, that
Kindly
I
have a
need
look.
to, my lord.
The, my lord, investigation regarding
So
the.
very well, let him finish, Mr.
Yeah.
Ghosh, please take your seat. Yes, Mr. Bandhavada, let us see 23, whether they can.
Yes, my lord, 23 kindly take, my lord.
Yes.
There is only provisions, my lord.
Where
No,
on
no right
information-
has been vested under the act, my lord, to any of its members. All rights, my lord, claiming through the rules. Now, kindly 23 investigation, where on information received, the state government is of the opinion, my lord, that there are circumstances suggesting that the business of the society is being conducted with the intent to defraud its creditors. No question, members or any other persons. My lord, this is an actions, my lord, to be taken by a suo motu. My lord, there are judgments. My lord, I just received the brief, my lord, at 1 p.m. My lord, the court had considered and court found, my lord, this claim cannot be made by, my lord, before a writ court by a member. Because no right has been vested on a member that they can ask the government to carry out investigations. My lord, it has been settled now. My lord, I am not shying away from the inquiry, my lord, because I know, my lord, these proceedings is initiated to frustrate me in the execution case.
Obviously.
My lord, that is the proceedings.
But they have a legal right to do that, why can't?
My lord, they are the, my lord, representative of the actual owners, my lord, who want to redevelop.
I don't know who is representative.
Yes,
of-
my lord, that I know. Because the next week, my lord, this probably on 24th, this is fixed. 24th, it is fixed. So I say, my lord, there's no right, legal right vested upon
Here
it.
it is stated there, here it is provided that whereon information received,
That is
the state government is of opinion that there are circumstances suggesting that such and such.
Yes.
Now, they have given you information. It is for the, not you, the state government. It is for the state government to observe that whether they are of that opinion that there are circumstances.
Yes,
If they
but
say no,
there's
they'll reject.
My lord, no, my lord, a person's can, my lord, starting from 1977 Supreme Court, a person's can ventilate his grievance, my lord, asking for a mandamus when he must show that he has a legal right which has been breached.
He has an apprehension of mismanagement
My lord, there is
and
no
fraudulent
my lord,
activity in the society.
my lord, there is no such right has been vested on a member. My lord, it's my submissions, my lord, I can, my lord, if you also kindly take this map next week, my lord, I can produce the judgment also, my lord, to
Come back
support my
tomorrow,
court.
Mr. Bandhavada, you are fairly ready in the matter.
My lord,
So just-
I've
just
never,
cite a-
I've even not even gone through these.
No, these
But,
the allegations, yes.
My lord, tomorrow, or I can try.
Day after tomorrow, come back.
From day after, my lord, Thursday and Friday, I'm not here, my lord, only that much.
Mr. Bandhavada, let us to take a chance tomorrow then.
Tomorrow,
just cite those judgments that they don't have a right which has been infringed.
Yes, I'll cite it.
For invoking the writ.
Yes. Two judgments I'll be citing. One is 1977 Supreme Court, another is, my lord, of.
If you have the page numbers, you can give the page numbers. I'll close arguments and.
My lord, I was just searching from my phone because I had taken a note, my lord,
Come
copies
back,
are also
Mr. Ghosh, come back tomorrow. Prima facie, I'm satisfied that up to this stage, at least the court can direct. Subject to what you cite, if you cite judgments which bind me, then definitely.
Yeah, no, my lord, I'm not, my lord, this is a, my lord, my defense.
No, this is not my opinion yet. I have not formed an opinion under section 23. I have an opinion that opinion has to be formed.
Only thing
I have given an information, my lord, state.
Yes,
government
whether
may
this
say, I
can
would
be
have a local.
this can be taken up as an information, and I'll record your other submissions. They have been set up and all this. I'll record those submissions and deal
because
with those.
these decisions, the discretion vested on the state, my lord, to form that opinion. But I would say, my lord, no one can ask for a writ court,
So,
my lord,
about
to direct government.
the difficulty is if there is an apprehension. I mean, this discretion being vested on the state government is the reason we are here.
Yes, but
writ courts are here. Not only the state government, the central government.
my lord, I'm just
discretion being vested on the governments. That is what is our food. the food for writ courts.
But
That is
yes,
the precise reason we are here.
obviously,
So
but
this discussion has to be seen. It has to be seen whether it has been reasonably.
yes, but one should have a legal right, my lord, to ask for a writ of mandamus.
Undoubtedly.
I have asked for.
Has to have a legal right.
I have.
Yeah, let-
Otherwise, at the drop of a hat,
No, let them
mandamus
show,
can.
my lord, this is not a legal right vested
right,
upon him.
You're right.
I have given a complaint, my lord. He may say, my lord, I don't have a.
No,
locus.
let me see the judgments
Very
first.
good. May I file the affidavit of service?
Acha, learned counsel for the learned counsel for the petitioner
Affidavit of
submits
service.
that the petitioner has raised certain grievances which are required to be uh, investigated into by the state government under section 23 of the West Bengal Societies Act 1960, Societies Registration Act 1961. Full stop. Learned counsel for the respondent number 4.
I cannot say I am appearing. Order 1, Rule 3, my lord.
4 you are
deferred me.
appearing.
Yes.
Learned counsel appearing for the respondent number 4 objects to the maintainability of the writ petition. Full stop. First, it is contended that section 23 does not confer any right on a member of a society to come up and seek a writ of mandamus on section 23 of the 1961 Act, since it is the discretion and the prerogative of the state government, if of the opinion that there are circumstances suggesting the fraudulent or other actions as contemplated therein, to take necessary steps. Full stop. It is further contended that the writ petitioner is seeking to frustrate other proceedings. Full stop. Next para, learned counsel for the petitioner controverts both the said suggestions. Full stop. However, at this juncture, learned counsel for the respondent number 4 seeks to place reliance on certain judgments on the proposition as forwarded by him regarding the non-maintainability of the writ petition. Full stop. Next para, to enable learned counsel to cite such judgments, let the matter stand over till tomorrow when it will be listed under the same heading.
Grateful.
Anything, my lord, kindly record that.
Affidavit of size filed to be given.
My lord, I am for the respondent number 5. I am no more the treasurer.
You are no more?
Treasurer. I have resigned. Kindly record my
No, after committing the mismanagement or
No. Before.
No, the state is not. State is not.
before
appealing.
committing the mismanagement. Anyway,
I
that
have nothing. I have
no, I'll record everything and when I oh, sure.
No, the state is not represented. I don't know whether it is state.
State is not being represented. From the morning, I'm seeing only one person I could rope in, Mr.
State
Chatterjee.
party too.
State is the necessary party.
Grateful. Item number 3, Subroto Goswami versus the State Chief Information Commissioner, West Bengal.
Yes, Mr. Shah, what is the matter?
I get to it for the respondent, the West Bengal
Yes,
Information
you are for the
Commission.
petitioner.
A
Yes,
very
Mr. Bhatt.
innocuous prayer for disposal of my second appeal presented under section 19 subsection 3 of the Right to Information Act, my lord. Lord, I'm guided by 2 judgments of this honorable court, wherein this honorable court had held that any appeal presented before the respondent under second appeal under section 19 subsection 3 is required to be disposed of within 45 days, my lord.
How long it is it pending now?
Yes, my lord, it's pending now. my lord.
How long?
My lord,
More than
mo-
45.
more than 45.
In the month of June, my lord, the matter has been filed.
8th.
But apart from the fact, my lord, the statute is absolutely silent. So far as the, my lord, second appellate authority is concerned.
Yegulo din.
My lord, so far as the
First
first
judge-
authority, that is the SPIO.
Cite the judgment,
No, no, no.
Shah, then. Yes.
2 copies of the same judgment has been given to.
Yes.
My lord, first judgment has been delivered on 20.
May I have a copy?
Yes.
Yes.
My lord, on
Sure.
7th of July 2010, my lord, regarding the same issues, regarding the pendency of the second appeal under section 19 subsection 3. If my lord will take up second page, last paragraph.
Yes.
In my opinion, keeping in mind the respective maximum periods fixed for deciding a first appeal under section 19(1) and disposal of a request for obtaining information under section 7 of the second appellate authority should have decided the second appeal within 45 days.
Reasonable period.
Now, my lord, the second judgment, my lord, I would like to cite, delivered on 24th July 2012, my lord, relying on the same said judgment.
You are the architect of this.
Myself, I appeal, my lord. My second paragraph, my lord.
Yes.
The learned advocate representing the petitioner cites an unreported decision of this court dated so and so.
Yes.
The learned judge, bearing in mind the statutory provision in the act requiring disposal of a request for information as well as first appeal, preferred against the decision declining to furnish information or failure to decide an application for information.
How many days have elapsed, Mr. Patori, in your case?
Month of
It
June,
ought-
my
it
lord.
ought to
They
have
have
been,
No,
it
we-
was filed on 8th of June and ought to have disposed on 23rd of July. 8 June to 23rd July expires 45 days, my lord. And this writ petition was filed on 16th of August.
Yes,
No, my submission, your
judgments are
lordships,
there.
my lord, this is a judgment of a coordinate bench. Your lordships have every right to, my lord, to differ with this. my lord.
Otherwise, I'm bound unless I give the reasons for
Yes,
that.
why I'm submitting before lordships, my lord, the statute has been, my lord, framed very, my lord, reasonably. The statute says the first authority should be, should consider the application for Right to Information Act within 30 days. First time authority is the SPIO, that is under section 6 and 7, lordship. The second authority, that is the first appellate authority, the statute says they will also, my lord, consider the first appeal within 30 days. Extendable period is 15 days, that is within 45 days. But very carefully, my lord, the legislature doesn't, my lord, mention any time period for the second appellate authority. Why, my lord? Since, my lord, the first authority, that is SPIO, and the second authority, that is first appellate authority, they are also only, my lord, considering or dealing with the right to information applications with regard to particular department. But so far as the second appellate authority is concerned, my lord, they are taking up the entire state of West Bengal, entire departments, all the, my lord, local bodies, everybody's. Now, my lord, there are other practical impediment also, my lord. So far as the statute is saying, my lord, the constitution of second appellate authority should be 1 chief information commissioner and up to 10 information commissioner. But right at this moment, my lord, we have 1 chief information commissioner and only 2 other information commissioner. So, my lord, that is why, my lord, the second appellate, the statute is absolutely silent about the, my lord, time period mentioning with regard to the second appeal to be disposed of. Number one. Number one, there are other practical impediments which your lordship knows for the last 1 year, my lord, the second appellate authority was not functioning. But on a regular basis, so many second appeals are being filed before the second appellate authority. So right now, my lord, we are taking up the second appeals, my lord, chronologically. But sometimes, if any kind of, my lord, serious or urgency can be pleaded by the applicants before your lordships, given 3 months, 4 months, even 2 months time period has been given for a particular case. Considering he is a senior citizen, considering that he is, my lord, preparing an application with regard to his, my lord, employment, any examinations relating to recruitment. So considering these aspects here, lordship, time to time, several other coordinate benches also time to time given us time. Sometimes it is 4 months, sometimes it is 3 months that we are supposed to conclude this second appeal within this period. But if any this kind of, my lord, order in rem, my lord, that second appellate authority has to complete all these things within 45 days, my lord, it will be really, really difficult. The courts will be flooded with contempt applications, lordships, since it is not possible.
This is a retired person of 70 years.
Senior citizen, 69
Yes.
years.
This
Super
can,
senior, 70 years.
super
So
senior.
that writer is there.
But so far as the application is concerned, my lord, kindly, if your lordships kindly see what he is.
You have a point regarding this, the decision, this ratio laid down in these judgments. You have a point there, but I don't want to distinguish. I mean, don't want to differ and refer this.
Kindly see the
This
application.
issue need not be referred to the.
There is another way, my lord. The first appellate authority has not, my lord, applied his mind. He is silent. So if your lordships can easily direct the first appellate authority, since the statute is also saying that he is.
So what was the decision of the first appellate authority?
No decision.
There is
The first appellate authority has given some decisions that these queries are, my lord, they are restricted under section 8 and everything.
First authority or first appellate authority?
First authority has given the decision that you are not
First
supposed to get.
authority
Is silent.
First, the very first authority, SPIO. SPIO refused on
Refused?
giving ground.
Yes.
First appellate authority, what did the first appellate authority?
The appellate authority has, by issuing letter, had declined to furnish me the information. Now, the second appellate authority has not given any decision, my lord. And that is also a ground for filing a second appeal under section 19 subsection 3.
Yes.
Now, where is the rejection of first appellate authority?
No, it specifically states that a second
there?
appeal against the decision under subsection 1.
He's not on that. He's trying to cut short the matter shorter for you.
My lord.
I mean, first appellate authority was, what was the decision of the first appellate?
First appellate authority had not at all decided, my lord. No communication has been received, my lord.
Have you annexed that?
My lord, decision of the SPIO have been annexed. I have categorically.
Have you got a copy of the first appellate authority?
Yes, my lord, that has been annexed.
That is annexed, Lordship.
Show me that.
So that is at page
First
number.
authority, not the SPIO.
Yes, my lord.
First appellate authority, Lordship.
Right.
Page 22, Lordship.
No, page 22 is my RTI application. The appeal is at page number 25.
25 is the first appeal, right? Right.
The decision of the appellate authority.
No, this is my first appeal, my lord. No decision have been given by the first appellate authority. That is also a ground for filing second appeal.
Because it is pending before the first appellate
Yes,
authority, you
yes.
have taken out the second.
Yes,
Second,
yes.
because this is a ground. If the first.
Very well. I'll render you a second appeal infractus. I'll direct the first authority directly to decide.
My lord will kindly consider 19 subsection 3. My lord permits me, may I place 19
No,
subsection?
no. I'm allowing you second appeal.
My lord.
Virtually from here.
My lord.
I'm rendering it infractuous means I'm allowing that. I'm directing the first authority because first authority undoubtedly is duty bound under the act to do it within 45
Within
days.
a
No, my lord.
45 days.
Now, the act also says that if the first appellate authority did not consider the request or fail to provide a appeal, dispose of the appeal, I had a right to file a second appeal and make a complaint to the second appellate authority. Now, my lord, my agony is that since the first appellate authority is also from the same public authority and the SPIO has already given a reason that he will not be furnishing information. So it is very unlikely, my lord, that the citizen will be getting information from the first appellate authority.
No, you cannot proceed on that presumption.
If my lord,
It's a statutory authority. It's a
my-
statutory authority.
but my lord will consider the wordings of section 19 subsection 3, my lord.
Show me that.
My lord.
But that is there.
My lord, may I?
Yes, Mr. Patwari.
19 subsection 3 of the Right to Information Act. A second appeal against the decision under subsection 1 shall lie within 90 days from the date on which the decision should have been made. The word used is should have been made or was actually received with the Central Information Commission or the State Information Commission. So the statute was very conscious of the fact that if the decision is not made within a 90 days, then the applicant can move the second appellate authority.
Yes.
The word is should have been made. Should have been made, either made, not made. So in this case, no decision was made by the first appellate authority, which prompted me to apply under section 19 subsection 3 before the second appellate authority.
So do you presume that the second appellate authority, or do you say that the second appellate authority will decide your first appeal?
No.
Merits.
Second appellate authority.
What is the best order you can get from the second appellate authority?
I can guess.
Direct the first appellate authority.
No, let him argue, Mr. Sir.
The second appellate authority, my lord, will
direct, yes.
will direct the SPIO to furnish the information which I am seeking, which in my very humble submission falls under the definition of information under the RTI Act.
That the first appellate authority can also do.
No, my lord, if matter is
I'll direct the second appellate to her.
grateful,
Act order name.
grateful, lordship.
Learned counsel for the petitioner contends that the petitioner's second appeal under section 19 within bracket 3 of the Right to Information Act 2005 is pending for more than 1 month above the time limit of 45 days after preferring the same. Push up
No,
by
time limit nowhere mentioned, my lord. That
by citing 2 judgments of coordinate benches of this court, learned counsel for the petitioner argues that the reasonable time limit for deciding a second appeal should also be construed to be 45 days. Full stop. Next para. It is argued that the petitioner is a septuagenarian person, septuagenarian retired person, and as such, is suffering unnecessarily for the delay caused by the second appellate authority in deciding the issue. Full stop. Next para. Learned counsel for the
second appellate authority.
second appellate authority submits that the ratio sought to be relied on by the petitioner is contrary to the statute. Full stop. It is submitted that the silence in the statute regarding any time limit for deciding a second appeal is deliberate and justified, since whereas the SPIO and the first appellate authority deal only with information regarding a particular department or branch, the second appellate authority deals with appeals from the entire state and as such, has to process numerous bulk of applications as compared to the other two authorities. Next para. That apart, comma, it is argued that the second appellate authority was without any official for a considerable period, without any chairman,
Yes, Chief Information Commissioner.
without any chief information commissioner for a considerable period of about 1 year, comma, for which there is a huge backlog already in place. However, comma, the second appellate authority is trying its best to resolve the pending appeals serially, comma, as early as possible. Next para. It is further contended that the second appellate authority is short of manpower and, comma, as such, comma, ought not to be directed to dispose of any second appeal within a very short period. Next para. Learned counsel for the petitioner submits that the grievance of the petitioner is that the first appellate authority did not advert to the specific provisions of the statute or the facts of the case. As such, comma, the petitioner seeks to redress such grievance before the second appellate authority itself, comma, as provided in section 19 within bracket 3 of the Right to Information Act 2005. The language of the said subsection is, comma, in the interpretation of learned counsel for the petitioner, that a second appeal lies within 90 days, double inverted day, from the date on which the decision should have been made, double inverted clause, or was actually received. Hence, comma, a situation as the present one, comma, where the first appellate authority failed to decide on the issue in time, comma, also furnishes sufficient ground for the petitioner to ask the second appellate authority to pass an order on merits against the order of the SPIU. Next para. Be that as it may, comma, although there may be some justification in the argument of the petitioner on the question of there being no statutory period for disposing of a second appeal, comma, which might be justified in view of the nature of functions undertaken by the second appellate authority, comma, the jurisdiction of which pertains to the entire state, comma, as opposed to the first two authorities, comma, since the petitioner in the present case is around 70 years of age and is a retired person, comma, it is expected that the second appeal pending at the behest of the petitioner is decided expeditiously. Next para. Hence, comma, even without going into the question as to what would be a reasonable period for disposal of the second appeal in the facts and circumstances of the case and the inconveniences cited by the respondent authorities, comma, the second appellate authority ought to be directed to decide the second appeal of the petitioner within a short period, Accordingly, WPA 1512 of 2023 is disposed of by directing the respondent, that is the State Chief Information Commissioner, comma, West Bengal Information Commission, to dispose of the second appeal pending at the behest of the petitioner under section 19 within bracket 3 of the Right to Information Act, comma, 2005, comma, as expeditiously as possible, comma, positively within 2 months from date, comma, in accordance with law. No address to cause certain.
Grateful.
এটা কি আমাদের বই?
Item number 4, Rosal India Limited and another versus the T-Board of India and others.
My lord, I appear for the petitioner, my lord.
I beg to appear for the Union of India, respondent number 3.
Right.
Service, my lord, I have served on.
T-board has been served.
Yes. Yes, my lord, please.
Yes.
18th of August, they have received by hand, it was served, my lord.
Right.
My lord, tea gardens, my lord, are usually, my lord, entitled to, my lord, under a scheme, certain subsidies and incentives. My lord, this writ petition challenges, my lord, an order of the, my lord, tea board, my lord, refusing to grant the subsidy. My lord, the procedure is that we need to apply under the scheme. The scheme postulates the mechanism. Under the scheme, we apply, and if we are found eligible in the form of disbursements, my lord, subsidies are granted. It is, my lord, this writ petition pertains to only one period, July 2018 to December 2018, for which, despite my application, despite making the, my lord, payment of the application fee, my lord, I have been denied the subsidy. Now this, by the impugned order, say that the period is over and we don't have fund. This is really the ground. I am, my lord, only wanting this, my lord, subject to what my learned friend says, my lord. I'll show your lordship why. I would, my lord, prefer the order be set aside and we be given an opportunity of hearing before the T board before they take a conscious decision. Because they admit in 2 emails that not only did I file the app, they received the application, they also admit that I have made the payments. Despite that, they kept, my lord, the matter pending, and only after the period, my lord, gets over, my lord, they say.
The only ground for refusal. That
My
the
lord,
period
the
is
only ground, my lord. Kindly let me just show, my lord, 2 provisions of the scheme. My lord, straight away comes to page 69.
Yes.
2.2, my lord, will find eligibility. Orthodox tea or kind of orthodox tea like and green tea producers owning tea factories within India, holding valid registration under so and so smart card of tea board in case of individual small tea growers are eligible for availing subsidy under the scheme. This is, my lord, the eligibility criteria. Duration activity will be in operation till 31st March. However, applications will be accepted up to 31st January 2020 for the last financial year 2019-20 or any other date specified by tea board. And subsidy at uniform rate of ₹3 per kg of actual production for both leaf and dust grades. This is the rate at which I get the subsidy. And, my lord, the procedure for payment of subsidy, clause E, lordship will find that. The payment of subsidy on production of orthodox tea will be regulated on the following basis. Applicants may submit their application to the nearest field office of tea board for physical verification of the factory and manufacturing records. Claims for half-yearly production, January to June, must be submitted to the field office of tea board latest by 31st August of the year under application. Similarly, for second half-yearly production, July to December, claim should be submitted to tea board latest by 28-29 February of the following calendar year. In case cutoff date of receipt of application falls on board's holiday, next working day will be considered to be the cutoff date. Claims for July to December 2019, which is the last period, my lord, are to be submitted latest by 31st January 2020. Delayed claims beyond cutoff date will not be considered for subsidy and will be rejected and returned immediately by the fielder. So rejection ground, my lord, would be, my lord, if I don't apply within the period. And if my claim is, my lord,
what is this? The second half yearly production?
My lord, it's in 2 terms. For January to
first is 31st August, second is 29th February. 28th or 29th February. Then the last sentence is claims for July to December 2019.
My lord, because, my lord, lordship sees clause B, my lord, duration. That is, my lord, it was for last financial year is 1920. That is why, my lord, this is there.
Yes.
So, my lord, only ground, my lord, on which they can reject is delayed claims beyond the cutoff date. And, my lord, clause 3 provides that inspection at the factory site for big and small growers by tea board official is essential before sanction of claim. Now, lordship kindly comes to, my lord, page 147. My lord, what had happened was they had changed it for a very brief period from the physical mode to, my lord, online mode. And in the portal, my lord, all tea owners need to make this application. And this process commenced for the period from July 2018, my lord, this process had commenced. So the, my lord, glitches is only in respect of, or the glitch is only in respect of one period of, my lord, July to December. Rest of it, my lord, I got it. Even under the scheme. Prior to that, I got it. My lord, only that period, despite my application and despite my payment, I did not get it. And they reject it only on the ground that the scheme is now over. And they don't have fund. My lord, 147, I was, my lord, placing.
Yes. You read from the handwritten portion.
I'll not, my lord. It's actually, my lord, I'll read it for your lordship. It's an email, my lord, not the handwritten portion which is relevant.
Yes.
My lord, it's an email of 27th February 2019, written by my lord, the tea owner to my lord, the also my lord. No, it is Hemchandra Agarwal. Tea board, my lord, the local office of the tea board. This is for your kind information that we have submitted the orthodox subsidy for July to December 18 on 16th February 2019. Within the cutoff date, lordship has found that, and deposited the fees of rupees 5,000 through net banking. However, we have not received any acknowledgement slip for the application submitted. We attach here with the application and the money deposit slip for your kind reference. This, after this email, the documents, application, how it was made from 148, it is there. But I will not trouble your lordship with this because of the two emails where they admit, my lord.
This is from Decom Tea Estate. How are they related?
There are two T, this writ petition pertains to two tea estates. One is Norkhoi Tea Estate, one is Decom Tea Estate. For both the tea estate, the petitioner is the owner. So my entitlement for subsidy is, in respect of these two tea estates, and I applied also for these two. The rejection order is a common rejection order, denying payment.
No, why do I get who communicated that? The tea board communicated this to you?
This is my email.
Oh, sorry.
This is my email. And T-Board's communication, lordship sees the admission, my lord. Two emails I show your lordship. 31st of December 21 at 1:54. There were series of correspondence on the issue. I'm not troubling your lordship with those immediately. Yes. My lord, 1:54. It's a trail mail, my lord. Lordship sees from the, my lord, middle of the page. Yes. Friday, 31st December, my lord, Joydev Shahu is, my lord, from T-Board, writing to us. We have checked and found that both the applications were received and submitted from two different IDs, details of which were shared below. Two IDs because, my lord, from two tea estates, my lord, for the same period. Two tea gardens. This is, my lord, with regard to the receipt of the application, because I said, my lord, they did not receive, my lord, issue acknowledgement slip. Yes. Now, regarding payment, lordship turns page 155. This is 1st February 2022. Again, my lord, written by Joydev Shahu, my lord, of my lord T-Board to us. This is to inform that after detailed discussion with you in the office, we made a thorough search in the database for the case of Decom and Norkhoi applications. As per findings, it is seen that for the period of July to December, you made the payments. However, it was not reflected in the portal. So, my lord, this is, my lord, their ground that acknowledgement I did not get, but application received. Payment I made, they admit, my lord, payment is received, but they say that it was not reflected in the portal. Now, sees, my lord, what stand they take, my lord, for rejecting my subsidy. This is, my lord, in February 2022, last, my lord, after, my lord, series of correspondence, they, my lord, give me a reason why they are rejecting it. Now, impugned order, lordship takes at 191 once. Page 191, my lord.
Yes. Response to
This is because, again, my lord, we had been communicating with them, and in response to, my lord, the last demand justice, this is what we received, my lord. This has reference to your letter dated 25th November 22 on the subject cited above. It may kindly be noted that the board has adopted online system of processing of application of subsidy. It would be evident from the letter dated so-and-so that both the gardens have submitted application for which specifically file number was created, but no acknowledgement was issued, as because confirmation of transactions were pending in respect of bank sent. Now, my lord, the email of 1st February, their email says that payments were, my lord, received. Your client, instead of raising help desk tickets, choose to file application afresh, for which whole application got inactive and could not be processed further. My lord, pausing here for a moment. My lord, if they admit on 1st of February that I have paid towards the application fee, the question of waiting for, my lord, acknowledgement or pending from banks end, my lord, possibly is not correct. Then, my lord, the second paragraph, in the meantime, other applicants who applied successfully, including subsequent application of your client, were processed and subsidy was disbursed. And in the meantime, planned period for disbursement of subsidy expired on so-and-so. So subsequent applications that I have received subsidy, I'm not joining issue. I, my lord, initially, my lord, made this submission. They say plan period expired on 30th September 21 and no further action could have been taken. Since the plan period is over and board has exhausted the amount granted by the central government for payment of subsidy, there is no scope for revival of impugned application and payment of subsidy thereof by processing the said application. This is the only ground they have taken. My lord, my short point which I would like, my lord, the authority to, my lord, decide is, my entitlement on the date of the application, because the rejections appears to be, my lord, on frivolous, my lord, or arbitrary grounds. My lord, based on the teeth of those two, my lord, emails, my lord, application filed, admitted, payment, my lord, received, admitted, they don't do it within the time, my lord, led me, my lord, to issue series of emails, and ultimately, my lord, in December 2022, much after, my lord, the expiry of the plan period, says that I will not be giving you the subsidy because the plan has expired.
But if the subsidy amount is exhausted, I mean, the period is also.
My lord, if I am otherwise entitled to the subsidy, my lord, if there is an entitlement on the date when, my lord, the subsidy plan or the plan was, my lord, there in force, my lord, that entitlement could not have been denied to me. This is a circuitous manner in which, my lord, the authority is trying to deny the subsidy to the, my lord, tea garden owner by, my lord, saying that plan period has or plan period is over.
Right. Yes.
My lord, this is, my lord, the sum and substance of the, my lord, petition. My lord, if lordship is with me, my lord, I would prefer, my lord, going back to the authority, my lord, so that they can, my lord, take a call. Why, my lord, on the date when, my lord, I had made the application, when the plan was in force,
What
I
will
was
they
denied.
decide now? They have already decided.
My lord, then, my lord,
They have said no.
they have. Then my
It is a question of reconsideration.
Very well, my lord, but their reasoning is, my lord, something which is, my lord, on the face of those two emails cannot stand. I would pray, my lord, there is a prayer for disbursement. I leave it to my lord.
Ultimately, you will have to pay. So you answer.
My lord, the problem is the T board has a separate panel of counsel, and it is everything has been issued by them. So they are the answering respondent. Prayer has also been made against respondent number 1 and 2, just for the respondent number 3. So they have to. I really cannot.
Service is proper.
Service is proper, my lord. They have received hand service, my lord. There is the 18th of, my lord, August. They have received.
At order in name. Despite service, none appears for the T board, although the petitioner and the Union of India are represented through counsel. Who's up next? Please take your seats, both of you.
Very good.
Learned counsel for the petitioner argues that despite the petitioner being entitled and eligible to get subsidy under a scheme floated by the Tea Board of India, comma, such subsidy was denied for a particular period to the petitioner, comma, on certain flimsy pretexts. Puts up next para. By placing reliance on the documents annexed to the writ petition, comma, it is contended that the T board, that is respondent number 1, comma, itself acknowledged that the petitioner had applied within time for the subsidy for the relevant period, as well as made the payments required to be so made under the scheme. Full stop. However, comma, ultimately, comma, upon several demands for justice being issued by the petitioner, comma, it was replied by the T board with a communication dated December 28, 2022, that due to certain technical flaws alleged by the T board, comma, the amount could not be disbursed, comma, more so since the period of subsidy had already expired. Full stop, next para. Upon a perusal of the documents, comma, certain documents assume importance for the present adjudication. Full stop. In an email communication dated February 27, 2019, comma, it was intimated by the petitioner to the T board that the petitioner had submitted the orthodox subsidy for July to December 2018, comma, on February 16, 2019, and deposited the fees of rupees 5,000 through net banking. Full stop. The petitioners had not received any acknowledgement slip for the application submitted, comma, for which the email was written. Full stop. In fact, comma, the petitioner also attached to the email the application and the money deposit slip for reference of the respondent number 1. Full stop, next para. In a subsequent communication dated December 31, 2021, comma, it transpires that an official of the T board had acknowledged by email that the T board had checked and found that both the applications of the petitioner were received and submitted from two different IDs within bracket for two separate tea gardens, bracket close, comma, details of which were also shared in the said email. Full stop. Again, comma, on February 1, 2022, comma, in an email communication, comma, the said official of the tea board, comma, namely one Joydeep DEEP Sahu, comma, communicated to the petitioner that the tea board had made a thorough search in the database for the cases of the petitioner's tea estates, and as per the findings, comma, it was seen that for the period July to December 2018, the petitioner had made the payments, comma, which was not reflected in the portal. Full stop. Next para. Ultimately, comma, on December 28, 2022, comma, the tea board communicated to the petitioner by the impugned communication, comma, that although the petitioner had submitted an application for which specifically file number was created, but no acknowledgement was issued, comma, the petitioner within double inverted, instead of raising the single inverted help desk tickets, HDT capital, help desk tickets, single inverted close, choose OOAC, ভুল ইংলিশ হোক, inverted চলছে, choose to file application afresh, double inverted close, for which, comma, allegedly, comma, the whole application got inactive and could not be processed further. Full stop. It is further cited in the said letter that in the meantime, the plan period for disbursement of subsidy expired on September 30, 2021, and no further action could be taken by the tea board, and that the board had exhausted the amount granted by the central government for payment of subsidy. Full stop. Next para. It is seen from the scheme itself, comma, the relevant provisions of which have been cited by learned counsel for the petitioner, that the claims for the first half yearly production within bracket January to June must be submitted to the tea board latest by August 31 of the year under application, and the second half yearly production within bracket July to December, comma, should be submitted in the form of a claim latest by 28/29th February of the following calendar year. Full stop. Next para. In the present case, comma, as admitted in the emails, comma, the petitioner had complied with the said requirement. Full stop. The refusal to grant subsidy to the petitioner for the relevant period between July and December 2018 was on entirely flimsy pretexts. Full stop. Next para. Whether the petitioner chose to raise a within single inverted help desk ticket, single inverted close, or filed a fresh application, comma, would be superfluous in the context of the petitioner having already filed application in time for the subsidy and made the due payment with the tea board. Full stop. Next para. Whatever the petitioner did subsequently could not have obliterated the prior compliance of the petitioner with the provisions of the scheme by filing application and making payment for getting the subsidy for the relevant period in due time. Full stop. The acknowledgement not being issued or the previous application getting inactive, comma, if at all, comma, was entirely within the domain of the tea board and the fault of the said authority, and the petitioner could not be saddled with any liability for non-compliance of the provisions of the scheme for such reason. Full stop. Hence, next para. Insofar as the period of subsidy having expired and the T-board having exhausted the amount granted by the central government is concerned, comma, the same is absolutely the T-board apostrophe's own issue, comma, for which the petitioner cannot be liable in any manner whatsoever. Full stop. Next para. Since the petitioner raised a claim in due time and complied with all formalities in that regard, comma, also within time, comma, as stipulated in the scheme itself, comma, it is the bounden duty of the T-board to disburse the amount of subsidy despite the expiry of the subsidy period subsequently on September 30, 2021. Full stop. The claim was made by the petitioner much prior to the expiry of the plan period, and the eligibility of the petitioner, comma, accordingly, comma, arose much prior to the plan period for the subsidy having expired. Full stop. Hence, comma, the subsidy so due to the petitioner is কথাটা কেটে দিন, বাকি সেন্টেন্সটা কন্টিনিউ করুন, accrued in favor of the petitioner much prior to the expiry of the subsidy period. Full stop. Hence, comma, WPO 1515 of 2023 is allowed, comma, thereby setting aside the refusal vide communication dated December 28, 2022, issued by the respondent number 1 to the petitioner and directing the respondent number 1, T-Board of India, to immediately disburse. It is by way of payment.
Yes, my lord. Prayer C, my lord, kindly cease.
Disburse the amount of subsidy due to the petitioner for the period July to December 2018, comma, to the tune of rupees 31,16,913 oblique dash, comma, positively within 4 weeks from the date of communication of this order to the respondent number 1. Full stop. No address to cause.
Grateful, my lord.
Much obliged.
Item number 5, Rosal India Limited and another versus keyboard.
Well, I am appearing for the Union of India respondent number 3, my lord. My lord, here also, my lord.
What will be the
service-
changes?
My lord, the ground is absolutely different. There is no difficulty with application or payment.
Yes.
My lord, one clause, lordship scheme is same. Only one clause, at page 128, my lord. I'm showing the document, my lord, at page 128. There was a change of, my lord, name. This is T-Board's, my lord, communication of 3rd May 2016. With reference to your application and its enclosures on the above mentioned subject, change of ownership of DCOM TE factory, Noctroy TE factory, so and so. My lord, there were so many factories. My lord, lordship kindly sees last, my lord, 3rd line of the first paragraph, from Messrs. Rossell T Limited to Messrs. Rossell India Limited. So, my lord, the name of the, my lord, T owner was changed from Rossell T to Rossell India. This was, my lord, sanctioned by the T-Board itself in 2016. And this relates to, my lord, one tea garden, my lord, Bokakhat Tea Garden. It should be noted that this registration does not constitute recognition of legal ownership or establish your title to the property. I am not claiming so. Under clause 7.1, my lord, by this document, they admit that there was a change of ownership. Now, my lord, kindly sees the provision in the scheme, my lord, at page 63, my lord, clause 3. Page number ভুল লিখেছি একটু ধরো তো 63
Yes.
63 page number ভুল বললাম বলো তো 68 I think, my lord, I gave your lordship a wrong page number, my lord. It should be, my lord, 68, my lord. 68, my lord. I'm sorry.
Yes.
My lord, clause 3, lordship in the first matter also took note of this clause. Inspection is required to be done by them. At the foot of the page, my lord. Inspect just above the, my lord, bold sentence. Inspection at the factory site for big and small growers by T-Board official is essential before sanction of claim. My lord, the rejection order is on the basis that the owner's change of ownership was not done. But my lord, I would show from after they, my lord, inspected the factory, they issued, my lord, document in the name of the, my lord, changed, my lord, owner, and that lordship will find at page application to Padarachi. My lord, 145. 130. My lord, first 130 is my application in the name of, my lord, Russell India Limited. 130, my lord, at the top right hand corner, lordship will find the name, company name, Russell India Limited. Lordship has found that. Yes. Now, my lord, kindly comes to page 139. This is, my lord, another application, my lord, because there were 4 periods involved. So, my lord, this is another at 139. Lordship will again find in name of Russell India Limited.
These are your applications?
My applications.
130 to 139.
So, my lord, there are 4 applications for
You
the
said
entire
that
period, 130 to 130.
After inspection, they gave a.
Yes, that later I would show, my lord.
Yes.
Now,
So these are your applications. I mean, why are you showing the application?
because, my lord, I need to first apply for the subsidy. Then, my lord, they
You
come and inspect.
applied in the new name.
I applied, my lord. I want to show that they acknowledge the fact that there was a change of name. 132 is the document which I would like to draw my lord's attention to. This is the, my lord, part of the inspection, my lord, report of T-board. And then, my lord, the letter which I was talking about.
So this says this gives the previous name.
Yes, now I will come to that, my lord, letter issued by T-board, my lord, which gives the, my lord, the changed name. No, no, ওর নামে দিল।
But even after that, they have given in the
that document at 128, lordship sees, my lord, its name in the name of Russell India Limited. They have approved.
That is there.
Yes. So it's their letter, my lord. We had applied.
But subsequently, they have written to the old name, in the old name.
That exactly, my lord, why I wanted to draw my lord's attention to this document. The change of ownership was recognized by issuing this letter to the, my lord, owner. At page 128, it is, my lord, referred to, my lord, Russell India Limited, not Russell T. Previously, it was known as Russell T. I applied, my lord, change of ownership was granted, and, my lord, by this communication, it was sanctioned. Thereafter, my lord, rejection order, they only reject because I did not, my lord, do the change of
Page
ownership.
132, you should not have shown to me.
No, my lord, 132, I showed only to, my lord, show that the subsidy application was, my lord, acted upon, they inspected. They may have, my lord, referred to the previous name. I only wanted to draw my lord's attention to this because they had acted in terms of the application, inspected the tea garden.
Shall not mark 132.
Then, my lord, 150 kindly comes. I'm sorry, my lord, I missed it, my lord.
132 should not be.
Very well, my lord.
If I look into 132, I'll have to discuss that.
Very well.
Yes. 150, yes.
150, my lord, paragraph 2, my lord. Keeping the above premise in view, I am directed to inform you that your client applied for subsidy for the period July to December 18, July 19 to December 19, January to June 20. So, my lord, 4 periods. Under tea development and promotion scheme for orthodox tea subsidy for Bokakhat Tea Estate, it may be noted that same applications were submitted through online mode in the name of Russell India Limited. However, from verification of our records, it is seen that as on the date of application, garden stands in the name of Russell Tea Limited and not in the name. They themselves, my lord, by their letter, address, my lord, this letter to Russell India Limited, but rejects it only on the ground that the garden stands in the name of Russell India Limited. I also showed, my lord, the applications from page 130 to 139. My application was made in the name of Russell India Limited.
That is your application.
My application.
Unilateral.
Yes. No, they did not, my lord, then reject my application saying that no, there has been a change of name, or they could have said, my lord, that it's recorded in the old name, Russell Tea Limited, how you are applying. Further, for July to December 20, application was made in the name of Russell India, but name of account holder was mentioned Russell T. This was brought to the notice of your client several times. Finally, it has come to the notice of board that Bokakhat was sold to Dhanseri Tea Private Limited. Above facts, which are self-explanatory, clearly establish why and wherefore subsidy could not be processed and paid. Now, my lord, the sale of the tea garden to Dhanseri is not the subject matter of the, my lord, period for which I am claiming subsidy. During the period for which the subsidy is being claimed, my lord, Russell India Limited was the, my lord, tea garden owner. The application says so. The 2016 document of tea board says so. My lord, the rejection is only on the ground that the garden still stands in the name of Russell Tea Limited in their records. And my lord, the same ground, paragraph 5, the same ground is taken, the other ground.
From the verification of our records, they say that it is in.
So we really don't know what records they are talking about, because if their records indicated, my lord, Russell Tea, then, my lord, the document at 128 would not have been addressed to Russell India Limited. It would have been addressed to Russell Tea only. Suddenly, my lord, this is because, my lord, of para 5. Lordship now takes note of page 151, para 5. Some reason was to be given to reject my application again, my lord, belatedly, when the plan is over. And this is in 2023.
Achha, what about this? I am arguing in their favor, Mr. Dattu.
Yes, my lord.
128, page 128, the second paragraph. It should be 128.
Yes, my lord.
It should be noted that this registration does not constitute recognition of legal ownership or establish your title to the property in the legal sense.
Well,
What
this
does
is in the
mean?
form of a caveat that this is not a title document, should not be construed to mean a title document as to transfer of ownership. My lord, it was a change of name. From Russell Tea, it was, my lord, Russell India. My lord, visualizes a situation in 2023. They say their record says it is still in the name of Russell Tea. Why would they issue this document in 2016 addressed to Russell India Limited? So, my lord, the ground really is, my lord, the plan period is over. There is no fund. I have to reject it. One ground additionally is being taken, my lord. And, my lord, page 22, lordship, is just to, my lord, for your lordship satisfaction, my lord, page 22, my lord. The fresh certificate, my lord, I have annexed, my lord. My lord, lordship looks at the middle of the page, my lord, in English, my lord. Fresh certificate of incorporation consequent upon change of name. My lord, I hereby certify, I'll read it for your lordship. I hereby certify.
Yeah, very please.
From Russell Tea, it went to Russell India. And this is how, my lord, they also recognized. And it's a document of 2011. So in 2016, they recognized that and issue this letter.
You are for Union of India. You have to say anything?
My lord.
Achha, act order.
And they were served, my lord, again hand service, my lord.
Despite service, none appears for the Tea Board of India, although the petitioners and the Union of India are represented through council. First of next para. The grievance of the writ petitioners is that despite the writ petitioners being entitled to subsidy under a scheme floated by the Tea Board of India, the same was denied to the petitioner for certain periods, being from July to December, 2018, July 19 to December 19, January to June 2020. Pushed up. Next para. The primary ground of refusal was the change of name of the petitioner number 1 from Russell, ROSSELL, T Limited to TO2, Russell India Limited, and that the period of the subsidy was already over. First up, next para. Learned counsel, by placing reliance on the documents annexed to the writ petition, seeks to satisfy the court that fresh certificate of incorporation consequent upon change of name was duly issued to the petitioner number 1 company by the registrar of companies, West Bengal. First up, more importantly, the respondent number 1 itself had approved of the change of name in its records. First up, as such, the ground on which the subsidy is now being refused is frivolous. First up, next para. A perusal of annexure P-I, P1 at page 22 of the writ petition clearly shows that a fresh certificate of incorporation was issued by the registrar of companies in favor of the petitioner, consequent upon the change of name of the petitioner number 1 from Russell T Limited to Russell India Limited. Full stop.
My lord, with 128, lordship will also take note of
No,
129.
I'll take into note.
With 128, also 129. I missed it, my lord. It is their document, Form B, at the left-hand bottom. They have, my lord, amended the name. I missed, my lord, this.
Very well. It is also কি বললাম it is Russell কিন্তু Russell না Russell ROSSELL. So next para. In the communication dated May 3, 2016 of the T-Board of India to the petitioner number 1 in its changed name, comma, the T-Board, comma, in unambiguous terms, comma, approved the change of name of the petitioner number 1. Full stop. The only rider given was that the registration does not constitute recognition of legal ownership or establish the title of the petitioner to the property in the legal sense. Full stop. Next para. Such rider does not carry any significance in the present context, comma, since it is nobody apostrophe S case that the approval by the competent authority, comma, communicated by the T-Board, comma, constituted any transfer or recognition of legal ownership. Full stop. Next para. However, comma, the same undoubtedly proves the approval given by the T-Board in the context of such change of name as far back as on May 3, 2016. Full stop. Again, comma, in a communication dated July 21, 1984, comma, a certificate of registration was issued by the executive director, comma, T-Board, comma, Guwahati.
It's in the same certificate. They endorse this view. That is why, my lord.
Guwahati. Regarding the tea estate in question as a unit of the Russell India Limited, within bracket, the changed name of the petitioner number 1, bracket closed. Full stop. The address of the manufacturing unit, comma, mentioned in the left-hand bottom corner of the said certificate of registration clearly mentions the address as Messrs. Bokakhat, BOKAKHAT, Tea Estate, comma, Golaghat, comma, Assam, comma, India, comma, which is the undisputed address of the petitioner number 1. Full stop. Next para. In view of the above, comma, the premise on which the refusal took place, comma, relating to the subsidy being given to the petitioner, comma, to the effect that from verification of the records of their records, comma, the T-Board could not see, the T-Board saw, SAW saw that on the date of the application, the garden stood in the name of Russell T Limited and not in the changed name, comma, is patently unacceptable and beyond the provisions of the scheme. Full stop. Next para. Such ignorance, comma, feigned, FEIGNED, feigned by the respondent number 1 is contrary to the records of the respondent number 1 itself, comma, since it gave approval much back, comma, to the change of name of the petitioner number 1. Full stop. Insofar as the other ground of refusal being that the scheme had come to an end on March 31, 2021, comma, is also insignificant in the context, comma, since the petitioner's claim is relating to a period much prior to the expiry of such period. Full stop. Since the petitioner's claim of subsidy was made in time and the respondent number 1 had previously acknowledged and approved the change of name of the petitioner to Rossell India Limited, comma, the grounds cited by the petitioner, by the respondent number 1 in their refusal to grant subsidy for the relevant period cannot but be set aside, full stop. Accordingly, WPO 1516 of 2023 is allowed, comma, thereby setting aside the impugned refusal with a communication dated March 22, 2023 made by the T-Board to the petitioner and directing the respondent number 1 to disburse the amount of rupees 34,82,274 in favor of the petitioner number 1 towards its claim for subsidy for orthodox tea for the period July to December 2018, July to December 2019, January to June 2020, and July to December 2020.
At
Terms of the scheme in question. Full stop. No rest to cause.
My lord, the time period lordship had in.
Such disbursal shall be made by the respondent number 1 at the earliest, positively within 4 weeks. I gave in positively within 4 weeks from the date of communication of this order to the respondent number 1.
My lord, at one, my lord, portion of the order, my lord, when your lordship was dictating, the period was, my lord, lordship has said up to June 2020.
One
The
was
last
missed out.
one was missed out. July to
But
December.
that was
20.
not referred in the
My lord, it is. My
in
lord.
their communication. It is there. In the refusal communication, it is not there. I was
So
reading
in
from
the, yes, lordship referred to the refusal communication. It was not there. But we have not been, my lord, paid that also. So my period is, in fact, this is my 144 lordship sees my claim. My
that
lord.
was probably I was referring to that communication. I was referring to that communication word.
Very well.
Anyway, I'll check it.
Very. I'm grateful, my lord.
Thank you. নিতে আসেনি?
Great.